Well, this matter, at one stage, your lordship had taken up and passed the order. In fact, it is covered by your lordship's order. This matter was appearing before the earlier bench for determination. Now the determination is changed. May I pray before lordship, my lord, for
What is the
inclusion?
urgency?
Well, it is the urgency matter is pending for the last 20 years.
What is the stage? Hearing?
Is the hearing. Small matter, absolutely very small matter. Only one judgment of Supreme Court all to be
The
considered.
other side.
I have given notice, my lord. Let's go.
Lordships, kindly, my lord, I was mentioning a very urgent new motion. My lord, I have filed this matter, but it was scheduled to appear on 4th of November. My lord, this petitioner is a senior citizen. Now, my lord, he is of a lawfully owned flat. What the daughter-in-law has done is, my lord, he has driven out the senior citizen from the house. My lord, this person, my lord, is roaming.
Who has driven out?
My lord, the daughter-in-law. And the daughter-in-law, my lord, is capturing the entire flat. He
Okay.
has approached, my lord, the maintenance tribunal meant for senior citizens. It is cited. But put this petition.
So what has done? Why you not approach the tribunal?
Well, I have approached the tribunal. Tribunal is doing nothing.
It is pending before the tribunal. So what you want before this court?
Alternatively, my lord, two things. First is, my lord, kindly directs the tribunal, my lord, to dispose of the matter at the earliest. Or alternatively, my lord, restores it, my lord, to his own flat. I have the deed of the flat.
Since when it is pending before the tribunal?
It is pending before the tribunal since 14th of October. This has happened, my lord, in the interregnum of the vacations. We have filed it before the tribunal. Thereafter, we have filed the petition.
So when the next date is fixed before the tribunal?
The tribunal has not fixed any date. But it is the procedure in which we have to submit an application. Now the tribunal will issue notice.
Correct.
The tribunal is not issuing notice.
May I have kindly to mention one new motion for inclusion. This was running in the list. Then for some reason this is no more there in the list. Where the urgency is this is from an order passed by the appellate authority under the West Bengal Highways Act. The appellate authorities order, we have challenged the writ petition. Nothing was happening. Now, on 4th of this month, the police authorities have come and said that they would come on tomorrow and to demolish the structure. So, the urgency cropped up. We did not trouble your lordship by mentioning, but now the this has happened, which is why we are mentioning. May this matter appear tomorrow and serve notice.
Serve the notice to them.
May I be
My lord, may I be permitted to mention one?
Who is senior? Please maintain seniority while mentioning.
My lord,
may I be permitted to
What is the urgency? So it will come. Correct. You have paid for the receipt of receive of money. So where is the urgency? It is not in the list. Okay.
My lord, may I have your
Opposite party has already mentioned the matter. Here, petition of police certificate was cancelled in absence of our presence here.
What is cancelled? OBC certificate is cancelled. Yes.
This time opposite party again mentioned the matter. So kindly will not allow him before 11 so that matter can happen.
Before 11th, how it can be? Today we are on 6. 8 to be mentioned.
may I have your lordship leave to
Yes,
mention one matter, my lord?
Just a minute.
My lord, this is a new motion. The urgency is this. The urgency is this, my lord. We have, my lord, already, my lord, preferred an appeal pursuant to an order passed by this court. Our grievance has already been, my lord, considered and that has been rejected. The urgency is this, my lord. Despite there being a specific clause in our favor in the tender notice, they have interpreted by importing certain other circulars which has not been given effect to, and therefore there is an extreme urgency on the basis of which, my lord, everything has been denied.
But the work order is issued.
No. Work order is issued. Work has already been done.
Then?
Thereafter, the substantial amount has been paid. But so far is the, my lord, GST and other component is there. Although, my lord, I had deposited the same by dint of the circular, I am entitled to. But they had withheld the huge amount of money so that the money would not be in circulation. There would be a difficulty, and, my lord, I am not getting the entire fund.
So what is the urgency? Let it come on the my
Lord, this is a new motion, my lord. I have given the date. In the date that has not been listed, that's why I am coming, my lord.
What is the returnable date in your presentation form?
My lord, that has already been, right now that has not been mentioned, but that has already expired, my lord.
इसको कम करो,
Three-
Monday करो.
My lord, may I be
Three analogous matters are
my
there.
lord, may I be permitted?
Monday, huh?
My lord, may I be permitted to grant leave to move this matter because my lord, on 30th of within 30th of November, I have to go abroad in USA and get admitted in my higher studies, my lord. What has happened to me, my lord? A criminal case is pending against me, and your lordship knows as per the rules, I have to approach the learned court below. If the learned court grants no objection, then I will approach the Passport Authority of India. The reason why, my lord, I have before your lordship, identical orders have been passed by this honorable court that these applications and this approach may be made in a time bound manner. That application, my lord.
Why you are not filing? Have you filed an application before the trial court?
My lord, if I file an application before the trial court, your lordship, it will take a time. I will take a liberty. If it should be, I will take liberty from your lordship. Same order, my lord, what I want as it was granted, my lord. Liberty to approach the trial court. If the trial court grants a no objection, the passport authority will consider accordingly within a time bound manner. This much as you want, my lord, identical orders are there. My lord, kindly see, I'm just showing the relevant page. My lord, these are the identical orders. Just a time bound manner. In view of the above, liberty is granted to the petitioner.
There is already liberty to you to be.
No. This is identical another order, not in this case.
Correct.
But my lord, if I approach the trial court, my lord, kindly visualize, my lord, it will take time. So I have very short time. This court only.
Which trial court?
My lord, it is in Krishnanagar, Nodia. But it will take a long time. Just a time bound manner, my lord. This much, my lord. Leave, my lord, one Monday, my lord.
Monday.
My lord, may I mention, my lord, matter, my lord, for
Have you filed this new file?
I want to grant a leave.
Grant leave.
Lordship.
Grant leave to file with the liberty to
On Monday.
and be listed on Monday.
my lord, may I
Lordship,
mention one
Lordship,
matter,
may
my
I
lord?
be permitted to mention, Lordship,
This
three
matter
matters, 3 are electricity matters, Lordship, not running in the list, Lordship. 3 matters, electricity connection has already been disconnected, Lordship. 1 matter, Lordship, it was supposed to come in the list on 3rd of November due to change of determination. The matter did not appear, Lordship. I am praying the matter listed. And 2 matters, Lordship, made returnable by Honorable
This
Justice.
under the under the heading new motion.
My lord,
My lord, myself,
Lordship, 2 matters, Justice Kaushik Chandra directed
Hello,
to
may-
appear 2 weeks after the vacation. 2 weeks.
Give, it will be listed.
my lord, this is also new
Have
motion.
you checked the list?
It will come to.
No, have you checked the list? No.
No, it is not.
My lord, this is also new motion.
permitted
New
to
motion
mention
में
one-
आएगा. New motion में आएगा.
My new motion,
My lord, new motion.
mine is also new motion, my lord.
New motion, all are new motion.
Give. When you file the restoration application,
Under compelling circumstances, Lordship, if
My lord.
permitted to mention,
Are new-
Lordship,
give the what is the mentioning? Give the list to my court officer. We'll see.
son of the petitioner is in the
If the court will find the reason is there, then it will be listed.
My lord has taken all the new motion matters, my lord. I also have a new motion, but with grave urgency, my lord.
What is the
Only,
urgency?
only, my lord, on the last month I have filed, my lord. I am a successful applicant before the West Bengal real estate authorities, and I am enjoying order. I'm a bunch of home buyers, my lord. Now, my lord, on the inaction, I preferred an execution proceeding, which was also passed in my favor, and the RERA directed the concerned DM and SDO to initiate recovery proceedings of that money ordered in my favor. Those recovery proceedings has been initiated. Orders were passed, but till date the SDO is intentionally keeping those recovery proceedings pending. My lord, I am not getting my money. I am not getting my home, anything, my lord. And I'm a bunch of home buyers. All are successful before the RERA in the main case and in the execution case also, my lord.
How many petitions are there in your application?
In my application, my lord, there are four petitioners, my lord, and
There is already an order.
my lord, there are 2 coordinate bench judgments of this honorable court in favor of 2 other petitioners who are similarly footed with my case, my lord, and in the very same proceeding against the very same home real estate authority, my lord. I am relying on those judgments only, my lord.
Friday.
My lord, kindly fixes, my lord, any date, my lord, at the top of the list.
Lordship, under
This matter, your lordship, allow is mentioning on Monday.
The matter will be appeared today. So for the urgency is concerned, for the highest act 1962,
আগামীকাল
the building construction will be demolished by Malad Party. So your lordship Malad has been fixed upon today, but matter did not appear in the list. And this mentioning has been after with notice to the others.
Have you mentioned issued the notice?
Lordship, under compelling circumstances,
Urgent motion.
Lordship, under compelling circumstances, Lordship, may I be? Lordship, the son of the petitioner is in the custody of CWC. They have now declared the son of the petitioner legally free for adoption. That is despite a direction of a coordinate bench of our honorable court saying that you consider my representation for his custody. I am the biological mother. They have not considered my representation. They have not responded.
Why the child has been taken to the CWC?
Lordship, the child was initially found injured. The father was found injured. The father took the child to the hospital. From the hospital authorities handed it over to the CWC. I had approached this court earlier on an earlier occasion.
Is there any proceedings pending against the husband and wife?
They had initiated an FIR that resulted in an FRT.
No, that is not with regard to the matrimonial domestic violence.
They were there, no, Lordship. They were not married. The child was out of a non-married couple, Lordship.
Non-married.
And unless your Lordship gives an urgent intervention, the child has been declared legally free for adoption. Today, if prospective parents are selected and the custody is gone, Lordship, there would be no going back. I was just praying for an urgent hearing.
So now where the child will
It is with the CWC, Lordship. My prayer is the CWC, as per the coordinate bench's direction, should consider I am the biological mother. My prayer for
considered.
not considered, not even responded to it, Lordship. It's from a different authority that
order it not considered. Why the new writ petition? There is another way.
Lordship, there was subsequently they had filed an FIR. There was a different writ petition. They waited for the DNA results. The DNA results matched. My only prayer is that, Lordship, the adoption proceedings need to be stayed and let them consider my application. Thereafter, they can proceed, Lordship.
Tuesday, urgent motion.
Mention one matter, Miller.
One matter. I am saying leave before your lordship. Malad, already Malad, a construction has been going on by the respondent number 12 to 15. Malad, in spite of specific order passed by the district magistrate under section 17(1) of the Inland Fisheries Act. And Malad, penal action already Malad taken by the PLLRO. In spite of that, Malad, local political party, they are constructing party office, Malad, by filling up the pukur. Specific direction has been given the district magistrate, stop construction, as well as Malad penal provision has also imposed. Malad, kindly any date as you
now what the court will do now?
Malad, Inland Fisheries Act 17(1) notice has already been issued. And Malad, penal action already taken. Malad, let the Malad construction may be stopped by your lordship. And
approach the district magistrate.
Malad, district magistrate already on the basis of that district magistrate already passed the order. They did not Malad delay. Malad, kindly any date. Malad, that going by 200 Malad years, more than 200 years that was used by pisciculture.
Malad, may I be permitted to mention, Milord, one matter?
To the petitioner, file and be listed on Tuesday.
Malad, may I be permitted to mention one matter, Milord?
Yes.
Where the Lord coordinate bench ask specific order that nobody should take any steps despite that, we find that either KMC or some other authority trying to change the nature and character of the water body. What will this bring? We have filed an intervention application. We have sought for some relief, not granted because we have followed the division. The division has said, come back to the trial court and pray for service upon the case. But I am mentioning this word.
Have you served? Have you served?
No, I am not saying that.
Tuesday, urgent motion.
Malad, may I be permitted to mention one matter, Milord? This is also a new motion, but the motion is appearing in the list of Mr. S.S. Milord Amrita Sinha. The contention of my writ application is this.
What is the urgency?
Urgency is this, Milord. Work order has been issued in favor of my client. Milord, completed the work within the stipulated period of time. But Milord, in spite of repeated Milord requests, they are not Milord disbursing the Milord amount. Milord, which is due to the petitioner. Milord, let it be appear.
And file a suit. Why the record? The writ court can.
Other coordinate bench, Milord, already interfered, passed an order, and Milord, along with the interest. Let it be appear under the heading of.
I am allowing if this court will find there is a dispute between you and the parties regarding amount, then you will be a heavy cost. Money suit cannot be in the rate. If you find the other side is disputing with regard to your claim, then you will be in difficulty.
I am ready to pay. Let it be appear, Milord.
Your lordship, may I be permitted to mention? Your lordship.
For withdrawal. इसको एक काम करो.
No.
कल रखो. फिर for withdrawal.
My lord,
इसको रखा
Your-
for withdrawal.
my lord,
Your lordship,
permitted to mention this matter. My lord, my passport has been impounded and till date it has not been released. My lord, I mentioned this matter on Sunday. Why did your lordship directed me to mention this today, my lord? My lord, as per his lordship, one of the last order, my lord, there was a direction for exchange of affidavits, and my lord, the matter was made returnable on 4th of November, my lord. But the matter was not listed on that day. And my lord, there is-
Affidavit filed.
no, my lord, they have not exchanged any served us any affidavit, my lord. So we could not file any exception, my lord. But kindly fix it anyway, my lord. And there is no
Okay.
interim order.
Tuesday.
your lordship, may I be permitted to mention one, three analogous matters?
Circumstances, I'm appearing in this SLST 2025, my lord, but I applied for EWS certificate, my lord. I have mentioned this matter on Thursday, my lord. It was supposed to be listed on
EWS certificate.
EWS certificate.
what?
For my lord, I have applied for SLST, my lord. I was under EWS
When is
quota.
the last date of the
My lord, 10th will be the date of verification, my lord. My lord, this matter was supposed to be listed on 6th of November, my lord.
Ah.
My lord, this one matter was not listed today, my lord. My lord, kindly, my lord, 10th is the last day, my lord, otherwise my matter will be infructuous.
10th is the last date?
Yes, yes, my lord. Last date for document verification, my lord.
Rako urgent motion.
Your lordship, may I be permitted to mention three analogous matters, your lordship, regarding electricity? If it is for hearing, your lordship, the affidavits has been exchanged. I have served on to the other parties also, your lordship. I am mentioning it for under the heading of hearing.
Electricity matter कब है हम लोग का? Tuesday. Monday उसको रखो.
Lordship, may I be-
Monday adjourn motion में.
Lordship, may I be-
Deeply obliged, your lordship.
Is there any dispute with regard to the payment? If there is a dispute, then you have to go to the suit. May be admitted, but this court will not admit if there is a dispute with regard to the payment. Wednesday for hearing.
My lord, may I be permitted, my lord, to mention, my lord, the application. It was running in the list
What
after,
application?
my lord, restoration application, my lord.
Restoration एक पहले दिया था कब बोला था?
Similar
My lord,
practices.
my lord, may I
रेस्टोरेशन एक बोला था ना, पहले एक डेट दिया था ना रेस्टोरेशन का, वो सबको
my
रेस्टोरेशन
lord, application for substitution.
ऑल
My lord, application for substitution of respondent number 4.
all restoration application takes on fixed on Tuesday under the heading application.
I'm deeply obliged to you.
My lord, application for
What is the urgency? 2018. हाँ. Tuesday new motion में रखो.
my lord, application for substitution of respondent.
Your lordship, may I have your kind leave to mention this matter for inclusion.
Okay, all will come.
All affidavits have been exchanged and it's ready.
My lord, application for
Exhibit
substitution.
adjourn motion में रखो.
Lordship, may I
My
be
lord,
permitted to mention one matter, lordship?
Non
My lord, application for substitution.
इसको application Tuesday.
Lordship, may I be permitted to mention one matter for inclusion in the list?
For what?
Lordship, in this matter, Lordship, I entered into a lease agreement with the Indian Oil Corporation for commissioning of a retail outlet. However, till date, Lordship, neither they have commissioned any kind of outlet, neither they have released my land, neither they are giving any kind of premium. Lordship, I'm praying only for inclusion. Let it be included in the list.
My lord, may I please be
Notice
permitted
of-
to mention a matter, my lord? My lord, application for substitution of respondent number 4. Great.
With your lordship permission, I would like to pray for inclusion in the daily list.
Tuesday application.
Substitution of-
Tuesday application.
I would like to pray for inclusion in the daily list. It's a long running matter, madam, under the heading motion.
तो न्यू मोशन में लेके आ जाओ Tuesday. उसको लो. Wednesday adjourn motion. Adjourn motion.
My lord,
Matter that is the restoration inclusion for the list So dismiss for default order is 22 and that is
What you want?
inclusion for restoration.
Restoration application on Tuesday.
My lord, may I have your lordship's kind leave, my lord. But pursuant to a memo, my lord, a person working as immunization volunteer ought to have been getting rupees 550 a day. But these are persons who are getting 90 rupees a day. I'm seeking your lordship's kind leave to intervene in
Why
this matter.
before this court?
But
Which
this-
department?
No, it's the residuary. Earlier, the matter was heard before a residuary bench. Order was assailed before the division bench. Refused to entertain. Went before the Supreme Court. Again, this thing is happening, my lord. This person is similarly.
File it. You're not filed. What is
But
that?
this is a similarly circumstanced person, my lord.
Okay, you file it and come mention I will take. First you go and file.
My lord, I'm deeply.
Our construction has been made.
Each one of us, I think, is-
So we don't have complaints with blame also. But action is taken against the
Okay, come on Tuesday. Yes. Call that.
Lord, mentioning not for inclusion, Lord, the matter fixed at 12 o'clock in accordance with the last Lord order South Point, Lord, original side. But not obviously it can't be taken up at 12 o'clock. It's come in the list at 3:30 and as item 5, Lord, unlikely to be taken up. Lord, would your lordship keep another date? I've given notice to my learned friend.
No,
Lord,
come at 3:30 and let any junior come. I will fix another.
I'm okay.
Very grateful, my lord. এই দুটো ফিরে গেল?
Lord, may it please your lordship's lord. Lord, this is concerning, Lord, a tender, Lord, for dredging in Muriganga River. এই তো দাদা আমরা পিটিশনার দাদা আমি তো এদিকেই ছিলাম পড়া
Have you served the notice?
Yes, Lord, everyone is appearing, Lord. The learned advocate general has come for the state. Lord, I just give your lordship a brief background, then I'll take your lordship to the pages. Lord, this is a tender, Lord, for dredging in Muriganga River. Lord, Muriganga River is Lord, perhaps one of the pathways to reach Ganga Sagar. Every year, during this time, the government floats a tender for dredging Muriganga River for easy, Lord, plying of the vessels reaching to Ganga Sagar Mela. This year, the tender was floated. In the first call, there was less than 3 technically qualified bidder participant. They cancelled the tender on 3rd of October. Lord, without waiting for the reasonable period, I have annexed government memos which says for a tender above 1 crore 50 lakhs, you have to give 21 days notice. Without that, এখন মামলা চলছে, please, কি করছেন? Without waiting for that, Lord, they floated the second call. In the second call, they did not adhere to that time. Lord, the petitioner, he challenged one of the conditions of the tender. What was the condition? That the dredgers, those cannot be more than 15 years of age. Lord, that conditions was challenged by this petitioner during vacation before Justice Om Narayan Rai. Justice Rai appreciated the point, passed an interim order holding that the state is arbitrarily proceeding, including that particular clause. Only Mr. Saha's client was not qualifying. So it was a tailor-made contract. That particular clause was stayed. I was allowed to participate. 10th of December was the last date for 10th of October was the last date for putting in the bid. Lord, on 9th of October, Justice Rai Milord allowed us to participate. We participated. We put in our bid on 10th. The tender was opened on 11th, the technical bid. Lord, technical bid was opened. On 13th October, they found that although I qualified technically in view of that High Court's order, and Mr. Saha's client, who was originally qualifying, Lord, he is the only one who is qualifying. Since it is less than 3, they cancelled this second call also. So first call you cancelled, you go for a second call. Second call you cancelled, you should go for a third call. Then the game started. When they lost in court, they decided to take it upon themselves. Lord. The cancelled tender was revived overnight. Financial bid was opened. Technical bid again opened. Initially on 13th, I'll take your lordships, they opened the technical bid. They said there are only 2 technically qualified tenderers, so we are cancelling. So the technical bid opening was done, finding was there, cancellation was there. Overnight, they revived it. They reopened the technical bid. On 14th in the evening, they found 2 of us are qualifying. They started proceeding with the tender. On 16th, they opened the financial bid. Lord, I have annexed one memo of the government, which is a notification under the West Bengal Finance Rules statutory force, which says that if there are less than 2 technically qualified bidder in a tender more than 1 crore, you cannot proceed with the tender without the approval of the finance department. 16th evening, they opened the financial bid. 17th evening, they uploaded the financial summary. 18th to 28th was holiday. 18th, on the day of Dhanteras, when all departments are closed, Mr. Dotto's client opened the office 6 a.m. in the morning. I'm talking from their record. 6 a.m. in the morning, offices are opened. Lord, LOA was issued in Mr. Saha's client's favor. A tender which is cancelled on 13th, reopened on 14th, 16th re-evaluation done, 17th Lord publication made, 18th on a holiday in 6 a.m. in the morning, the tender is given to Mr. Saha's client. 18 to 20 was not a holiday. 29th I got to know. 31st I approached your Lordship's court. Lord Justice Sinha fixed the matter on Lord 4th. It appeared. I mentioned your Lordship kept it today, Lord, for your Lordship kind consideration. Lord, the primary point I am agitating before your Lordship is, Lord, arbitrariness, hot haste. This undue haste is malafide. And I will show a Supreme Court judgment which says that a cancelled tender cannot be reopened. Very recent judgment. My 2 points are there. One is you did not adhere to the time limit of 21 days. Number 1. Number 2, you did not, after you cancel the tender, you could not have reopened it. Number 3, even if you have reopened it without finance approval, you could not have given the work to Mr. Saha's client. Now, let me show you Lordships one by one. Not kindly straightway come to the tender clauses. And not only one thing, though it is not germane for this writ petition, it was germane for the earlier round. The clause that they wanted to, Lord, insert, clause 34 of the additional terms and conditions, that were never there in the earlier tenders, where I was the successful bidder. My case from the day one is just to suit him, just to select him, they have inserted that clause. And now that sanctifies with the subsequent actions. But kindly take the writ petition. Lord, kindly take the present NIT. Kindly first come to Lord page 75. Lord, there are 2 volumes, Lord. First volume, last page 75. I will not travel with the first volume anymore. Only this page, not all papers are in the second volume.
Yes.
Kindly see, this is the cancellation of the first call. Kindly mark this, Lord. Number of qualified bidders found is less than 3, which is less than the minimum allowed tender under rules for first call tender. Hence, the tender is hereby cancelled.
Yes.
So, when there is less than 3, you cancelled it in the first call. Let's take the second volume now. Lord, kindly come to the tender at page 76, first document. Look, 76. Look, diye de na koro. Diye de.
Yes.
Lord, I have only prepared a supplementary affidavit annexing that. I am prefaring it. I have served copies, Lord. But kindly come to 76. The tender starts in the second call. Second call, kindly see.
Page 71 and 75 is the
First call cancellation because less than 3. Now take the second volume. Page 76.
Yes.
Kindly see at the top.
Yes.
Second call. Malaras Kali got that?
Yes, yes.
After the bold, short notice inviting tender. Lord, kindly take the next page. The timeline, everything is given. Kindly have a look at it. Lord, on the left-hand side, serial number 2, your Lordship will find, Lord, the nature of work. Dredging before Moody. Malaras Kali got that? Page 77, Lord, next page. Lord, serial number 2, nature of work, name of work. On extreme left, there are boxes on the extreme left. Serial number 2.
Name of work.
Yes. Dredging before Gangasagar Mela 2026 in Murigonga River in connection with dredging in river Murigonga in PS Kagdip and Sagor, district South 24 Parganas. Second call to the first tender being number so and so. So the work is from one police station to another police station, the entire area has to be dredged out. Lord, kindly take note the column number 4. The value of the tender is 31 crore 98 lakhs. Malaras kindly got that. Lord, kindly see column number 6. Period of completion 75 days.
Yes.
Then Lord, kindly take Lord this technical pre-qualification criteria, which is not very essential now because I was technically qualified also. Lord, kindly take column number 9.
Yes.
See, Lord, the period of completion is given there. Serial number 1 under column number 9. Physical progress of the whole work in package. In percentage. Lord, what is this percentage? Total 75 days. So 15% of time, I have to complete 20% of work.
Correct.
Then within 40% of 75 days, I have to complete 50%. 75% of 75 days, I have to complete 75%, 100%, 100%. That way it is divided. So suppose even if someone does it for 5 days, then it could be expedited and get it done. But kindly come to the offending clause that I challenged in the earlier writ petition. Kindly just take note page 109.
Yes.
109. Kindly have a look at that is the additional terms and conditions. Maladas kindly got that. Not kindly come to, it starts at 109. Kindly come to the particular clause, page 113.
Yes.
See clause number 34, which I challenged in the earlier writ petition. The offered CDS, dredgers, CDS mana?
Cutting
dredger suction machine should be less than 15 years age as on the date of the submission of bid. So they put in this clause so that nobody holding a dredger having more than 15 years of age.
No, the offered of CDS. What is CDS?
Lord,
CSD.
CSD, cutting suction dredger. The machines, Lord, the machines by which the dredging would be done, they said that cannot be more than 15 years of age. That was the condition put in to suit a particular bidder who only had this at that point of time. But I challenge this. Kindly come to Justice Rai's order. Kindly, Lord, come. Lord, I am very sorry. I just forgot to show you, Lord, is only one page. But I'm very sorry. Kindly take page 95 once. Kindly, Lord, pardon me. Page 95 once. এটা তো মহা বিপদে পড়েছে রাতটা এদিকে পুরো
Yes.
But I'm so sorry, my lord. This is the timeline in the second call. Kindly have a look at it. E-tender published on 5th October 2025 in the newspaper, 4th October at 6:50 p.m. Then document downloaded start 4th October 6:50. Pre-bid meeting 7th October 2:30. Bid submission start date 7th October 5 p.m. Document download end date 10th October 5 p.m. Bid submission end date 10th October 5 p.m. Technical bid opening 11th October. So they basically gave 5 days time. Now, my lord, apropos to this, kindly take page 130. This is another ground of my challenge of the entire tender process. Take page 130.
Yes.
In exercise of the powers conferred by clause 3 of Article 166 of Constitution of India, the governor is pleased to hereby to make the following amendments in the West Bengal Finance Rules, Volume 1, and in partial modification of the notification number so and so. So this has statutory force, my lord. This is in modification of the West Bengal Finance Rules under 166. Lord, kindly come to 131, the next page of this notification. This was published on 25th June 2012. This has statutory force. Kindly come to 131. Next page.
Yes.
Kindly see the bold portion at the bottom. For tenders valued 50 lakhs and above, e-tendering through the centralized e-tender portal is mandatory in addition to publication in print media. Look, kindly turn the page. Note A, minimum period as stated below shall be allowed for submission of the tenders from the date of publication. Look, kindly come to C. for supply of article or stores or for execution of work and services with estimated value exceeding 1 crore 21 days. So if my lord tallies this with page 95, state only gave 5 days time. Okay,
4 to 11. 4th October to 11th.
4th October published not in the evening in the website, 5th October newspaper. That says from the date of publication, even if I take 4th October, 10th October was the closing date. Notification says 21 days time has to be given. Then not kindly take the other notification which I have annexed. Not kindly come to page 140. 142. 140. This is a subsequent notification of 22nd July 2014.
Page
140, my lord. I'm so sorry.
Yes.
Now kindly see what the notification says. It has come to the notice of the state government that provisions of minimum period time for submission of tender as enjoined in note 3 below rule 47(8) of WBFR volume 1 since amended by notification of 25th June, which I have shown your lordships.
Yes.
My lord may tally, my lord, that I have tallied the number and the date.
Yes.
My lord, see it yourself.
95.
Yes.
130, no?
Yes.
That is the 25th of June 2000.
25th of June 2002 and 5400FY on the left hand side, my lord will find the number.
Yes.
Is not being properly observed by the tender inviting authority, like the present case. It is reiterated that the provision of minimum period of time to be given to the bidders for submission of tender should be counted from the date on which the notice inviting tender, including tender, is actually published in the newspaper. So I was just saying 4th will not be the date, 5th will be the date. As per criteria given in note 2 and note 3 below 47(8), the tender publication date is the date on which the advertisement actually appears in the newspaper, wherein it should be specified that the bid needs to be submitted by the date to be fixed after allowing the minimum period of time for submission of the bids according to the provisions of note 3 in case of publication of NIT in more than one newspaper as per the provisions of note 2 of so and so. For instance, the case of tender valued exceeding 1 crore, the date of submission of tender should be fixed not earlier than 21 days. Can you mark this, Lord?
Yes.
To be counted from the date of publication of the tender notice in the newspaper. Likewise, the period should be counted accordingly to the time schedule given in the serial number so and so. Now, on the last occasion, I'll show Justice Rai's order. The Advocate General submitted that in the second call we need not adhere. Justice Rai disbelieved that, rejected the statement, saying that this notification doesn't say that in the second call you can give 1 day's time. So this is my principal ground of challenge in this writ petition. But earlier round, I did not challenge the tender. I only challenged that particular clause. I wanted to participate. Here I am challenging the entire tender. But kindly take Justice Rai's order. So my first ground of challenge is non-giving, not adhering to the mandatory time limit of 21 days. Kindly come to 142. Madam, kindly got that?
Yes.
Lord, I don't want to place the entire fact because it's a very longish order that will take a lot of time. Lord, I'll just place it from the portion where the learned Advocate General submission is recorded.
But the question, the first tender was issued. You know that only the 4 days or 7 days, whatever the time is given, 5th to 11, 4th and 5 days has been given. You have participated. You have not challenged that. You have participated.
Lord,
you have acted upon.
I challenge that particular clause, saying that this clause is stopping participation. Allow me to participate. Court allowed me to participate. Lord, why I am showing this? I understand what is coming from your lordships. Lord, what is the purpose of floating a tender? Why this 21 days? So that everyone knows and participates. Lord, the government floats a tender to invite competition so that they get the work done from the best people at the best rate. That is why 21 days. Otherwise, it could be 1 day also.
Okay.
Lord, kindly come to Justice Rai's order. Kindly come to page 151. Paragraph 15. 151. Straight away, my lord, on the observation I'm taking your lordship, otherwise, my lord, it will take a lot of time.
Yes.
Para 15. This court is at a loss. My lord has kindly got that, my lord.
Yes.
This court is, my lord, this has not been appealed against, this has been accepted by the state. This court is at a loss to find any reason, far less convincing reason, as to why tender process was to be scurried. Was it to suit a particular person or not? Would be the obvious question that would pop up in such situation. The argument of the learned Advocate General that the present tender process, being the second round, did not require adherence to the time schedule of 21 days mentioned in the Finance Department circular does not appeal. So this was rejected. Since I wanted to participate, court did not cancel the tender. Then this court also finds substance in the submission of Mr. Chakraborty that there is no reason as to why the CSDs which are less than 15 years age have only been considered to be eligible. Lord, my lord may skip over because that the court allowed me. Kindly come to para 19. Para 19, 153.
Yes.
In such view of the matter, the question as to how a CSD which is aged more than 15 years would not be able to execute the work and would not be able to complete such work within the period of 75 days as mentioned in the notice inviting tender becomes pertinent, and the same has not been answered at all. The state failed to give any answer. Then kindly come to, Lord, the judgments have been quoted. Kindly come to para 28.
Yes.
Para 27 kindly comes, Lord. I'm sorry, para 27, I should show your lordships. Or from para 26, Lord. In the case in hand, this court has reached a prima facie satisfaction that there is indeed involvement of public interest and that the hasty conduct, now kindly mark this, hasty conduct of the tender process seen in the light of insertion of the tender condition as regards the age of CSD makes the same wholly unreasonable. Since there is no apparent basis on for such condition, it cannot be said that at this stage that any reasonable authority, responsible authority acting reasonably would have taken such a decision. The other ground as regards acquiescence taken by Mr. Dotto also fails to appeal inasmuch as, Lord, what is the ground of acquiescence? That I participated in the first call also. What is falling from your lordship's, Lord? That point was taken by Mr. Dotto. Other point of acquiescence taken by Mr. Dotto also fails to appeal inasmuch as, firstly, the earlier tender process failed. Secondly, it is settled law that even if a person has participated in tender process, he can always challenge the same on the well-known grounds of arbitrariness. And thirdly, in the tender process which we are presently concerned with, the petitioner has not yet participated, thereby obviating the hurdle of acquiescence. Then 28, for all the reasons above, this court is of the prima facie view that clause 34 of the said notice inviting tender is unreasonable, and as such, the same should not be pressed for the purpose of assessing the bids of the bidder participating in the tender. Therefore, there shall be an interim order directing respondent not to press clause 34 of the additional terms and conditions at page 116 of the writ petition while assessing the bids of the bidders participating in the tender process until further orders. The petitioner shall therefore be eligible to put in their bids, and the petitioner's bids shall be considered along with the bidders without taking into consideration clause 34. Then kindly take para 32. It is clarified that the bid submitted and considered during pendency of the writ petition shall abide by the result of the writ petition. Lord, I am carrying a copy of the writ petition. At that stage, my grievance was that this additional clause is stopping me from participating because all my treasures are above 15 years. Court came to my rescue. Court deprecated the practice saying that 21 days less than is not appreciated, but I did not challenge the tender. Court did not go into that aspect. At this stage, I participated. Then not kindly take page 157. 75 there, but then first volume. 75.
Yes.
Lord, 13th October.
Yes.
Kindly see number of qualified bidders. Number of qualified bidders. Not qualified means they have opened the tender, found qualified is less than 3. Hence, the tender is hereby cancelled.
Yes.
The above cancellation of SNIT shall abide by the result of the writ petition which is pending before High Court. Lord,
There is a second cancellation.
second cancellation by the tender inviting authority, like page 75.
Yes.
So I was waiting for the third call.
Yes.
Then kindly see what happened. Take the next page. But page 158, kindly mark the date. That is not on 14th of October. There at the bottom, 14th of October, he signs. Kindly see, my lord, the date of publication of the NIT, 4th October 650, last date of submission 10th October. Two number of bidders. Lord, clause serial number 3 I am reading. Serial number 3 I am reading, Lord. Name of the project below that. Kindly got that, Lord? 158. Two numbers of online bids have been received, which are admitted prima facie without verification of the documents after decrypting the e-tender on 11th October 3 p.m. So the tenders were decrypted on 11th October 3 p.m., cancelled on 13th October. Then, by the undersigned, text messages, mails has been deemed to have been sent through the so-and-so system. Meeting of the departmental high-value tender committee was held on 14th October. So he cancelled, then high-value tender committee took it upon themselves. Yes. Place of meeting so-and-so. EAC. Two numbers of online bidders were received from so-and-so 11th October 3 p.m. from the web portal. Now, after careful evaluation of the technical bids by the department high-value tender committee in terms of delegated powers on behalf of the government irrigation department, the preliminary result of the technical evaluation is summarized below. Qualified dredging, the petitioner and Mr. Saha's client reply. Qualified. Then kindly, my lord, come to clause number 6. Final bid evaluation summary for the work tender would be published and uploaded in the designated folder of e-procurement website on e-tender on 3 p.m. 16th October. Signed by the same person. My lord may verify who cancelled the tender in page 157. So firstly, 11th decrypted 3 p.m. evaluated, 2 persons found eligible, less than 3, cancelled. Then high value tender committee, his superior bosses, they took it upon themselves. They again evaluated. They found us qualified, started proceeding. Very well, you started proceeding. My second ground of challenge is once it is cancelled, they could not have proceeded. Then, Lord, I'll show your lordships. Kindly take 159. The financial bid summary was opened on 16th. Lord, kindly come to, very well, madam. My bid is 35% below, his bid is 32% below. Financial bid was open. Only 2 qualified bidder.
Yes.
Kindly come to the next page. What is to be done, Lord, in this sort of a situation? That, my lord,
what is the 159?
Lord, 159 is, my lord, the document financial evaluation, which was evaluation. Because they said by 16 they will do it.
Yes.
Lord, kindly come to 160. This will be the seat anchor of my submissions, Lord. Kindly have a look at it. This is a notification issued by the Finance Department on 14th February 2017. As per Finance Department memo number 3rd December 2012, if the response to tender, including e-tender, is less than 3, then tender is invited afresh in terms of note 1 below rule 47(8) of the West Bengal Finance Rules, as amended by this department notification number 25th June, which I have shown to your lordships. The tender notice and retender notice, if any, is required to be published in widely circulated dailies, also through e-tender portal. In case of e-tender auction, prior to invitation of the tender auction, the eligibility criteria and other terms and conditions are required to be prepared carefully by the tender inviting authority. However, in the second call, if any eligibility criteria and other terms and conditions as contained in the first NIT are required to be reviewed by the tender inviting authority to ascertain whether it was too much of restrictive, say specifications and qualifications were fixed at a higher standard than required, 2, advertisement in the widely circulated newspaper were openly properly published, and 3, other related procedures matters were observed in its entirety. Now, kindly pause here for a moment. So it says that in the second call, you may think while publishing that why we went wrong, why there is less participation. We may relax. Then However, it has been observed that in many cases, the above provisions and procedures of reviewing the eligibility criteria and wide publication of NIT for the tender second call are not being properly observed by the tender inviting authority and department. Also, in some cases, extending the time for submission of bids after expiry of normal time is regarded as equivalent to a retender or fresh tender. Under such circumstances, in partial modification of the department memo dated so and so and related orders issued in this regard, the following provisions regarding extension of last date of submission of bid and acceptance of bid, kindly mark this, and acceptance of bid with numbers of qualified bidders during the retender is less than 3 are to be followed. So if there is less than 3, what is to be done? They have stated. But kindly come to A, 2, II. If the number of qualified bidders during tender, retender, re-auction is less than 3, the tender inviting authority shall take a decision based on the following situation. Lord A, if the estimate is less than 5 lakhs, doesn't apply. Lord C applies. If the estimate is more than 1 crore, our case, it is more than 31 crore, the department head stroke secretary, in consultation with the finance assistants of the department and departmental tender committee, will refer the file to the finance department.
Yes.
Lord, kindly pause here for a moment. Lord, the government has considered this eventuality.
Yes.
Suppose, apart from my submission that after cancellation it could not have been reopened. Suppose let us take a situation there has never been any cancellation. Only both of us are there. What would the state do?
Then this is the procedure.
This is the procedure. State would forward it to department. Now kindly read. However, in such cases, ABC are to be followed. But in my case, 2 applies because it has to be sent to the finance department. In the case is to be referred to finance department. Got that? Through the head of the administrative department secretary, the tender inviting authority will forward the case along with duly filled up format, annexure 1 and necessary documents to the head of the administrative department. The head of the administrative department, in consultation with the finance assistants of the department, on recommendation from the departmental tender committee, will forward the file to finance department along with necessary justification. But if I have understood it correctly, subject to correction to be made by my learned senior, high esteemed senior adversaries, my lord, that if my lord comes to page 160, Roman 2, shall take a decision based on the following. So the decision is to be taken based on the approval of the finance department.
Correct.
That is, my lord, I could answer. But kindly come to 162. What is to be sent? 163. They said, my lord, annexure 1 in page 161, it is stated annexure 1.
The format.
Just to show you lordship only one thing. Lord, kindly come to in the second call, page 163, middle of the page. Kindly see number of bidders, respondent, number of technically qualified, details of financial bid received. So they will open the financial bid. Then with the financial bid, they'll send it to the finance department. That's the notification I have understood. Now, Lord, kindly take the supplementary affidavit I have given to your lordship today. Supplementary dilam. Je supplementary dilam. Diyechen Judge Sahib ke?
Yes.
Lord, kindly straightway come to page 8 of the supplementary affidavit. I'll just give you, lordship, the timeline. Kindly, my lord, take first page, bids list, first box. 2, Replay App and Companies, Tevering and Handling Private Limited, accepted AOC. Then on the extreme right hand side, 18th October, 6:31 AM. But who works at this, sir?
Where? Okay. 18th at 6:30 AM.
6:31 AM.
No. Bid number so and so.
18th October, 6:31 AM.
Rejected finance, accepted AOC.
Then, my lord, I'll show you lots of the other dates. So 18th October in the morning at 6 AM, state opened their offices, which was a declared holiday. I have annexed the calendar. On the day of Dhanteras, to, my lord, issue the LOA in favor of Mr. Saha's client. Now, my lord, kindly see the timeline thereafter. Timeline.
Dhanteras is the auspicious.
Yes, they got the dhan. Dhanteras, 31 crore dhan, they got it on the state. That's why Dhanteras day was, I appreciate their thought, my lord. They're right. But kindly come to page 8 once. Just have a look at it. Just see the technical bid summary portion. Second column. Kindly see, my lord, updated on. So the technical bid was updated on 14th October, 8:53 p.m. I has got that second box. Then technical evaluation summary detail. Kindly see the date. Technical evaluation summary updated on 16th October, 4:10 p.m. So technical bid open 14th October, although cancelled on 13th, updated on 16th October. Turn the page. Financial bid opening summary. Financial bid updated on 16th October, 5:31 p.m. Opened. Then financial bid evaluation. Then kindly come to financial bid evaluation summary detail. Kindly see the time. Updated on 17th October, 8:02 p.m. So financial bid summary was uploaded on 8:02 p.m. Not kindly pause here for a moment. As per the notification, they should have sent the file to finance department. 17th in the evening at 8 p.m. you uploaded. 18th in the morning at 6 a.m. you issued the LOA. Then it doesn't end here. Doesn't end here. Kindly take the next AOC. Next box AOC. Kindly see the date. Updated on 18th October, 6:29 a.m. That I have shown your lordships. Yes. 18th October. Now, my lord, kindly come to page 11. Although in the website they say on 18th October in the morning they issued the LOA, kindly see the date of the LOA. 17th October. Page 11 of the supplementary affidavit.
Yes.
At the top right hand side. Then when did you send it to the finance department?
Yes.
Lord, I have 3 points to summarize. I'll now go to the judgments. One is that 21 days timeline has not been adhered to. Number one, Lord, kindly see the chronology of events. Just to identify and shoot and give the work to one person, what they did. First, they shortened the time of participation.
Now you are having the 3 points.
One is 21 days not adhered.
21 is not cancelled.
Cancelled, and then this notification has not been adhered.
Memorandum is not been
Very well. Now, Lord, let us see what is the law on this. Kindly have a look at it. Lord, kindly first take, Lord, এটাতে সকালে যেটা পাঠালাম সকালে যে জাজমেন্টটা পাঠালাম এইটা এটা বেলা ত্রিবেদী জাজমেন্টটা নট কাইন্ডলি পড়িসিনি সকালে Lord, this is reported in 2024 SCC Online Supreme Court 480. Yes. Reported judgment দাদারা সব জানে এটা কি নামে মামলাটা তুমি তো জানো লেভেল 9 বিস প্রাইভেট লিমিটেড আদিত্য বলছে কপি দাও আমি কেন কপি দেবো দাদাদের সব পড়া আছে Lord, what happened in this case, I tell you, Lordships. Tender was cancelled. X was selected as not the bidder successful. Work order was issued. Disqualified bidder challenged it. During the pending of the writ petition, work order was stopped. Tender was cancelled. A high court committee was appointed. They found illegality in the tender. Tender was cancelled. Now, my lord, High Court disposed of the writ petition, saying the tender is cancelled. Now the qualified bidder who was given the work, he filed to LPA, latest patent appeal, and one writ petition. The writ was taken up by the division bench. The state came, where the earlier party was not made party. State came and said, we can reopen the cancelled tender if he is agreed to work. Tender was reopened, work was given. Supreme Court deprecates such practice. Says you could not have done it. But kindly see, kindly comes to my lord, paragraph 4. I don't want to trouble your lordship with the entire facts, my lord. This is more or less the facts. The question that has been posed before us in the instant appeal is whether the High Court could have disposed of the CWP civil writ petition filed by the respondent number 2 by simply accepting the statements made on behalf of the learned advocate of the respondent number 1 and respondent number 2, virtually permitting the respondent number 1 HIMUDA to withdraw the cancellation of initial tendering process order dated 5th February 2021 and permitting respondent number 2, Mrs. Vasu Construction, to execute the project on the same terms and conditions and at the same rate as per the initial, though the said tender was already withdrawn by the respondent like our case. Now, my lord, kindly take paragraph 7. Subsequently, the respondent number 1 so and so cancelled the tender on 5th February in view of the said order dated 18 January 21 passed by the High Court. The said action of the respondent number 1 came to be challenged by the respondent number 2 Vasu Construction by filing CWP so and so. Respondent number 2 also filed 2 LPAs being agreed by the common order dated 8 January passed by single bench. The division bench of the High Court disposed of CWP wide impugned order dated 18th October accepting the statement made by the learned counsel of the respondent stated herein above. We are at a loss. We are at a loss to understand as to how the said petition filed by respondent number 2 would have been disposed of by the division bench by merely recording and accepting the statement of the learned counsel of the respondent number 1 when the tender in respect of NIT was cancelled by the respondent number 1. HIMUDA on account of gross irregularities and illegalities in the tender process found by the independent committee constituted by the High Court and on account of the order passed so and so. We are also at a loss to understand as to how Executive Engineer HIMUDA would have made the statements before the division bench that the competent authority of the respondent number 1 wanted to withdraw the cancellation of the initial tender process order and that the respondent number 1 had no objection to go ahead with the initial process. Then I'll go on reading. In case the respondent number 2 was ready to execute the work at the same terms and conditions as we agreed at the time of finalization of the NIT, 15 November, when the respondent number 1 itself had decided to cancel and in fact cancel the initial tendering process, vide its order dated 5th February 21, accepting the finding of the committee constituted by the High Court to effect that there were irregularities in the irregularities committed by HIMUDA in processing the tender and that the respondent number 1 technically qualified. When the common order dated so and so was passed in the writ petition number so and so and petitioner so and so filed by the present appellant recording the said finding, the committee appointed by it pursuant to is the respondent number 1 had cancelled the tender on 5th February and had issued fresh NIT. It was incumbent on the part of the respondent to imprint the said 2 writ petitions. Particular kindly take para 10. Though it is true that initially an LOI was issued by the respondent number 1 in favor of respondent number 2 on 17th December 2018, but the same was withdrawn by the respondent number 1 as per the letter dated so and so on account of pending litigation. In any case, now kindly mark this. In any case, it hardly needs to be reiterated that letter of intent is merely an expression of interest to enter into a contract. It doesn't create any right in favor of a party to whom it is issued. So Mr. Saha's client cannot come today and say that I got the LOA, right has created in my favor. Still, I have made him a party. A detailed agreement contract is required to be drawn up so and so. 11. Since there was no right whatsoever created in favor of the respondent number 2, and since the respondent number 1, HIMUDA, has already accepted the recommendation of the committee appointed by the High Court by order dated so and so and cancelled the tender and issued fresh NIT, the respondent number could not have agreed to allow the respondent number 2, who was found to be technically qualified, not technically qualified, to go ahead with the work. So we have 2 things. One is Supreme Court deprecated the High Court, that High Court has allowed the appeal on the basis of the stand of the state that they withdrew the cancellation. They could not have, and LOA doesn't create any right. Then, Lord, I'll just show you, Lord, give you also one more judgment on the issue that, Lord, hot haste itself is malafide. Kishorda jeta dekha ota dao. Parata bol. 13. Lord, this is a favorite judgment of Mr. Dottum, Lord. So, তুমি তো এটা দিয়েছো আমাদের আগের মামলায়, অন্য মামলায়। So, this is reported in 2009 10 SCC 388.
আমরা তো আরো করেছি এনএসসি কত
Obviously, senior se kala na junior ke.
করতে হেড করছি না
9 10 SCC 388, Lord. Paragraph 27 and 39.
Yes.
But every action of the state or its instrumentalities should not. No, para 27. I'm so sorry, my lord.
Yes.
I'm sorry, my lord. Every action of the state or its instrumentality should not only be fair, legitimate, and above board, but should be without any affection or aversion. It should neither be suggestive or discrimination, nor even apparently give an impression of bias, favoritism, and nepotism. Not what should I say in this case? The decision should be made by the application of known principles and rules. In general, such decisions should be predictable and the citizen should know where he is. But if a decision is taken without any principles or without any rule, it is unprecedented, unpredictable, and such a decision is antithesis of the decision taken in accordance with the rule of law. Now, kindly come to 39 now. Or 28 ফেরত আনাচ্ছিস।
Yes.
Anything done in undue haste can also be termed as arbitrary and cannot be condoned in law.
Yes.
And Mr. Mondal asked me to show para 28 once. Not kindly pardon me, I should have shown it earlier. In essence, the action order of the state or state instrumentality would stand vitiated if it lacks bona fide, as it would only be a case of colorable exercise of power. The rule of law is the foundation of democratic action. But there cannot be anything more colorable exercise of power than this.
That's all.
That's all. Same. I don't want to multiply. Lord, kindly Lord, stay the LOA and Lord, protect the interest. They should. And Lord, I have prayed for interim order because at that point of time we do not have the work order. Kindly have a look at my prayers, my Lord. Aage read tag bad dao. Page 30 of the writ petition. Lord, kindly see B certiorari transmitting record instant case, thereby rendered H for the present. H is interim order passed, thereby restraining respondent authorities to proceed to a subject tender. Lord, I have prayed for that even if any work order is issued for cancellation of that. Para E, prayer E, quashing the work order if any granted, because I didn't have access to that. Now I have access, I have brought it. So the supplementary affidavit is in line of the prayer. And just to clarify the earlier round of writ petition I am carrying, my Lord, kindly have a look at the prayers. Only clause 34 was challenged. So it cannot be the case that I challenged and the court did not grant me that relief.
Let what Mr.
Very
AG will say.
I'm carrying that, Lord, if they say this. But I'm grateful to you. But may I just come back in a minute?
Yes.
Now, my Lord, the first thing is that what had happened, my Lord, after, my Lord, cancellation of the tender. Well, let us confine ourselves to that. Please take me documents. First, my Lord, kindly, my Lord, those documents are not on record. My Lord, kindly permit me to, my Lord, furnish it to the court, my Lord. First is, my Lord, your Lordship would find, my Lord, this revocation or the cancellation of tender, my Lord, these were communicated to all the bidders. Or rather, my Lord, these are all uploaded. Like, my Lord, my learned friend has procured all these documents, my Lord, from the website. Now, these things, my Lord, what has the untold story, my Lord, may I first, my Lord, tell the court. But first, my Lord, kindly take, my Lord, the mail summary details report. উপরেরটা খালি দে তাহলেই হবে But this, your Lordship would find, this was addressed to so many persons. In the middle of the second column from the left hand side, after serial number, message generated date, message type. What is the message? Cancel, retender, cancel, tender, revoke. This, your Lordship will find, please take the second last line, fourth paragraph under the column username. is dredging and desiltation.
And হচ্ছে এটা ক্যান্সেল হচ্ছে সবার কাছে
Cancel, return,
সকালবেলা
revoke.
10:56 সবার কাছে
Cancel, return, revoke.
এটা হচ্ছে রিডেম আর এটা হচ্ছে cancel.
The second last is the writ petitioner before my lord.
Yes.
Now, what was sent to them? Miller, kindly Miller, turn the page. So this is what was sent to everybody, where there are two lines. It is informed that the tender that has been cancelled has been revoked to the previous stage through corrigendum. You may kindly visit the portal for further details.
NIC sent to everybody.
So but this was Millard uploaded, plus Millard NIC had sent it to all the Millard these bidders or the addresses. Then my lord may kindly take Millard another document. L ta de, L. A second page ta de. Act. But my first endeavor would be to demonstrate before the court that the writ petitioner was contemporaneously aware of, not only the writ petitioner, various authorities, of what had happened, Millard, post cancellation of the tender. First is revocation of the cancellation, information to everybody. The next document. Cancelled on 13th, 14th onwards, Millard, these are the happenings. Joseph ke din eta. Now, please take Millard the second page. This is very important. Where at the top, Millard, your lordship finds Millard in bold, technical bid opening TBO preliminary technical and evaluation sheet. Then Millard, there is a table in the middle of that page. Name of the contractor. Number 1 is the writ petitioner. Number 2 is Millard, the successful bidder. And Millard, both are qualified. Yes. Now, Millard, below the table, Millard, there is a heading, preliminary result. Millard has found that. Qualified in technical evaluation, 2 numbers. Within 24 hours of uploading of TBO summary sheet containing preliminary technical qualification result, any of the aggrieved bidder may seek clarification, redressal, review of HTEC on the list of bidders through email so-and-so with supporting facts, figures, documents. If such clarification review relates to eligibility of other bidders on the grounds of submission of false, forged, manipulated, inappropriate credentials, modalities prescribed in the departmental notification shall be followed. In case the review only seeks the eligibility of the applicant himself, view of the tender evaluation committee HTEC would be communicated in writing to that bidder within 2 working days. If the bidder, the second part, first is Millard, it will be procedure. Second is, if the bidder is not satisfied with the clarification of so-and-so, he may appeal to the chief engineer within 24 hours of receipt of the communication from HTEC through email. The concerned chief engineer will dispose of the complaint jointly associated with at least another available chief engineer within the next 2 days. Thereafter, the final technical evaluation sheet of the technically qualified bidders would be uploaded after incorporating modifications if required. The TIA shall, while uploading the final TBE summary sheet, accept or reject electronically the admitted bids based on the advice of so-and-so as per so-and-so. Thus, at this stage, the rejected bidders will get back their EMD such and such. Such and such will be treated as valid mode of communication. All bidders are requested to regularly check the registered email so-and-so. Then 6, final bid evaluation summary for the work tender would be published and uploaded in the designated folder of e-procurement such and such. This was to the knowledge of the writ petitioner. No complaint filed, no clarification sought. Therefore, Millard, this exercise was not carried forward because we did not receive any complaint.
After technical bit এটাও বলা আছে যে সবসময় keeping
Yeah, সেটা দেখিয়ে দিচ্ছি। Then kindly take me lord the next document এবার M টা দেখ M
এটা একটু দিয়ে দিন।
Now this is my lord the bid technical bid evaluation summary.
After expiry of 24.
Now my lord, we had to wait for 24 hours my lord, in terms of the previous document. We waited for 24 hours. My lord, this is on the 16th. My lord, your lordship finds my lord, this is the technical bid evaluation summary where your lordship finds my lord, there are two bidders, the petitioner and my lord, the successful bidder. Please take my lord the next page. This is the on the top my lord in bold final technical bid evaluation sheet.
Yes.
Then my lord, your lordship would find my lord, we open the financial bid, which is document N today N.
এটা দিয়ে দিন।
My lord, may kindly turn the page.
Yes.
My lord, in bold at top, financial bid opening summary sheet. Where then my lord, 3 lines thereafter, date of financial bid opening 16th October at 5:03 p.m. Financial bid of 2 numbers of technically qualified, such and such. My lord, but I'm reading my lord, the second page. Where at the top, financial bid opening summary sheet.
Correct.
That your lordship has found, my lord. In the middle of, but after that, my lord, your lordship finds where the date and time, 16th October, my lord, the third line thereafter. Then, my lord, the table in which, my lord, your lordship finds that the replay and company had given
36 and 32. Yes.
32. Therefore,
First time.
the first time?
First time.
Yes. Now, my lord, this is the stage where my lord, malice, malafide, bias, etc., many things have been alleged. My lord, this is the first time or the first stage where my lord, the department comes to know about the financial bids or the offer, financial offer that has been made, because there is a two-bid system. Then, my lord, whatever is there, my lord, the other things, my lord, I don't trouble your lordship. Then kindly take, my lord, this document, which is O. Please take me at the second page.
Signed on 22nd October.
But the second page is minutes of the meeting of the departmental tender committee such and such on 16th October at the conference room, so and so. Millard, your lordship finds, Millard, please take, Millard, these 2 tables. Please take the second table in that page. Second call, tender details. My lord is found, Millard. First call also, Millard, has been noted. Second call is noted. Last day of submission, etc. Then please take, Millard, my learned friends, one of the fundamental submission was that it did not go before the finance department. Where in that page, where instead of Millard troubling your lordship in its entirety, please take the last paragraph at that page. Considering site condition and general scope of work, Chief Engineer so-and-so, being the tender accepting authority, recommended acceptance of the lowest bid at such and such in favor of such and such. Next page, after threadbare discussion on the issue and careful perusal of the relevant clauses of the ENIT considering the reasonableness of the L1 rate, the government appointed departmental tender committee recommends the lowest rate, that is 36% such and such of such and such of so and so address amounting to rupees so and so only for acceptance. The TIA is required to follow the extent guidelines in regard to additional performance security in terms of FD number such and such. Then, my lord, it goes to the finance. This your lordship would find, my lord, the previous page.
Yes.
With reference to the above, there is 1610. In connection with the subject, the undersigned is directed to send herewith the copy of the minutes of so and so. The first page, of the last bunch that I have handed up.
With reference to the yes.
Yes. The so and so is directed to send herewith the copy of the minutes of the tender committee meeting held on such and such date. Then kindly take the finances acceptance, what are they? Which is P. But kindly excuse us, I do not know why this has come in this form. But
এটা হচ্ছে আপলোড হয়েছিল মানে এগুলো হচ্ছে ফিজিক্যাল কপি নেই তো
Now, but this is the observation, my lord, of the FD, that is the finance department. We may opine that the administrative department may take suitable decision regarding tender regarding the work such and such in so and so Murigonga based on the recommendation of the Departmental Finance Committee TIA Annexure 1 in terms of finance memo dated such and such. Further concurrence in this respect from GRT FD is not required. However, as the tender is proposed to be accepted below 36% of the amount put to tender, additional performance security may be taken, etc. So, this takes care of one of the fundamental submissions of my learned friend, that what could not have been done without the finance department approval. In my very respectful submission, stands answered that the finances approval was taken because of the value of the work. This is in respect of the first one. Number two is, but I'll come to the importance of the work later on. As your lordships know, that there are two stages. One is the tendering stage, the other is the contract stage. The contract stage follows the tender stage. Today, my lord, when this matter is being moved before your lordship, my lord, the agreement has already been executed by and between the state and, my lord, the private respondent. My lord, the date I give your lordship is on 22nd of October 2025.
22nd October
2025.
Yes.
With the execution of the agreement, my lord, today we have crossed the tender stage, and now, my lord, we are at the, my lord, contract execution stage.
Yes.
Dada, সব বলছি দাদা।
Yes.
But my learned friend submission was that the tender should be cancelled, and, my lord, the LOI should be cancelled because LOI does not confer any right. My lord, today, my lord, we are at the contractual stage where, my lord, important rights have vested in favor of the private respondent.
Yes.
But I have the measurement book also, my lord.
এটা ডিসক্লোজ করব না কিন্তু কাউকে
I have the measurement book, my lord. Yes, but I can, my lord, place it for the perusal of the court, my lord. Kindly, my lord, I would not like to, my lord, part with this document, my lord, for the perusal of my learned friend. But this is the, my lord, measurement book, my lord, as your lordship knows.
When you started the work?
But on the 18th, 17th was
17th was the
work order.
Work order 17th, work started 18th.
Reading has also started.
My lord, your lordship, kindly take, my lord, the page number 2, my lord, printed, my lord, at the top. My lord, the fifth line, handwritten, date of commencement 1810. Page number 2, my lord, printed at the top right hand side.
Yes.
My lord, the fifth line, handwritten line,
1810.
date of commencement 1810, date of measurement 2010.
Yes. Yes.
But today, my lord, the letter of intent, my lord, has matured into, my lord, a binding contract. And therefore, my lord, in my very respectful submission, my lord, there is no scope of any interim order at this stage. But, my lord, this is the second part. But the third aspect of the matter is where the circular of the Finance Department of 7th of June 2022, my lord, which relates to acceptance of tender, may not be that important, but kindly just have a look at it.
But Mr. Datto,
Yes, sir.
what about the 150? Though you're shown,
Yes.
can you continue? What about this 157 of the writ petition cancellation has been informed?
Yes.
How you can continue?
My lord, the cancellation was revoked, my lord, and my lord, it was informed. My lord, yes,
The first document is telling that the cancellation, revocation, and review.
yes,
First, you're saying that the cancel, retendered, and revoked.
yes,
Correct. So this is the cancel is 157.
right.
So where is that retendered and revoked?
But that is where the first document where the which was my lord, yes, yes,
You
yes.
stated that. So
But
how
kindly take the second page of that. It is informed that
revoked to the previous stage?
the yes, tender that had been cancelled
Hmm.
has been revoked to the previous stage.
Okay.
So they were informed.
So what is your answer to the Supreme Court judgment?
Yes, I'll come to that. I'll come to that's why, my lord, I have made this submission. The Supreme Court judgment, but I'll definitely deal with that. But that was, my lord, possibly, my lord, on a different context, where, my lord, High Court had constituted a committee. Then the committee had come to certain findings as regards the irregularities in the tendering process. Thereafter, based on the submissions of the advocates, counsels, my lord, the Supreme Court took umbrage on that, that you cannot, after all these things, rely upon advocate submission and allow somebody to reap some benefits. But I'll come to that. I'll take that, my lord. So, my lord, this is, my lord, the second part. The third aspect of the matter is, my lord, which is of utmost importance. My lord, this is a job which cannot wait, which cannot be deferred. Why? Well, my learned friend's client is an expert in this. I can understand the anxiety. From 2006, every year they are doing this job, minus last year. Now, what happens is, my lord, before the Gangasagar Mela takes place, my lord, about 2 months before that, my lord, the channel has to made navigable. To make it navigable, my lord, this desilting or dredging has to be done. Otherwise, my lord, there would be, I mean, the navigable, what should I say? It will get choked. So this is a work, my lord, which cannot wait, my lord, for 2 months, 3 months, or even maybe 15 days. My lord, the Gangasagar Mela is, my lord, in early January.
January 7th.
7th January 2026. But I have to, my lord, complete it by December. This is a 75-day work. Where the work is to be completed and handed over to the administration or the administrative head, who is the district magistrate of that district, by 1st of January 2026. So, my lord, this work cannot wait, my lord. Therefore, my lord, first of all, my lord, there is no illegality. Everything is, my lord, transparent. Everything is uploaded. He was contemporaneously, my lord, having the knowledge of it. He was qualified in the tendering technical bid. He could not outbid the other bidder. Therefore, my lord, it's too late in the day to come up and, my lord, make, my lord, these kinds of submission. But what is more important is, my lord, your lordships, my lord, sitting in judicial review, my lord, on, my lord, tendering processes and, my lord, contracts, my lord, have always, my lord, adopted, my lord, judicial restraint. Why? Because there must be paramount public interest in entertaining a writ petition of this nature. I don't think I need to place judgments on that, number one. Then the question would arise, what is the remedy of an aggrieved person? The remedy is by way of damages. And, my lord, on the issue of injunction, my lord, now, my lord, as your lordship know, my lord, that with the amendment of the specific relief act in respect of infrastructure projects, the injunction is to be refused. Because just for the sake of it, kindly have a look at section 41 HA. Please take 41 HA and the schedule 3E. বেশি দেখো ইয়ে করে নে রোটেট করা তাহলে তো হয়ে যাবে।
Yes.
3E, your lordship has seen in the now, my lord, 3 short judgments, my lord. I'll not trouble your lordship with all these. First, my lord, this Jagadish Mondol's judgment. Just, my lord, for the sake of it, my lord, please have a look to this. একটাই জানি তাই বারবার দেখাই। 2007-14 SCC 517 Jagadish Mondol's judgment, my lord. The remedy, your lordship would find, my lord, paragraph 22.
Yes.
Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, malafide. Its purpose is to check whether the choice or decision is made lawfully and not to check whether the choice or the decision is sound. When the power of judicial review is invoked in matters relating to tenders or award of contracts, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to the award of the contract is bona fide and is in public interest, courts will not, in exercise of power of judicial review, interfere, even if a procedural aberration or error in assessment or prejudice to a tender is made out. But these are the threefold submissions of my learned friend.
Yes.
The power of judicial review will not be permitted to be invoked to protect private interests at the cost of public interest or to decide contractual disputes. The tenderer or the contractor with a grievance can always seek damages in a civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, business rivalry to make mountains, etc.
Yes.
But this is the remedy that is available. Judicial restraint. Just note this citation, not very important. Shilpi, this is Shilpi Construction, 2020, volume 16, Supreme Court cases, 489. Well, it all started with Tata Cellular's case.
Yes.
Only to give you a lordship a later one. Please take para 20.
Yes.
The essence of the law laid down in the judgments referred to above in the exercise of restraint and caution, the need for overwhelming public interest to justify judicial intervention in matters involving the state instrumentalities. The court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal, etc., etc.
Yes.
And this fair play in the joints, the lordship will find this is at paragraph 19 also, the Supreme Court has once again said.
That is, yes.
And the last one, this is a where in writ jurisdiction also, section 41 HA has been applied by the Honorable Supreme Court. This is NG Projects 2022 is volume 6. SCC Online 127. Please take paragraph 19. 19. But this is in the writ jurisdiction, that's why, my lord, I just wanted to cite this. Section, para 19, the specifically amended by so and so, when section clause HA was inserted, then, my lord, clause HA is, my lord, quoted.
Yes.
Then please take, my lord, para 23. Where, my lord, the Supreme Court once again holds that injunctions should not be granted. Okay.
Yes.
But only one thing where I wanted to show that circular, I think, but 2320 one circular I've handed up. 7th June 2022 Finance Department Circular number 2320. Well, please come to Millard, the fourth page of that, or the last paragraph number 4 in the fourth page.
Which document you are referring?
Well,
This superseded Chinese for Article 2017.
The first line is superstition. Superstition.
Well, please take, Millard, the paragraph number 1. Now, this circular supersedes all the previous circulars. Paragraph 1, my lord, has found.
Yes.
In supersession of all the orders published earlier in this regard, the governor is pleased to prescribe the following norms for acceptance of tenders, where everything is there in case of first call. In the second page, then in the third page, the other things are there. And finally, my lord, at paragraph 4, where, my lord, this is the play in the joints. For acceptance of tender beyond the limits as stated herein above, the proposal shall have to be referred to the Finance Department with rate analysis by TIA, comments of DTC, and with specific recommendation of so and so as enclosed. If any revised administrative approval is necessary due to acceptance of tender beyond the estimated and so and so.
Yes.
না না এটা আগে দেখো না এইটা কিসের
That's all.
Yes, these are my submissions, Millard. Today, Millard, we are at the tender contract stage, Millard.
I appear for the respond number 6.
Millard, may I take your lordship's leave?
Yes.
Lord, I have now become successful. Now, my lord, 2 or 3 things, very short, briefly.
In the beginning, he was successful only in interjection.
My lord, please have a look at, my lord, the previous order of my lord, our court. My lord, that your lordship will find is at page 142. I will only draw your lordship's attention to page 155. And my lord, as my learned friend has very fairly submitted, his previous challenge was not to the tender. He was very happy with the tender. His challenge was confined to one clause, clause 34. Now, my lord, please see what the court directs at page 155. Well, if your lordship please comes to paragraph 28. For all the reasons aforesaid, the court is of the prima facie view that clause 34 of the court.
Clause 34.
That's right. Now, my lord, court says what? The same should not be pressed for the purpose of assessing bid. So, my learned friend, my lord, accept the fact that, my lord, the tender is otherwise valid. This is the only offending clause. My lord, once this clause goes and he is allowed to participate, he has no other quarrel with the tender. Now, my lord, he therefore thereafter participates without any further challenge to the tender. He participates and, my lord, makes his, my lord, technical bid and financial bid.
Yes.
My lord, my lord, then, my lord, says that very well I shall wait for evaluation of my lord, financial bid. My lord, the question is very simple. My lord, if, my lord, his financial bid was L1 instead of, my lord, being L2, and, my lord, my was L1,
then my lord, would he still have preferred the challenge? My lord, that is my lord, test of bona fides. He is taking a chance. Your lordship has seen the timelines. 13th, my lord, the second call is there, only 2 bidders cancelled. Then, my lord, considering the immense urgency of the work, on 14th it is reconsidered. My lord, it is, my lord, goes through the channels, reaches the approval of, my lord, the committee, reaches the approval of the finance department, comes back and is sanctioned. Thereafter, my lord, my learned friend is, my lord, put in the know because everything is uploaded in the portal. He is aware. He does not, my lord, at that point of time make a challenge. He waits. When, my lord, he is declared L2 and I am L1, my lord, then, my lord, he decides, my lord, to challenge and he then waits for, my lord, more than 10 days. In the meantime, work order issued, LO issued, deployment post haste, work started, 10 crores has been, my lord, employed, dredging equipment all in the site because the work is a time-bound work. My lord, in this regard, I'll just request your lordship to please have a look at, my lord, page 109. My lord, these are the additional terms and conditions of the tender. My lord, please turn to page 110.
Yes.
Clause 10. My lord, this is the purpose. To ensure participation of resourceful bidders having expertise in dredging for this type of project, which absolutely cannot afford any time overrun. In view of the internationally acclaimed religious fair going to be held at a fixed time in January 2026. So, my lord, time overrun, my lord, was a constraint, was a challenge from the very beginning. Then please have a look at page 112.
Yes.
Well, this was the specific requirement, clause 21. The contractor shall mobilize all the dredgers, allied vessels, equipment, and manpower at site within maximum 15 days from the date of LOA. And, my lord, finally, please have a look at page 113. My lord, clause 36. Notwithstanding anything mentioned anywhere in the clauses of this short notice inviting tender agreement and attached documents, contractors shall have to complete the required dredging work in all respects by 31st December 2025. Specified timelines. My learned friend knows the urgency.
Yes.
Now, my lord, my learned friend raises 3 points. Point number 1 is, my lord, 21 days. My lord, what is the 21 days requirement? Please turn to page 130, which my learned friend showed your lordship.
130.
130.
Yes.
My lord, this is the, my lord, notification he relies on. My lord, turn to, my lord, page 132. Clause C is what my learned friend relies on.
Yes.
My lord, what is the requirement for supply of articles or stores or for execution of works and services with estimated value exceeding 1 crore? 21 days. What is 21 days? Minimum period for submission of tender. He has submitted his tender. How can he raise this point?
Yes.
Well, secondly, well, please see, well, he has participated in the tender, put in his technical bid qualified, put in his financial bid. So therefore, my lord, he accepted the fact, my lord, whoever is the L1 bidder will get the tender because both are now qualified. Now, my lord, today, if he has participated in the tender, the question is, what is, my lord, otherwise the justification for which he now challenges the tender? Now, my lord, the question is, again, I repeat myself, if he had been the L1 bidder, would he have, my lord, brought this challenge? Obviously, no. Now, my lord, the important question is, my lord, here, my lord, he is therefore now, my lord, by his own actions, stopped from contending that, my lord, the changes should be challenged. And, my lord, so far as his challenge is now concerned, his challenge is now confined to only one question. That, look, you had cancelled the tender and then you revoked the cancellation. Now, my lord, with the greatest respect, I ask myself this question. What is the prejudice that he suffers? Now, your lordship is aware that, my lord, if a person has not suffered prejudice, he has no cause of action to approach the writ court. Well, the Supreme Court has said that, High Court has said that, every court. Now, the question is, what is the prejudice? He accepts the fact that he is L2.
Yes.
Then, my lord, what is the prejudice? He only wants what? He wants that the whole thing should be retendered so that he may revise his bid and, my lord, make an attempt to become L1 this time. So, my lord, there is presently no prejudice because he has participated, put in his technical bid, put in his financial bid, found to be, my lord, not the L1 bidder. The second is, my lord, kindly see, did he ask back for his earnest money?
He wanted
Once the tender cancelled,
he want the work order, not the.
yes, now my lord, that's why when he says the tender is cancelled, did he say you have cancelled the tender, give me back my earnest money? Not once. Because, my lord, he was taking a chance.
Tell them you have to contact, tell them they are with you from day one.
Yes.
Now, my lord, in the proceedings of, my lord, the second, my lord, part of this, my lord, tendering process, the High Court order is followed in its entirety. Clause 34 waived, no challenge brought. We said very well. My lord, why 15 years, my lord, timeline? Because, my lord, a newer equipment will dredge more efficiently. My learned friend challenges it, the department accepts it. They said very well. You go ahead with, my lord, more than 15 years. We don't mind. But, my lord, after that, my lord, the question is, my lord, once you participate and, my lord, you don't back for your earnest money, the question is, what is the now, my lord, malafide or arbitrariness? Now, my lord, my learned friend has relied on a judgment of the Supreme Court. Please see, my lord, the facts which compel the court to, my lord, make that observation. This is the 2024 SCC online judgment.
Yes.
Just one paragraph. Please come to paragraph 8. Well, these are the facts which compel this observation from the court.
Yes.
We are at a loss to understand as to how the said petition filed by the respondent number 2 could have been disposed of by the division bench by merely recording and accepting the statements of the learned counsel for the respondent numbers 1 and 2 when the tender in respect of NIT dated such and such was cancelled by the respondents on account of gross irregularities and illegalities in the tender process found by the independent committee constituted by the High Court. We are at a loss to understand how the executive engineer could have made statements before the division bench that the competent authority of the respondent number 1 wanted to withdraw the cancellation of the initial tendering process order, and the respondent number 1 had no objection to go ahead with the initial tendering process. Now, it is in the context of a finding reached by court that the entire tendering process was irregular, it was illegal, it was malafide, it was motivated. That the court made this observation. What is the parallel in this case? Well, in this case, the only question that was raised was clause 34. Clause 34 done away with. My learned friend accepts that the tender is otherwise valid, participates it. He, does not raise the 21-day contention because he is put in his tender. He, raises the contention of cancellation without even asking back for his earnest money. He waits to see as to what is the outcome of the tender. Well, on 14th, there is revocation. Revocation of the cancellation. On the 14th, he knows about it. He does not approach the authorities. On the 16th, ultimately, the evaluation is done. On the 17th, the work order LOA is issued. On the 18th, the LOA is uploaded. He now makes a comment that kindly see how irregular it is. LOA is uploaded on 18th, but issued on 17th. With the greatest respect, issued on 17th, uploaded on 18th. What is the malafide in this? And ultimately, at the end of the day, the question is, he has no prejudice because he has been allowed to participate. He has participated. He has not become successful. He cannot now stop. Now, the last thing is, here your lordship has seen the timelines, the urgency. Entire dredging process will have to be completed by the 31st of December.
That Mr. AG has.
Yes. Now, today, in view of the timelines, today, if the entire retendering process is done, the public interest will suffer. I have deployed, I've started working, and he has remedied damages. If at all he is successful in proving that there's malafide, there's no malafide. The law of estoppel applies, the law of approbate. You can blow hot and hotter, but you can't blow hot and cold. You say very well, allow me to participate, consider my financial bid, technical bid. You are allowed to do so. Now you can't back and make a complaint about that. These are my submissions. With the greatest respect, at this point, ultimately putting the entire process on hold will be tremendously prejudicial to both to me and to the general public.
Lord, I will very short deal with the argument, Lord, one by one. But I'll start with Mr. Saha's submission, Lord, since he has finished last. Lord, the Saha, Lord, said. That, Lord, cancellation was revived on 14th. Lord, the Advocate General, Lord, I was out of the court for a few minutes. May I ask one question to myself, Lord, kindly allow me to do this. But my junior says the Advocate General has not produced before your lordship any order or decision of revival of the tender.
No, he has produced and not given the copy.
No. No, the decision to revive the tender.
Acha, decision to revive that.
Mr. Saha says on 14th, the tender was revived.
My lord, I have the document, I can hand up to you.
Obviously, he would have it. State doesn't have, he has. That shows the nexus. He would have it. I know that. Yes, yes. I know that.
It's uploaded.
It is uploaded, my lord.
Let them show it. May I have a copy?
He has handed over.
So, my lord, today the situation is that ki bolche. Mr. Saha says that he has started the work. He has executed the contract. My lord will take the supplementary affidavit that I have handed over to your lordships. Supplementary Lord,
yes.
Take page 11 once. Lord, today, if I am being able to show your lordships that arbitrariness was there, whatever he has done, that will not have any effect on the matter. That is the law laid down by the Supreme Court. Kindly see the LOA, 17th of October it is issued, Lord. Kindly allow me to place the first paragraph only. You offered rate in the above mentioned online tender has been accepted. Lord, I did not place it deliberately because I knew this sort of submission will be made. Chief Engineer so and so, wide order dated 17th October. Below them, the current schedule of rates for whole of the work, you are requested to execute formal tender in quadruplicate in this office within 15 days from the date of issue. I am told they will correct me again that the contract was executed on 2nd of November. They will correct me if I am wrong. 2nd November, the contract.
21st of October.
22nd October it was executed.
22nd October. Baba. You have a copy? 22nd October. So, if
2nd October, they started the inspection was carried on 17, 18 work.
18th work has started.
Work is started.
Formal.
So, the judgment to 2024 judgment I have given your lordships that says that LOA would not create any right. Within 15 days, the contract has to be executed. On 24th, if my lord, since they have said 24th, my lord will kindly take note one page of the supplementary, page 7. Just have a look at page 7. Color print down again. Just set a color no niche. Tomar kaj to. Huh? 22nd October was a holiday. Kindly have a look at it, Lord, in the calendar.
What was the holiday? Where is it?
Lord, on the right hand side, kindly see these small letters. I'll just highlight it. Highlighter, একটা highlighter হবে? Highlighter.
Yes, it is here.
The marker. Lord, on the right hand side, kindly see Durga Puja, then Kali Abadin Navake. October 21, 22, additional days for Kali Puja. Then Joseph just mark this portion. The declared holidays. These are declared holidays on the government of West Bengal.
My lord, kindly I am
Lord,
adding one thing.
You should not disturb me like
This
this.
is relevant for this.
Lord, I don't think that we are in a personal fight, my lord. He will wait for his turn.
In the year 2023, when he is this,
Lord, I cannot argue
that
like
time also in the holidays, this work have been done.
But
I
believe, Lord, the Advocate General has submitted, Lord.
No,
And my
they
learned
not
friend,
raised
Lord.
this question that time.
Lord, I will wait, Lord. Let them finish. Lord, this exuberance shows what is the urgency in the matter. Please, Dada, personal to kichu nahi. Please keep yourself cool. Eto thamo. Please thamo. Mamata korte dao.
Yes.
So 22nd was a holiday. So the Advocate General has, my lord, submitted before your lordships that, my lord, that after cancellation it was communicated whether the state has a power to reopen the cancelled tender, which is my fundamental point that has not been addressed. Not even one line on this. Number one. Number two. Yes, I'm sorry. The London Advocate General has said that what happened after cancellation, he has informed your lordships. What is the source of power to reopen the cancelled tender? No submission made. Second, after evaluating on 13th and cancelling, why a second evaluation was made? No submission made. Then he says that I did not ask for a clarification after 24 hours of the publication of the technical bit. I said that it was cancelled. There was no point that you could reopen. Then, my lord, reason of cancellation, nothing has been said. He said that urgency of the work, that this is such a work, government need not adhere to any time limit, any point. It has been said that on the earlier occasion, I have shown your lordships that Justice Rai held that 21 days argument of the Advocate General, the second call, it is not necessary, did not appeal the court. So no argument has been made on this. Mr. Saha says that 21 days to submit the bid. I submitted, that's the end of the matter. What is the public interest? Advocate General says that.
But you are not in the public. You.
It's an adversarial litigation. It's an
application on your cause.
It's an adversarial litigation.
Admittedly, you have participated in the tender. First, you went to the High Court, the writ court.
To participate only.
To participate, court has debarred the authority, invoked
and allowed me to participate.
Clause 34. So they are not invoked clause 34.
Allowed me to participate. So once I participate.
If you're telling that is a public interest, then how?
No, I am not in, sir. The Advocate General says there is no overwhelming public interest involved in the matter.
No, overwhelming public interest with regard to the work which is to be executed. The Mr.
Lord, kindly come to.
AC has make a submission because this is urgent work.
Lord,
just have a look at. Or is to be started from 7th of January. If any stay is passed, then the total public will be public interest will be hampered.
Lord, kindly come to para 155, page 155 of the writ petition once.
155
of the writ petition, volume 2. Para 26. Today a submission has been made that there is no overwhelming public interest which required your lordships to interfere.
Yes.
That's the submission that was made before the earlier round. Kindly see what is the observation, not challenged. In the case at hand, this court has reached a prima facie satisfaction. There is indeed involvement of public interest, and that the hasty conduct of the tender process, seen in the light of the insertion of the tender condition as regards the age of the CDS, and wholly unreasonable, since there is no apparent basis of such so acting reasonably. The other ground.
That is with regard to hasty conduct of the tender process.
Hasty conduct. So I have. So my second round of submission before the lordship was that hot haste is mala fide. Today, tomorrow, overnight, in the morning, 6 a.m. On the holiday, you execute a contract. On 18th in the morning, you reopen. No submission has been made. It has been said that this is a work for which they cannot wait. So since they cannot wait, they will pick and choose. They will select somebody and they will execute the tender. Lord, which cannot be accepted. The learned Advocate General has relied on 3 judgments. Kindly have a look at those judgments. Lord, first he has relied on Jagadish Mondal, then he has relied on Silpi construction. Of course.
Yes.
So he has relied on Jagadish Mondal, para 22.
Yes.
When your lordship should exercise your lordship's power of judicial review. Lord, this was followed in AFCONS. Kindly have a look at AFCONS.
Again, reply.
No. In just one paragraph, this was followed. What is the parameters on which? Lord, on law, not on fact. That your writ court can interfere in a tender matter. Just have a look at it. Paragraph 12 and 13. Lord, I have to show only 3 things.
Yes.
Arbitrariness, malafide, and perversity.
Yes.
In Dwarkada's Marfatia, San versus Port of Bombay, it was held that the constitutional courts are concerned with the decision-making process. Your Lordship is concerned with the decision-making process. Tata Cellular versus the Union of India went a step further and held that the decision, if challenged, the decision having been arrived at a through a valid process, the Constitutional Court can interfere if the decision is perverse. However, the Constitutional Courts are expected to exercise restraint in interfering with the administrative decision and ought not to substitute its view that the administrative authority, this was confirmed in Jagadish Mandal, what is led by Advocate General. Then 13. In other words, a mere disagreement with the decision-making process or the decision of the administrative authority is no reason for the Constitutional Court to interfere. Now, kindly mark the next sentence. The threshold of malafide, intention to favor someone, or arbitrariness, irrationality, or perversity must be met out before the Constitutional Court interferes with the decision-making process. Malafide, intention to favor someone. Justice Rai has very categorical in his observation that the state was trying to favor someone. No observation, not challenge. State cannot come today and say, I have not done any malafide. The process by which they proceeded shows arbitrariness, exuberance, overnight urgency. You knew that Gangasagar Mela is not something like this. Mela depends on the coming up of the moon like Eid. We know it will take part in the first week of January. Okay. This should have started earlier. So this is one. Then the Advocate General has relied on NG projects. So Baba Bhola. But kindly take NG projects once. Just have a look at.
Yes.
Not kindly take paragraph 5 of this judgment. But I tell you, Lordship, this matter was from Jharkhand High Court. So, Justice Hemant Gupta has delivered this judgment. Then Justice Hemant Gupta only rely on another judgment of Justice Hemant Gupta, but considering this past interim order. So this is not the end of the road, what is being shown by the Advocate General. Kindly have a look at the para 5. What was the fact there? Kindly have a look at. The technical bit of the appellant was declared to be substantially responsive, and after due evaluation of his financial bit, work contract was issued on 3rd October. Kindly mark this date. The appellant started work on the stipulated date of commencement on 22nd October. The completed earthwork of 21.9 out of 24 kilometer of the proposed. Tender was for 24 kilometer road construction. They completed 21.9 kilometers. Then, as per the appellant, it had completed the work approximately 8.5 crore and had mobilized the plant and machinery. Respondent number 1 filed a writ petition on 11th October 2019 for quashing of the decision of Technical Evaluation Committee, its bid to be non-responsive. The state count then para 8, after pleadings were completed, learned single bench of the High Court passed a common order in respect of two other work in question on 14th January 2020, setting aside the hour of contract. So the fact of that case was the appellant before the Supreme Court executed 90% of the contract. Then the writ court interfered. So Supreme Court deprecated, says that you go and pray for damage. Kindly have a look at Baba Bholenath, which is not an unreported judgment of the Supreme Court considering this by the same bench. This is also by Justice Hemant Gupta, my lord, same bench. So NG project cannot be said, the showing NG project, you cannot say that I have to go and pay for damages and you can do whatever you want.
Yes.
Kindly have a look at the 3rd paragraph. The challenge in the present appeal is an order dated so and so passed by the High Court of Judicature Bombay, whereby the writ petition filed by the appellant was dismissed, relying upon the order of NG projects, which the Advocate General has relied on. But first page, 3rd paragraph. My lord has got that?
Yes.
Then, kindly turn over. NG project was considered. Kindly come to internal page 3. We have heard the learned counsel for the appellant. We find that the High Court has totally misled the judgment of this court. Respondent number 4 was declared eligible in a flagrant violation of principles of natural justice and all former fairness in the process of determining the eligibility of the tender. The bid of the respondent number 4 was accepted when at the time of opening of technical bid, the said respondent was disqualified. Therefore, the manner in which the bid has been accepted shows arbitrariness. Consequently, the order passed by the High Court is set aside. So, NG project never says that even if it is arbitrary, I have to go and pay for damage. Now, my lord, kindly appreciate only one thing. And only one thing, the learned advocate general has relied on this notification. I take this 7 June 2022. Lord, I don't know why he has relied on this. Kindly come to page 44. Roman 2. Situation where number of qualified bidders is less than 3, then B in case of second call. Others kindly got that?
Yes.
Then kindly see I tender valued up to 5 lakhs, II tender valued up to 10 crore, III tender valued up to 5 crore. The notification that I have relied on in page 160 of the writ petition, which says that you have to take finance approval before proceeding. Here it is said up to which stage you can approve. Then kindly come to page 46, para 4, for acceptance of tender beyond this limit. So anything above 10 crore. Herein above proposal shall have to be referred to the finance department with the rate analysis, comments of DTC and the specific recommendation of the finance assistant, head of the department, annexure 1. So it is the same reiteration of the earlier recommendation. Now I am told that they have said that they have not got a finance recommendation. Kindly have a look at that once. I don't know whether it is handed over to your lordships or not. Document.
Yeah, they have given.
They have given. Kindly have a look at that. Mentioned as document P. প্রিন্ট পেলে খুব ভালো হতো। The timeline shows they had even less than 2-3 hours every day. 16th 8:30 the financial bid was evaluated. 17th LOA issued. 8th 6 AM uploaded. Now this is of 17th. Kindly see, we may opine that admin department may take the suitable decision regarding the acceptance of tender regarding the work of dredging before Murigonga river in connection with the dredging in river Murigonga so and based on the recommendation of the departmental tender committee TIA and the annexure 1 in terms of finance department. There has never been any discussion anywhere as to after cancellation how can there be a recommendation. Lord kindly appreciates the state cannot go beyond the law. Your lordship's court, my lord, in 1936 in Moniruddin Bapari has laid down the law. A statutory authority cannot act beyond the statute. I can do, my lord, what is not prohibited. He can do only what is permitted. Has any notification, law, finance rule been shown that a cancelled tender can be reopened? The submission has been made that in the Supreme Court judgment, since the High Court has passed an order, so here there is no order, we can anytime reopen. If that anarchy is allowed to be continued, if that is not an arbitrariness, if that is not an irrationality, then I put this question to myself, what is? But in this sort of a situation, I beseech your lordship to interfere and not much work has been done.
Let the same be left to
My
the
lord,
court.
as I leave it to your lordship, not much work has been done. And just by saying that work order has been issued, I have done work, but they cannot come out of this cartel that they have formed. But these are my submissions, my lord. I am extremely grateful to your lordships.
Thank you. Counsel for the parties have concluded their argument. Come to my office. I will give dictation in the evening. You will
But
give the order.
I am extremely grateful to your lordship, not for this patient. And you have taken the entire morning, my lord. I'm sorry.
That's why I am not dictating.
No.
Otherwise, again.
Our job is over now.
Hearing concluded, लिखा है ना? Counsel for the parties have concluded their argument with regard to the interim order. ठीक है ना? Fix for orders. अगर आज होगा तो आज दे देंगे नहीं तो कल. Yes. Item number
2. So this, I'll try and keep it short because the issue is also very short.
I'm for the respondent. Before my learned friend starts the matter, one supplementary affidavit has been served. And there is a question of infringement of the interim order. First of all, may I make it very, may I submit that and make it clear before your lordship. But this matter was assigned to me, my lord was pleased to direct me to take instruction when my learned friend was present. And that context, my lord was pleased to observe that no finality should be given till the next date of hearing, and followed by the date which was on 22nd of September. I could not be present because my son was unwell. So, my lord, for that the same thing was extra. So, in my humble submission, that, my lord, cannot be considered to be an interim order per se, my lord. This is just an observation, and since it was not heard on merit, my lord.
May I just,
Since it has been served.
After the order dated 22nd September,
My lord.
have you issued the work order?
No, my
so
lord,
what
no,
they've
no,
done is
no.
slightly, which is what I
And
have
there is
come
a
up with
maintainability
a
point also involved, my lord.
supplementary affidavit with today. Well, what happens is, I'll give a brief conspectus as to what the writ petition is about. But there is a line that is interlinkage of a railway line that's connecting part of Bangladesh to part of India. IRCON is the tendering party in Bangladesh. I become the subcontractor of IRCON where I'm doing the linkage. Now that's the Bangladesh part of it. When the linkage happens in part of Bengal, a tender is floated. I participate in the tender. That tender is issued solely to me because I am the one who has the drawings, and this is stated to be proprietary drawings of mine because this is unique to my business and unique to this project. First, they issue a normal tender. When I write to them that you can't issue a normal tender, you're using my drawing, they cancel it, issue a tender in my favor, saying it's a single packet tender. It's a proprietary drawing, and therefore you're going to discharge this particular tender. That tender is somehow stated to have lapsed. Then they try to return my earnest money deposit. That's chapter 1. Then they issue another tender where they use my drawings, which written, the name of the petitioner is there. These drawings, which are proprietary concerns of the petitioner, had been used for another tender using the same product, same drawings, and has been floated. I come up before this honorable court saying, you can't do this because this is my drawing. My entire business is going to go. And the drawings mention that this is the drawing of the petitioner.
So the infringement.
No, not here. It's just a slide. I'm not even on the intellectual property issue. But this is something beyond, similar to what Mr. Chakraborty was arguing. This is something beyond that because its admitted position is that. So when we move the matter, they say we're going to come and take instructions. The instructions are given. Then the matter is, and no work order shall be issued. That's the understanding based on which the court proceeds. When the matter is called, then on 22nd of September 2025, there is an injunction because courts are going to shut on 24th. There is an injunction because for whatever reason, the instructions don't come. There's an injunction restricting them from issuing a work order in respect of this tender. What they do now, which is my supplementary affidavit, to circumvent the interim order, they use the same drawings again, same item, same drawing, float another tender. Just to avoid the injunction that has been passed by this one.
What happened to the earlier tender?
It's pending. That earlier tender, they say nothing. Which is what I have come up before a supplementary.
That tender is neither cancelled nor revoked. But
Nothing.
And the same tender has
same product, same drawing, identical to what is there in the first tender, just to obviate the interim order. And probably they had not seen the prayers. My prayers are that you can't use my drawings for anything at all because of my drawings admitted position. They now float another tender which I have essayed. It is this it is this frown on your lordship's face is what I actually invoked to the supplementary affidavit. Because this is not, yes, Manoj. Now this is not just a matter. This is not about the petitioner anymore. This is a deliberate attempt to circumvent a court order. Whether there is an injunction or not, a railway, I have nothing against my friend here. Railways ought to have come up before this honorable court and sought a modification if required, or a vacating of that order. Please have a look at this new application, at the supplementary affidavit that we filed.
Where is a new tender?
Yes, Manoj. Please have a look at the supplementary affidavit.
Yes,
Page
sir.
10, please see.
Page 10.
Page 10. Manoj, if I may just beseech your lordship to undertake one slightly tedious exercise, Manoj. If your lordship looks at volume 2 of my present writ petition and opens page 273. Second volume, page 273. I'll just highlight the exact tender that has been now floated. 273 is the offending tender in the writ petition based on which the interim order has been passed. Now, please have a look at page number 10 of the supplementary affidavit, closing date of 3rd of November 2025. Please see tendering section 61, compares it with 273, 61. Tender title, turnout 1 in 12 sleeper dual gauge, turnout 1 in 12 sleeper dual gauge. Tender type, open, indigenous, bidding system, single packet. Your Lordship will find the consignee is the same, senior Denmark NFR 15. Immediately above that, description, turnout 1 in 12 sleeper dual, turnout 1 in 12 sleeper dual. Now, the other more embarrassing bit of it. Lord, please have a look at page 15 of this of my supplementary affidavit.
Yes.
And compares it with page 278 of the volume 2 of the writ petition. Page 15 at the bottom, please see, my lord, documents attached with tender. Your Lordship will find there are drawings at page 16. Sleeper drawing, again serial number 8 and 9, sleeper drawings 2, 3, and serial number 12, again drawings. I'll show these drawings, my lord. This, Your Lordship will compare with page 278 of the writ petition, document attached, drawings.
No, page number 15.
Yes, ma'am.
Which clause you are referring to?
Serial number 7 at the bottom, drawings attached with tender.
Page number 15.
1.5 of the supplementary affidavit.
Clause 7.
Clause 7,
Document attached.
Yes, documents attached with tender.
Correct.
Kindly turns over to 16. Serial number 12 at page 16, Your Lordship will find drawings 2.pdf. 2.pdf.
12.
Please compare this with page 278 of the writ petition. This is the offending tender where there's an interim order.
Yes.
Documents attached with tender, serial number 6. Serial number 1 of that, drawings underscore 2.pdf. Now, same drawings again. Now, the drawings I'll show. Please have a look at page 158.
Drawing 2 underscore 2.
2.pdf.
Yeah.
Again, drawings underscore 2.pdf.
No. Acha. Item number?
Item number 1 at page 278.
Item number 1.
Yes, is equal to item number 12 at page 16.
Yes.
Now, please look at.
Yes.
Please have a look at page 160 of my supplementary affidavit. Now, there are all the plans have one. So, for the sake of brevity, I'll just keep it to one plan, my lord, so I don't waste your lordship's time.
160.
160 of the supplementary affidavit. All the drawings have been disclosed, but I'll just show one because they're same.
Yes.
This, my lord, please have a look at right at the bottom. Your lordship will find the name of the petitioner at the right hand bottom. Drawing number Rahi. That's the petitioner number.
Yes.
That's right, you know.
Rahi drawing number or TTPC.
Yes. All these. Please turn over, my lord. 161. All these drawings, your lordship will find have a specific number ascribed to each drawing. And all of them bear the name of the petitioner because this is unique to me. I have prepared these drawings.
Yes.
Now, these numbers, if your lordship corroborates, all appear from page 158 of the supplementary.
(158)
158 of the supplementary. Your lordship will find each of these drawings have again a certain number which is ascribed to it. Drawing number, right hand column. All these drawing numbers, we have painstakingly checked them. All these are the drawing numbers which appear from page 160 onwards. Same drawings. Now, if your lordship please has a look at page 28.
So 158 and 159
is drawings of 160
to 16 whatever it
to 171.
Correct.
Now 158, please, I'm sorry, my lord, this exercise is slightly tedious.
Yes.
Please have a look at page 280, volume 2 of my writ petition. And compares once, my lord, page 158 of the supplementary affidavit with it.
280.
280. It is same drawings. So one tender, 280 read with page 158. Same chart your lordship will find. What is stated as annexure B is again stated in annexure B.
Yes.
So what they do is first tender when they float, they issue my drawings and float the tender. Well, these railways, and I'll say this very consciously, they have a certain number of people that they like. And for some reason, they dislike me. But no one else can do this without my drawing, because I am the one who was instrumental in the main linkage. So when you join it, you will need my drawings to know how it is to be joined, which is why the first tender, if I may just show that one page, your lordship will just from the writ petition see one document, which is specifically given to me, my first tender.
How many cases you are having against the railway, Rahi?
Please have a look at volume 1, Milon, of the writ petition. Okay, volume 1 ta
Yes.
Thank you. Writ petition volume 1. Please have a look at page 86 once.
Yes.
86 is the first tender in 2024 that is given to me.
Yes.
Here, tender type, as opposed to what I've shown a single bidder system. Here, please see tender type PAC.
Where?
Proprietary article, sorry, Milon.
Where
Page
you got
86, right hand column top, tender type.
Building type, contract type, tender now.
Yeah, tender type. PAC indigenous. Proprietary article certificate indigenous. This is solely for me. That your lordship will find.
Tender type. In 86.
Tender type. 86 of the writ petition.
86 of the writ
But
petition.
there's a template, then there's a contract category, right hand column, top, Milon. Top right hand. There is a template. Then there is contract category, tender type. Grateful, Milon. Your lordship will find PAC indigenous.
Correct.
Proprietary article certificate. Same page at the bottom. Please have a look at serial number 2 as eligibility conditions, special eligibility criteria. This is a PAC item of the petitioner. So and so, West Bengal, so and so.
Yes.
Proprietary article certificate. This was issued only to me. Once they issue it to me, I give them all the drawings based on which I am to discharge the tender. When they get my drawings, they exclude this particular product and they float another tender which is assailed in this writ petition using my drawings. All the drawings. Your lordship will not rely on me. While your lordship is there, please have a look at page 282 once of the writ petition, volume 2. ওখানে পরিষ্কার লেখা ছিল দিস ইজ দ্য ড্রয়িং এটা একদম লাস্টে আছে তাহলে সেকেন্ড ওটা দেখাবো একবার page 282 kindly see.
Yes.
At the right hand corner your lordship will find the name of the petitioner, so and so, and these drawing numbers are there. So when they give me the tender, I give the drawings. Then they stop that. They float another tender using my drawings to give it to their favored candidate, excluding the product which I make. So they use the drawings, figure out the know-how, how it is to be made. They specifically mentioned in these drawings, and I'll show that this is a PAC item of the petitioner. I come and show this to this honorable court. Good, bad, whatever, my lord, there is an injunction. My lord, if my junior is right, if your lordship looks at 321 once, it's a slightly better copy. Volume 3, part of their tender, 321. All the drawings are there. This is slightly more legible. So, yes. At the right, yes, very good, Shonok. Thank you. Right hand bottom, kindly see. Manufacturer, Rahi, petitioner's name. This drawing, please mark this. This is the cornerstone of my case. This drawing is the property of Rahi Track Technologies Limited, so and so Jabalpur, and shall not be used, copied, and reproduced in any part or whole without prior consent in writing. This is my writ petition. This is my writ petition. This drawing gets the approval of RDSO.
And also this field which
And please have a look at that same thing, checked and found in order, checked and found okay by the railway submit.
Yes.
Now they issue this tender, which is a in the writ petition using my drawing. What they do is once my drawings are uploaded, I'm finished. So I will never be a competitor for anybody because I make this. This is my business. And what they do, because they have this drawing, your lordship at 321, if your lordship is there, please see that there are certain things marked in blue. The entire thing is how the sleeper dual, this particular gauge, is the lock system is going to work. Because I am the one who made it in Bangladesh, I am the one who does it here. That is getting joined. They exclude this product. So with regard to that, I will beseech your lordship to direct the respondent to file at least a report to indicate if they are using my drawings, why haven't they included my product in the tender? And as of today, Lord, considering there was already an injunction in respect of the first, and this one is completely to overreach the court, identical drawing, identical tender, same consignee, same product, same section. Lord, let them be restrained from taking any steps on the basis of these drawings at least. But my object is not to stop the tender. My object is not to allow them to use my tender, my drawing. And if they use my drawing, then they must allow me to participate.
Correct.
You can't form a cartel, use my substratum of my business, throw me out to give it to somebody you like. I can't even participate in these tenders anymore.
Okay.
Well, for today, these are my submissions.
Yes.
Well, one more aspect. আর কিছু দেখার দরকার নেই। Well, what had happened was initially when the tender was floated, it was for me what I showed to your lordship. It was for heat-treated welded crossing. Then they take the drawings. Then they do away with this product type. Now they float something else. The new tender, your lordship will find use my drawings, but it's actually for a different product. So for that, let the railways come and explain how they can use my drawings and keep me out of it. And for now, let them not proceed on the basis of the second tender, my lord, where they were injuncted in the first. My lord, these are my respectful submissions for today.
My lord.
Yes, sir.
First of all, my lord, may I answer to the, my lord, the violation of the order, my lord. May I place the order first, my lord? The first order, my lord. First order. The first order. Or, my lord, the 22nd September order, it is just an extension of that, my lord. On the first occasion, my lord directed me to take the instruction because no one was appearing on behalf of the authorities, my lord.
No, first direction kindly come to 12th August.
12th
August. Work order has not been issued till date.
It is expected that no work order will be issued. Till date, no work order has been issued.
Then
that is number one. It's on the
September.
fact, my lord, may I first place. Thereafter, my lord, the 22nd of September, when I could not present, my lord, it has been submitted that the work order has not been issued in favor of any party till date. It is expected the work order will not be issued. Nothing has been heard on merit, my lord, till that date, my lord. Till today.
Now, what about this?
This case has
supplementary affidavit with the
supplementary affidavit has been served on me on this last Friday. Last
Yes, so how you tender, how you publish the same tender?
My lord, may I come? May I first of all come? This is my lord. May I first place, my lord? There is a maintainability point. My lord, all the respondents first, my lord, takes the cost title of the, my lord, of the writ petition. This project is relating to Indo-Bangladesh project, my lord. So, my lord, lordship kindly sees the concerned railways all are outside, my lord. Whereas Guwahati, it's all in Assam, and the RDSO, the approving authority, it is approves the design only. That's all, my lord. So, my lord, all are outside, my lord. I'll place the judgments that this writ petition, it cannot be maintainable here. Not a single fraction of a cause of action arises here.
Where the tender was issued?
My lord, Assam project is outside. Everything has been outside. The only pleading has been made in the writ petition is, my lord, paragraph it is they have the petition number 2, my lord, petition number 1 is a reputed manufacturer designer so and so. They have received the notices within. That's the only cause of action they have to assail this writ petition before this Honorable High Court, my lord. That is number 1. Number 2, my lord, kindly takes, my lord, may I place paragraph number 9 onwards. Well, I'll not take much time of your lordship, my lord. Kindly takes, my lord, paragraph 9. Yes, writ petition, my lord. It talks about the respondent authorities thereafter in connection with the same work floated a notice inviting tender dated 17th of October 2024. The first open tender notice. My learned friend just submitted that the 26th November 24 is the first tender, which is not the fact. It is from the pleading, it will appear. However, this 17th October is not annexed to the writ petition. The notice inviting tender was described as an open tender, although the same included the drawings, which are proprietary articles, certificates of the petition number 1. The designs being unique to the petitioner so and so had immediately approached the respondent authorities, calling upon them to forthwith withdraw the said tender as it was available to the public at large, disclosing the unique drawings so and so. Realizing its mistake, I don't know from where they have come to this conclusion. Respondent number 3 immediately on 17th October 2024 itself withdrew the said tender. It is not annexed to the writ petition, and thereafter published a notice inviting tender dated 26 November 2024, which is annexed, which was restricted only to the petition number 1, which has been placed, my lord.
That's the one I showed.
Now, my lord, kindly see page 86, my lord. This was only with regard to the petitioner only. That's why this proprietary thing was mentioned. And now, my lord, before that, my lord, kindly see the description of it. Procurement of dual gauge 1 in 12 so and so, well, the specification given for laying with thick way curved, this is what is written, switches and heat treated welded crossing, including.
Where from your reading?
My lord, page 86.
86.
Description, item number 2, item details, my lord.
Item number 2, item details.
Item details 1, description 1, my lord.
Yes.
Has your lordship got it, my lord?
Yes. Procurement of
His drawing is relating to, my lord, kindly mark it, my lord, heat treated welded crossing. That's his specification. That's the specification of the writ petitioner.
Yes.
Thereafter, all the tenders, thereafter, my lord, kindly see.
Will you file the
Paragraph,
affidavit?
my lord, this writ petition is not maintainable at all. 1, my lord, they have not participated in a single tender thereafter floated, not the recent one, not in the 9th, the tenders which are under challenge floated in April 2025 and May 2025. They have not participated, so they have no locus to challenge this. I have judgments to show on that aspect. Neither his specification, his design, which is a disputed question of fact, my lord, in humble submission, read court cannot go into. In the Commercial Code Act 21C, clause 17, specifically says if it is a proprietary design, it's a design and intellectual property related to that, my lord, it has to be for the commercial code. If any dispute, it is his design, it is the design of the petitioner company, it has to be challenged before the commercial code. Not my lord, the writ court cannot go into that dispute that it has been used, not used, or whether its specification at all can be used. My lord, may I?
How by way of a subsequent tender you use the drawing of the writ petitioner?
My lord, that is the respond number 6 approves. Respond number
respond number 6 approves his design. If he's not participated, you can allow the other party.
Lordship,
This is the design of the other party.
For,
You use
for that, my lord, kindly takes, my lord, page 85, just the page before, my lord. Page 85. Their document, my lord.
Page 80?
85, my lord.
85.
Annexure P2, my lord.
Yes.
Respond number 6. This is the approving authority, my lord. This have approved this document.
What approved?
The design. There is no system, my lord, from the middle of the portion, from the first paragraph, it is stated there is no system of approval of non-standard design by RDSO. However, the following layout drawings developed by Mrs. Rahi were examined by RDSO on the request of NFR. Well, the NFR is the railway authority. They have requested for approval. That has been approved. This has happened in the month of 2024, May.
Correct.
And accordingly, this was floated. And thereafter, not in a single tender, Lordship, now my lord, cannot take.
No.
My lord.
What is the process? If he has submitted the drawing, it has been approved, then what would be the process? His drawing is to be used to the another tender by allowing the other party to execute the work.
Even for seeking such, in humble understanding, even for seeking such injunction,
Tell this, no, seeking injunction.
one has to have that locus, my lord, in order to challenge that.
Either you give the answer to the court.
My lord. Lordship.
The court is asking one question because 2 days this court has passed an interim order. Correct. Now petitioner has filed a supplementary affidavit disclosing another tender. Now you are telling that this, and as per the case of the petitioner is having a approved drawing which you are using. How you can use? Give the answer to that. Can you use that?
My lord, that is my case, my lord. If on the merit, my lord, third tender and fourth tender which have been floated, my lord, it does not specify the description of the specification which has been used. Lordship, kindly takes, my lord.
Supplementary affidavit.
My lord, for
Kindly come to supplementary affidavit, page 10B.
My lord. 13th about. Lordship, kindly sees, my lord. Page 10, my lord.
10B, yes, 10.
It doesn't talk about, my lord, this heat weld.
Huh?
It doesn't talk about heat weld, my lord.
Heat weld, but drawing. You miss word you will say. Where is the drawing of this tender? Show me the drawing of this tender. It is not matching with the drawing of the petitioner. I am dismissing herein now.
No, my lord.
Sending the petitioner back to the home.
Now, whether
show me this tender is not connected with the drawing of the petitioner. That's all.
My lord, for that, my lord, I have an answer, my lord. Kindly takes, my lord, page 86. 86, my lord, as I have just, my lord, placed, my lord, and page, my lord, 319, my lord. 319, does it?
319.
319, my lord.
Yes. You do one thing. You have taken note of the pages of the petitioner given to you. You have taken note of.
Yes, my lord.
Come tomorrow with the proper instruction.
Lordship.
Whether your authorities are using the drawing of the petitioner in this tender dated 3rd November 2025. That's all.
My lord, my lord. my lord,
Because
complete.
prior to that, there is an
I
order.
will. Well,
This court,
before I'll come to that.
I will hear you. I will hear you on merit with regard to the maintainability. Now there is a short of timing, and petitioner has already argued. He has pointed out what are the pages he has relied upon. Main grievance with regard to the supplementary affidavit of page 10, the new tender. You come tomorrow, only the specific this tender. In this tender, you are not relying upon the drawing of the petitioner.
Very well, my lord. My lord, only thing, if I may submit today only, page 319, my lord, once, my lord. Each tender has its specific clauses, my lord. Lordship kindly takes the special conditions.
Correct. I am not telling, sir.
Only, my lord, my lord, for my sake, my lord.
Sure.
Conditions of the contract, my lord. The vendor has to design and develop the dual gauge, my lord.
Huh?
Whoever will be awarded, well, it has to design and develop the dual.
That's what I'm telling
So
you.
it's not the.
That's why I am telling you come with a specific written instruction that this drawing which the petitioner is relying upon.
Whether we can,
will not rely.
whether we can use this.
No, not can. Whether
You will not rely.
Well, it
You will not rely that because now you are
has
telling that the 390 the contractor has to use this own drawing.
Absolutely.
So let you say that this tender which you floated on third number 20 is no way connected with the drawing of the petitioner and your authority will not use. That's all. Matter ends.
Very well, my lord. But the maintainability point, my lord, may I place?
That I will kept open. That I will kept
But
open.
even if for the sake of challenge, my lord, my understanding, my lord, lordship, kindly pardon me if I'm wrong, my lord.
I will hear. I am not telling that I will decide.
Something which is being challenged before your lordship, it has no locus to place before this root code, my lord.
Both okay. On the both point, I will hear tomorrow. Come with the specific instruction in written instruction, not on verbal instruction.
In that case, my lord, kindly give me a few days time.
Then not to give any effect to this.
It has not been given. It is only the work order not issued. Only the corrigendum issued to extend the day. That's all. Even then, my lord, they have not participated, knowing that.
How will I participate?
That is their case, my lord. Supplementary affidavit, lordship kindly takes, my lord.
It's been extended till third.
Corrigendum issued, my lord.
So bid is over. They'll issue a work order.
They issue a corrigendum dated 9th October.
Closing date is 3rd November. Closing date is 3rd November.
My lord, their supplementary page paragraph 7.
I am recording your submission.
Lordship.
You are not going to issue any work order till the hearing of this case.
My lord, kindly fix it till the next.
When you will come? Tell me, I will fix that.
My lord, next week, my lord, Wednesday, my lord. If I can file an affidavit to that extent, my lord. Meanwhile.
Then if you file the affidavit,
I'll keep the kindly keep
if you file the affidavit, then you will reply. How soon you will file the reply?
My lord was seeking to file.
Okay, how soon you will file the affidavit?
Well, I have to file in 2 days, my lord, since my lord is.
Correct.
Well,
how soon you will file? Tell me.
Today is Thursday.
Then give the advance copy. He will use the reply. Then I am fixing on 19th.
19th.
On 19th. As per your convenience, give the date of your convenience. No problem. The court will fix that.
Today is. But 19, my lord. My lord can keep it, my lord, on 14th itself, my lord. If my lord's times permits, my lord. Convenient.
Today we are on 6th. How soon you will file the affidavit?
Well, I mean, in the meanwhile, I'll file it.
No, the reply also, no? That's why I'm asking. Reply also, he has to get a reply if you file within 3 days.
Very well, my lord, kindly keeps it on 19 then.
19?
Well, I'll file it between 14, my lord.
Okay. The counsel for the petitioner has filed supplementary affidavit after serving the copy to the learned counsel for the respondent. Let the same be kept with the record. The counsel for the respondent faced for time to file affidavit in opposition. Let the affidavit in opposition be filed by
14th, my lord.
By 14th. Reply, if any, there to be filed by 18. By 18 you can file. 14 after serving the by 14 after serving the copy to the learned counsel for the petitioner. Reply, if any, there to be filed by 18th of November 2025 after serving the copy to the learned counsel for the respondent. List the matter on 19th November 2025 at the under the same heading at the top. Under the same heading at the top. Full stop. The learned counsel for the respondent submit that the tender document dated 3rd November 2025 is only with regard to the extension of time, and as such the respondents are not going to issue any work order. In view of the above, in view of the above, this court is of the view that the respondents will not issue any work order till the next date of hearing.
Well, kindly keep the record, the maintainability point.
The petitioner and the respondents has challenged the maintainability of the present date application. The same is kept open.
I'm so grateful. my lord.
The date will be 24th September 2025.
No, 30th November. This
Closing date is 3rd November.
tender date 24th November.
24th September
24 September. 3rd November बोला ना? 24 September.
Very great.
Deeply obliged, my lord. Well, but kindly make the interim order limited to that extent, my lord.
Next date of hearing.
Till the next date of hearing, my lord. I'm so
Next
grateful.
date of hearing.
Deeply obliged, my lord.
जो ऑर्डर के इससे पहले वाला फाइल है ना उसमें रख लेना
Appearing for the state, my lord. Appearing for the state, my lord.
I'm residing in a place, my lord. My lord, my next door neighbor, my lord, constructed a sawmill, my lord.
Constructed a
Sawmill.
sawmill.
My lord, two aspects are there. Throughout the day, even in the night, mill operating, huge sound, and the dust, my lord, everything like makes my life miserable. And my lord, my wife is a serious patient under doctor surveillance. She is not in a position to stay there. She had to stay, my lord, at her, my lord, daughter's house. Lordship, kindly see, at the very outset, I am drawing Lordship attention, page 12.
Yes.
Page 12, my lord.
What is this?
My lord, this is, I'm sorry, my lord, this is Porcha. Since it is in Bengali, translation is not made. I am not at present, my lord, relying upon this, my lord. Lordship, then, my lord, kindly turn to the photographs. And, my lord, the woods are keeping page 14. Lordship knows to run a sawmill, one has to take permission from the forest department also. Lordship knows illegal felling of the trees, T. Godavaran and other matters. Lordship, my lord, even today pending before the Honorable Supreme Court, my lord. Then, Lordship, kindly see, my lord, page 16. This is, my lord, treatment seat of Christian Medical College, Vellore. My wife and, my lord, her ailment, page 18, page 19, prescription, page 20, 21. This is going on. Now, my lord, kindly consider page 25. My letter addressed to the district engineer, Hooghly, West Bengal Pollution Control Board, subject objection to sawmill operation due to sound and dust pollution. Page 25, annexure P4.
Yes.
My lord, we wrote them. We wrote also, my lord, to the forest authority to look into the issue where from they are getting all this wood and other things.
Yes.
My lord, wood, my lord, there is specific law in our West Bengal also, my lord. In order to cut tree, my lord, more than 3, one has to take permission. And, my lord, huge woods are keeping there. And, my lord, they are operating this particular sawmill. Then, lordship, kindly see, we have communicated all. And this is page 37, my lord. They have received it. Then, my lord, kindly comes to page 38. Page 38, my lord, now it is, my lord, 163 of the BNSS, previously 144. Application, page 41, there are some order. Lordship will find second paragraph, page 41, Lordship got it? Lordship got it, page 41. Second paragraph. Her, the learned lawyer from the petitioner and considered BL and LRO Jangipura district, Hooghly so-and-so is directed to submit a report and shall keep strict vigil to the local and to restrain OP in case of any possibility of breach of peace. Moreover, my lord, the usual order they have passed. At the very outset, we have taken this initiative, my lord, by approaching, my lord, the magistrate court, but nothing happened. Things are going on. Now, my lord, lordship knows, my lord, the provision of Forest Act is applicable. My lord, without permission of the forest, they cannot cut trees. And, my lord, hips trees in front of my house. The other thing, lordship knows, my lord, consent to establish, consent to operate by the Pollution Control Board. We don't know, my lord, whether there is any such license or not. My lord, the local panchayat permission is also required. We are not in a position, my lord, whether certificate of enlistment they have done subject to, my lord, satisfaction of the other authorities. My lord, this is a question which was taken into consideration on number of occasions by this honorable court. But I intend to rely upon, my lord, one judgment. Lordship, kindly see, all are division bench judgment. But only difficulty, my lord, one copy. I'm just reading particular paragraph and hand it over to this honorable court. 2013 SCC Online Calcutta 120. 2013 SCC Online Calcutta 120. I'm just reading second paragraph. In the read proceedings, record of proceedings, dated so-and-so has been annexed. Direction was issued upon the respondent number 3914 not to run sawmill without valid forest license. This is first. Then, my lord, consent to operate from the West Bengal Pollution Control Board as per the statutory provision and the concerned act rules. The respondent number so-and-so, my lord, directed, my lord, so-and-so. So, my lord, consent to operate and consent to establish is badly needed. Lord Lordship, kindly excuse me, my lord, the second page I have used a huge page. My lord, kindly yes, my lord. Then, my lord,
Who
before
is appearing for the state?
My lord, I am appearing for the state one.
You are for
I am for the private.
You are having the license?
Yes.
What license?
My lord, we have the consent to operate from the West Bengal Pollution Control Board.
Ah.
We have the Uddam registration. We have the permission from the Forest Department. My lord, we have the electricity connection for running the sawmill by the WB ACDCL authorities. My lord, we have the permission from the local Gram Panchayat to run the sawmill.
So, my lord, in residential place,
All of this writ petition is.
Now, my lord, the Pollution Control Board, after taking into aspect all these, has issued me a certificate of
Yes,
NTC.
what is the content?
My lord, this writ petition is itself is not mental level, my lord.
And my lord, he
Since
should
his-
approach before the National Green
One
Tribunal.
person should.
Since he is alleging sound pollution, my lord, he should approach, my lord, the National Green Tribunal. Writ petition is not the proper forum to ventilate his grievances, my lord. Writ petition is not mental level. The clearance is everything is there since my learned friend is showing, and 144 was filed and that was dropped, my lord. That had validity only for 6 months, my lord.
What?
141 proceeding, that was dropped.
But if your
Okay,
lordship,
you file affidavit.
I shall file
no,
an
my
affidavit.
lord, kindly direct them, my lord, to hand over all these copies. Consent to
file
operate.
by-
That's why court is calling the affidavit. Let the
Lord, very short time, my lord. In a very short. Kindly decide this issue whether in a residential
Also,
place.
kindly record that this petition is not mental level.
Why?
There is alternative remedy and a
Have you gone through the report? Prayer.
prayer is for stopping the sawmill, but the
Yeah. So close the sawmill. Whether the green tribunal will close the sawmill.
Yes.
His case is with regard to the no license. Nothing is there. One is the aspect that his wife is facing difficulty due to that. So
no, but let by
counsel for the respondent failed to raise for time to file affidavit in opposition. Let affidavit in opposition be filed by.
But I shall file it by 2 weeks.
1 week.
1 week, my lord. Deeply obliged.
Next week, I am not available. That is the
Within 2 weeks, comma, reply if any there to be filed within
3
week
days.
thereafter.
3 days.
Within a week thereafter, list the matter on December.
My lord, at
My
the
lord,
top,
kindly give liberty to.
top, my lord. At the top, since I am suffering, my lord, not in a position to
My lord,
stay in my
kindly
house.
give liberty to state to file affidavit also, my lord.
Respondents.
Okay.
Well, at the top of the list, my lord.
It will be there only. Don't worry. It is the what is the list?
My lord, the lordship list will be huge, my lord. Days will come, my lord. 1 month. That is why, my lord, praying. This is only indulgence.
Urgent motion. Urgent motion.
Under the heading urgent motion. Deep down. Deep down.
Yes.
Oh, my lord, I am waiting for the picture.
Yes.
My lord, 47 is the record of rights.
What is your prayer?
My lord, my prayer is, my lord, respondent number 12.
Demolition of the construction of the restaurant number 11.
By filling up the pond. Nature of land is pond. I made written complaint before the authority. After filing of this writ application and after receipt of this writ application, the already concerned authority, my lord, initiative steps and direction has been given to the district magistrate to inquire and complete the proceedings. That by way of supplementary affidavit, my lord, I am annexing that. If your lordship kindly, direction may be given to the district magistrate to conclude the proceedings under 17.
Where is the proceeding you initiated? Which page?
Supplementary affidavit.
Supplementary affidavit, my lord, I
No.
just,
Proceeding you initiated. Where is the representation?
my lord, my representation page 55 and supplement.
On the basis of that only the
Yes.
authority has taken steps.
Taken steps. That is, my lord, in my supplementary affidavit.
Page 3.
Page 3.
Initially, my lord, the West Bengal High Jack attracted. My lord, assistant engineers passed an order.
Hearing for whom?
State respondent, my lord.
Where is the private respondent? Have you
Private respondent, my lord, I serve.
Where is the
Received.
affidavit? Received.
Yes.
Recorded only. So I am disposing of.
Yes, my lord. Yes, my lord.
Who is the district magistrate?
Yes, my lord.
My lord, yes, district magistrate. My lord, within a certain
The
time.
Fisheries Act, my lord.
The
District magistrate is the
petitioner
authority,
has
my lord.
filed the present application. with the grievance that the private respondent has illegal constructed a building by filling up a water body, filling up a pond, which is used for pisciculture, situated at Muaza Indus, LR Dag number 434, RS Dag number 434, JL number 66, Block Indus under the police station, Indus in the district of Bankura. Police station. Counsel for the petition submitted, though the petition has filed the complaint to all the authorities, but the authorities have not taken any steps. Accordingly, the petition has filed the present date application. After filing of the present date application, the Additional Director of Fisheries within bracket Tech DACA, headquarters West Bengal, has made a communication to the District Magistrate Bankura, dated 17th of October 2025, by requesting for taking appropriate action as per the provisions of the Indian Inland Fisheries Act 1984. This court find a counsel for the state submit that the on receipt of the complaint of the petitioner, the authorities have already initiated action and is pending for adjudication. Considering the above, this court finds that no purpose should be served by keeping the present date application pending. Accordingly, writ petition is disposed of by directing the District Magistrate Bankura to dispose of the representation submitted by the petitioner dated. What is the date?
My lord, dated that is page 55 onwards, my lord.
12 September.
12 September 2020. 12 September 2025.
By giving an opportunity of hearing all the parties within a period of 6 weeks after receipt of the copy of this order. Full stop. If the authorities found that the private respondent has made illegal construction over the pond, filling up the pond, the authorities shall take appropriate steps for eviction against eviction of the private respondent from this property. WPS also,
Grateful, my
In item number 5, my lord, I beg to appear on behalf of the respondent number 6.
I am for the respondent 1, Union of India, led by coming.
We are challenging an order of debarment, my lord, which is at page 56 of the writ petition, my lord. Earlier 2 occasions, the matter was taken up for consideration. We have obtained the interim order. The issue is that, my lord, the department concerned has debarred us from participating the tender process, and challenging that part, we have preferred this writ petition, my lord. The issue is that they have unilaterally extended the work order. However, we have not extended those work order, my lord. Kindly takes up page 34, my lord, for once.
Yes, page
34, my lord.
Yes.
That is the first work order which was given to us. Lord, the type of work was the deployment of the manpower to various organizations by our company.
Page 30?
34, my lord.
34 annexer B.
Yes.
It was given.
23rd of.
To whom it was addressed?
It was addressed to the Department of Defense Production.
By whom?
By our company, my lord, the HRT Commercial and Industrial Security Force Private.
Who are you?
I am the HRT Commercial and Industrial Security Private Limited. It is a company, my lord, who actually deploys some manpower services to some organizations for gardening, for security services. Now, my lord,
providing the security service.
Yes, my lord.
Yes,
now,
then?
firstly, the work order issued to us on 23rd of March 2023 at page 34, my lord.
That's a 34 is one annexer. Where is the main order?
The order which I am challenging, my lord.
Annexer B. Where is the main order?
56 is the department order, my lord.
Huh?
50.
Giving the work order. Where is
Yes.
the work order? This
For-
is the annexer B. Where is the main order? Which
Main order is
annexer A and annexer B. Where is
Yes.
the main order?
annexure P3 is at page 43, my lord. Page 44 rather, my lord. 5.0, the requirement of the GEM generated invoice for claiming bills for so-and-so period starting on and from 27th of March 2023 till 31st of May 2024.
Page 44.
Yes, my lord. First paragraph, last line.
44 is this one. Which
I'll
writ
wait by-
petition?
Page 44 of the writ.
19176.
19176. my lord.
Yes.
My lord, page 44 of the writ petition. My lord, perhaps my lord is taking up the report.
Report on this.
My lord, may I briefly give the facts, my lord, before I refer to the documents?
Yes.
My lord, the facts is, my lord, I am a bidder. I bidded for a contract circulated by the Department of Defense. I was supposed to supply manpower for a period of 1 year. I was successful. I was given the work order. I completed 1 year of my work. Thereafter, there was an extension. And that extension was accepted by, it was a joint acceptance. They offered, I accepted, and I continued the work for another period of the extended period. Thereafter, my lord, there was a third extension which I did not accept. And I did not want to continue on the same terms and conditions, my lord. And I had communicated that to the authority concerned. So, my lord, on the basis of my not accepting the point of extension, I have been debarred. My lord will kindly appreciate, my lord, the original period of tender work was for 1 year. And I have been debarred for 5 years. And after debarment, my lord, what happened was they communicated it to the GEM portal. My lord, GEM portal, my lord, though my lord knows, my lord, just for a recollection, my lord, GEM portal is now a portal of the central government, which says that all tenders has to be floated from the GEM portal itself. So pursuant to the communication of the debarment order by the authorities, my lord, the GEM portal further debarred me that I will not be able to participate in any tender in the entire country. My lord, we came up before the honorable court, my lord. The court passed, my lord, 2 orders, and by virtue of those orders, my lord, the court, my lord, firstly allowed us to continue to participate in the GEM portal for all other tenders except for the tenders, if at all floated by the tendering authority in question. And thereafter, my lord, also granted them, my lord, an opportunity so that they can suffice whatever they have in terms of the report. That's why a report and an exception has been filed. My lord will kindly take up page 56 of the writ petition now.
Yes.
My lord, page 56 is the communication of the debarment, my lord. My lord, I am just placing it. Thereafter, I will take, my lord, to the debarment order. It says, it is regretted to inform you that your firm has been debarred from all running contracts, awarded bids, participated bids or tenders, and future bids or tenders that have been published or will be published by the DOD. My lord, the DOD here, my lord, is the Department of Ordnance. DOD and its allied establishments for the upcoming 5 years. This decision has been taken by the competent authority of this office due to non-compliance of the monthly wages to the contractual laborers deployed by your firm for a period 27th May 2024 till 31st August 2024. Well, I'm just pausing here for a moment. I was not in acceptance of any extension. So the date of 31st of August 2024 is itself not right.
When you accept, what was the last date when you have worked?
31st July. Right? The last date was 31st May 2024, which was the time I had accepted. My tender period was up to 31st March 2024, extended up to 31st May 2024, which was in consonance. I accepted, I worked. Thereafter, I did not work.
After 1st June, you have not worked?
No.
So the 31st of August 2024, you have not worked.
This is as per their third extension letter.
Correct. Whether you have deployed, you have executed the work from 1st of June to 31st of August 2024.
We have executed it from
No, we have not executed from 31st May to 31st August.
As per your submission, only 3 days is here. Only.
Yes, 3 days we worked.
3 days is
We
here.
worked.
After the 3 days, that's why 1st June till
We did not.
31st of August, you are not deployed any person, you are
No,
not executed
no,
any.
no.
Yes.
For which the contractual laborers have already performed the works belongs to service contract, horticulture service, gardening works, manpower outsourcing, 6 numbers of resources for DOD Rajarhat complex. In view of the severity of this breach and violation of service contract, competent authority has also decided to forfeit the bank guarantee security deposit amount made in favor of the principal controller of accounts, Kolkata, with the performance with regard to the performance security deposit by intimating the paying authority for this service contracts concluded by this office with a firm. Will now come to page 57. Page 57 is the order by which, the reasons by which page 56 is issued.
Yes.
This says, this is with reference to the buyer's letter number such and such procurement dated 21st February 2025. Through the said letter, the buyer conveyed their ex parte decision for debarring our company for the 5 years in Directorate of the Ordinance and forfeiting the bank guarantees deposits retained with the buyer. Against the action against the action taken by the buyer, this is to state that the buyer did not gone through the terms and conditions of the GEM contract before going to take their decision on us. In fact, the buyer never responded and replied to our letters issued to them by us from time to time, but they always acted upon their wills and accordingly issued all the letters to us without any authority and justification, because we are no way responsible for payment of wages to the contractual laborers who had rendered services during the period 27.
What is this?
Lord?
What is this?
Lord, this is the annexure, my lord, of the 21st of the page 56.
Page 56.
Page 56.
And no, can't be. There is no mentioning with regard to the annex.
This was supplied to us like this. Page 56, page 57.
And this is not the who authored this letter. Where is the signature?
Milord, there is no signature.
Then you have issued this letter. You are admitting this 57.
Reporter luggage na?
No signature is there.
No, it is your
How?
document.
How can I, Milord? If signature is not there.
Milord, they did
It
not
is,
deny it before this division single bench on the last
Is there-
occasions.
is
Even
there
in the
no-
report, they
Okay,
have
okay,
not said so.
continue, let me see.
Milord, we have received, I am repeating, Milord, we have received this along with the page 56. Milord, I am not taking, Milord, to the entire part. Milord, will in the first paragraph, last sentence, which it starts, the buyer did not issue show cause notice to us before going to the issue the letter dated 21st February.
It is your contention they are writing.
No, Milord, this is Milord, we see the heading. It is a document of Department of Defense Protection.
Okay, continue.
It is to be stated that the Honorable Guwahati High Court passed a judgment on such and such, whereas, Milord, that judgment also, Milord, I am just taking a pause here. The judgment there also, Milord, what has happened was, in that particular order, they had given a similar debarment. The Guwahati High Court set aside that particular debarment as well. So, Milord, the question involved here is twofold.
Yes.
Page number 12.
Basis of their extension.
Milord, will kindly come to page 41 once. Milord, page 41, basically it starts from, the document starts from page 35. Page 35 is the contract documents. This has also been reproduced by the respondents in their report as well. And Milord, I am referring to Milord, will kindly come to page 36 first. I'm so sorry, Milord. Milord, page 36.
What is this?
Milord, this is the contract document starting from page 35.
Yes.
So, Milord, page 36, Milord, at the beginning of the page, Milord, there is a table. If Milord sees, there is a table.
36.
36.
Yes.
There is a table Milord can refer to.
10 year, 12 months.
Milord,
Yes.
in the last the tenure, it is 12 months.
Correct.
Milord, thereafter, Milord will kindly come to page 41.
Yes.
Page 41 says, Milord will see 2.1. It is option clause.
Yes.
Purchasers reserve right to increase or decrease the quantity to be ordered up to 50% of the bid quantity at the time of placement of contract. The purchaser also reserves the right to increase the ordered quantity by up to 50% of the contracted quantity during the currency of the contract at the contracted rates. Bidders are bound to accept the orders accordingly. Milord, to our understanding, before we place our understanding, Milord will kindly refer to page 41.
Yes.
Milord, in page 40, there is 8.2, clause 8.2.
Yes.
It is in the between stage, Milord. The heading is total.
Yes.
In total, Milord will see there is a word called Q in quotations, which says quantity. And in bracket, Milord, it says number of resources required by the buyer.
Correct.
Milord. So our understanding is, Milord, the power of the tendering authority is that whether the number of people we are supplying, if they want, they can increase it before or during the contract. But their observation is they have the power to increase the tenure of the contract. So according to them, the extension is under clause 2.1 and I am bound by it. So, Milord, I am seeking an interim order, Milord. So far as here is concerned, Milord will kindly refer to my prayers.
Why interim order? They have filed the report.
Yes, they have already filed. Milord will kindly see their report then. In report also, they have reiterated this.
What is your prayer?
Milord.
What you prayed for?
Page 24, Milord.
Setting aside the
Setting aside of the debarring. Milord, first part has already gone.
Where is the debarring order?
Debarring order is page 56.
That is only. Page 56.
Milord.
Where is the 5 years?
5 years.
Where is that?
Milord will see.
In view of the security breach of so-and-so, authorities decided to forfeit the bank guarantee. Control. Where is the 5 years banning?
Milord, it is in the first sentence, the last line of the first sentence. All for 5 years. Milord, has Milord got it? Or may I read it again?
Yes, 5 years.
5 years. So for 1 year contract, I am penalized for 5 years. My security deposit also goes.
So what is their contention?
Milord, their contention, Milord, in the report, Milord, if Milord takes up the report. Milord, I am placing the report because that will be.
What is the contention? Only one.
When the contention is clause 2.1, they have the power, and by the virtue of that power, they have the power to extend the tenure of the contract. Okay. Our understanding is they cannot extend it.
That is the only.
Yes.
Yes, sir.
Milord, may I show some judgment?
Yes.
Yes. Lordship, we have submitted the report only on one point. Learned judge directed us to submit a short report only on the basis that whether unilateral debarment can be done or not as per the contract. This was the only thing. Now, my Lordship, kindly come to page 6 of the contract report.
Yes.
Here, Lordship will find in para 9 the links prescribed in the contract dated 21st March 2023 are the following. Under heading additional required data / documents, that is buyer. Then scope of work and job description, I. Format for price breakup details to be provided by the participating firms in the letterhead. Petitioner accepted the price breakup for manpower outsourcing services for horticulture against 2 Mali gardeners and 2 helper unskilled for 26 working days per month or 312 working days per year for Rajarhat complex and 2 helper unskilled for 22 working days per month or 264 working days per year
for ordnance complex at Alipur. Now, to determine the quantity in terms of man days for outsourcing, this is paragraph 10. Outsourcing manpower requires the scope of work, calculation of total work hours needed, and then to be divided by the expected man hours per day per person. That the quantity is expressed as a total number of man days representing the sum of each individual day's work to complete the project. Therefore, the instant case man days is the required quantity as per scope of work of the contract which the petitioners have accepted. Photocopy you have already annexed, that R4, that initially the stipulated period of contract was for outsourcing of 6 manpower unskilled for horticulture service of Rajarhat complex and DG House DOO CS Calcutta for 27 March 2023 to 27 March 2024 at the rate 26 days and 22 days per month for the period 12 months, placed to the petitioner, Messrs. HRD Commercial and Industrial Security Force Private Limited. That since the period of 12 months, that is 1 year contract period, was over, the buyer means Directorate of Ordnance, Kolkata, applied the option clause 2.1, which provides as follows. Lordship, I'm placing 2.1 at page 41 of the petition. 2.1 generic. Option clause. The purchaser reserves the right to increase or decrease the quantity to be ordered up to 50% of bid quantity at the time of placement of contract. The purchaser also reserves the right to increase the ordered quantity by up to 50% of the contracted quantity during the currency of the contract at the contracted rate. Bidders are bound to accept the orders accordingly. This is the contract clause below. They've accepted it. Then Lordship kindly come to next page. Now that relying upon the option clause 2.1 of the contract, the buyers/respondents have the right to increase or decrease the bid quantity/mandate of the contract unilaterally, and the bidders are bound to accept the same. Yes. Then, my lord, in the instant case, total mandate of 4 numbers unskilled outsourced manpower for Rajarhat complex as per contract is 26 days per month or 312 days per year. And total mandates of 2 numbers outsourced manpower for DG complex at Alipur is 22 days per month or 264 days per year. The quantity of mandates per year being 312 days for Rajarhat complex might be extended by the buyer up to 50% of 312 days, which becomes 156 days. The quantity of manpower mandates per year being 264 days for DG complex at Alipur might be extended by the buyer.
Whatever you explain, whatever you explain,
yes,
where the contract says, show me.
That is 2.1, my lord.
2.1 what say? 2.1 is simply.
Yes.
2.1 is simply.
Yes.
In the tender notice, you have not stated that this 5% are required, 6% are required, 10% are required.
Yes.
You have only stated that you have to supply the manpower to this area.
Yes.
Correct.
Yes.
And 2.1 says if they can, if suppose today they have ordered, they have directed to supply 4 persons.
Yes.
Tomorrow they can order for the 8 persons.
Yes.
You have to supply the 8 persons.
Yes.
Or you can decrease by 1
Yes,
person.
I admit that.
This is the only thing.
Yes.
Correct. So show me whether there is a quantity that yes, this person is to be given. Where there is there is any cutoff mark that the only these persons are required. And
no. I'm not on that.
So,
Milord, the contracted period was over on 27 March 2024.
Correct.
Then, Milord, it was extended for the first time.
Correct.
Milord, Lordship, now come to page 51. 51. From Lordship, we find that first contract that was made, Milord, 27 March 2023 to 27 March 2024.
Page.
51.
Yes.
Annexure P7 of the writ application.
57.
Yes, 51 page, Annexure 7. Annexure 7. Yes. where subject is compliance of wage payment to contractual employees for horticulture services, gardening works at DWO Rajarhat complex. Now here Lordship clearly see that till 27th of March 2024 payment cleared for these 6 persons who are supplied.
Correct.
Then come to the next winner. This is the period from 28th March 2024 to 31st May 2024.
Yes.
But here payment was cleared up to 26th of May 2024.
Correct.
They didn't pay beyond that.
Who?
This petitioner. They should pay, my lord. Then, my lord, next one. 1st June 2024 to 31st July 2024. Payment not cleared. Not a single penny given.
Whether this 1st June and the first contract was up till the 21st of March 2024.
Yes.
27th of March 2023 to 21st of March, 27th of March 2024. That was the original contract.
Yes.
Correct.
Yes.
So that there is no dispute.
There is no dispute.
No dispute.
Yes.
Now thereafter there was
Extension.
From extension is 28th of March 2024 for till
31st
August
2024.
31st
Oh,
of
31st May.
May
31st May. 31st.
Yes.
31st of May 2024.
Yes.
So as per your allegation that they have paid only till 26th of May 2024.
They paid.
6 days, 5 days they have not paid.
They didn't pay.
Okay.
Then well, next
Now,
extension.
no,
was
that's why
made.
the
Yes.
next extension. Where is the next? There is any extension of 1st June 2024 to 31st of July. Where is the extension?
Next extension is extension number such and such dated 31st.
Show me the
May
extension number.
2024.
Where he is telling that's why I put a specific question to them. Whether there is any order of extension from 1st June 24 to
Yes,
31st.
yes. That is
Where is
there.
that?
It is written there.
Show me the extension order.
I'm coming to Lordship. First Lordship, I have a notice to it.
Yes, I gone through. No
1st
problem.
June 2024 to 31st July 2024. Payment not cleared. They didn't pay.
Correct.
Then we'll have third extension 1st August 2024 to 31st August 2024.
Correct.
They also didn't pay.
Not paid.
As they didn't pay from the first extension for 5 days,
Correct.
thereafter they were given the so-called.
Correct.
You know why you are not paying?
Where is the so-cause?
Milord, so-called is there.
That is only the page 51 is the so-cause, I think so.
Pardon?
Page 51 is the only so-cause.
Yes, Lord.
51 is the only so-cause.
Yes. In view of the above, you are asked to provide a suitable clarification. Page 52, regarding your claim by letter such and such, you are also requested to make the payment to the contractual employees without any further delay. Your reply with proper clarification should reach this office on or before 31st January 2024, failing with appropriate action as deemed fit will be initiated
Escalated
against your firm.
Yes.
Yes. Then Lordship is there. Then,
Yes.
Milord, what happens? They didn't. And because of the reason, Milord, we had to take, Milord, the action against them.
What is the reply?
Reply, Milord. Milord, Paras the 31st January 2025.
30th January.
31st.
54.
Page 54, yes.
54 years.
Here, Milord, they stated the GEM contract work against number such and such for 1 year has been successfully completed on 26 March 2024. Moreover, the contract as per extension granted for the period 27 March 2024 to 26 May 2024 has also been completed from this end. They have also admitted.
Yes,
that
yes.
it has been paid till 26th of May.
Correct.
We are accepting.
Then, Milord,
Come to the paragraph 4.
Paragraph 4. Yes, it is
Paragraph 3
accepted.
3 is also 3.
Okay, 3.
That due to oversight and typing
Okay,
mistake,
let come to 3. Did not accept your office of decision.
second extension offer communicated by your letter number such and such dated 31st May 2024 did not accepted by this office, and the decision taken by our company has been conveyed to you by letter dated such and such 7th August 2024. As your company did not accept your second extension offer, acceptance of third extension offer issued on 11th July 2024 does not arise. In view of above, under what authority you are asking our company to clarify the matter once more. Under no circumstances you can take any action on our company as per available values of the contract. This is their request. Then my lord, next page lordship can come to, from our official record, the period of delayed bill payment are submitted to you by our letter number such and such. We are not accepting your other points of complaints under any circumstances. So for option clause 2.1, they have stated against term and conditions of 2.1 of the contract, increase or decrease up to 50% bid quantity does not mean period of the contract. We have also not stated anything period of the contract. We have stated manpower. The period of the contract, but it means numbers of manpower required.
So now here only the question is that you are stating that there was a extension.
Yes.
From 31st of May, from 28th of May 2024 to 1st of August, 31st of August 2024.
Yes.
They are telling that yes, you have given the, but they have not accepted.
Yes.
So if they have not accepted, how you can say that they have to pay the amount?
And by virtue of that, I am punished.
Yes.
No, that is not the thing.
Why?
But what I like to submit is this, that as per the clause, we may extend 50%, we may reduce 50%
Correct.
of the manpower.
Correct.
Then, my lord, we have extended that they have not accepted. And now, my lord, according to them, that they have been deferred for a period of 5 years by us. But GM portal has barred them for 3 years. This is the main contention of their submission. Now, lordship can come to the last page 85. Page 85, it starts from my lord, office memorandum dated 2nd November 2021, guidelines on debarment of funds from bidding. Page 83, it starts. And lordship kindly come to page 85.
Yes.
Here lordship will find guidelines on debarment of funds from bidding. Guidelines are classified under the following 2 types. In cases where the debarment is proposed to be limited to a single ministry, the appropriate orders can be issued by that ministry itself, thereby banning all its business dealing with the debarred fund. Where it is proposed to extend the debarment beyond the jurisdiction of the particular ministry, that is covering to all central ministries / departments, the requisite orders shall be issued by Department of Expenditure, DOE, Ministry of Finance. Millard, respondent number 1 to 5, they belong to Ministry of Defense. Therefore, lordship can come to the paragraph 5 above.
Single ministry.
Single ministry, lordship, page 85.
There is no dispute.
Debarment by single ministry / department, orders for debarment of a firm shall be passed by a ministry / department organization keeping in view the following. The bidder of any successor may be debarred from participating in any procurement process for a period not exceeding 2 years. Funds will be debarred if it is determined that the bidder has breached the code of integrity as per Rule 175 of GFR. Then, my lord, it would be 5 years. This is.
Sir, only here the question is, they may made out a case, whatever it may be. Only the question is that their original contract for 1 year, thereafter till the 31st of May 2024. Correct. You have extended the time, they have not accepted your extension of time. Can for that period, if they have not accepted the time, can for that period you debar?
This extension is for what? What is being extended? Innocuously, if your lordship can
Where is the extension order?
Lordship can
Where is the extension order? Second extension order.
Page 45, my lord.
Oh, no, that's fine. Lordship, 1 minute. No.
The second extension is at page 45.
45.
My lord.
Implementation option clause extension, horticulture service.
That we'll see 1.0. May I
Now,
please?
competent authority decide to extend the order of period of census for 2 months using clause 2.1. Yes.
So the extension is for period. What my learned senior friend is trying to say.
45, dated 31st May 2024.
Correct.
Now, competent authority has decided to extend the order
Yes.
for period with effect from 1st June 2024 to 31st July 2024.
Yes.
That is 2 months using clause number 2.1 of the referred work order.
Yes.
This is one.
At
Then
page 47.
Also, similarly, page 47, that is dated 11th July 2024. Here you
Identical.
will find competent authority has decided to extend the order for period with effect from 1st August 2024 to 31st August 2024.
Correct.
That is 1 month using clause 2.1 of the referred work order. These are the extension.
Yes.
Then the question is this, that while contract says something and they have accepted the contract. And therefore, my lord, while they have accepted the contract, then they should not go beyond the contract. If they go contravening the contract, then my lord, certainly we have the right to, my lord, take action against them. That is the thing what happened.
It is a mandatory, the extension is to be accepted.
Lordship really
If it is
consider
mandatory to be accepted,
this.
then I will record that it is extension. If they ask for the extension, then you have to be mandatory, you have to be extended.
My lord,
how it can be, sir?
2.1 says that
no, sorry,
that we have the right to.
This could differ from your submission. 2.0 say period is extension, no problem. They have accepted second extension, yet they have not accepted. If they have not accepted, can you put the burden upon the contractor? You pay the amount or depart. You may pass an order, okay, if the persons have been worked, you pay the amount, that is different thing. But whether you can depart when you are not extended.
Payment is something else. While extension has been made and they have not accepted the extension.
If they have not accepted, how you can say that you have to accept?
In my humble submission, that is violation of contract.
Okay, that's all.
Yes.
That's all.
Yes.
Yes. Supposed to reply, Millard.
Yes.
Millard will kindly take up page 85, Millard. My learned senior friend concluded it with that, Millard. Millard, 85, Millard, according to my learned senior friend, is the power of debarment the department draws. Millard will kindly take up clause 5A. Millard, page 5A, clause 5A is at the bottom of page 85.
Yes.
It says, Millard, orders for debarment of firms shall be passed by ministry/department/organizations, keeping in view of the following. A bidder or any of his successor may be debarred from participating in any procurement process for a period not exceeding 2 years. I am 5 years. So I am exceptional bidder who has to be punished, who has to be debarred for 5 years, whose security deposit has to be snatched by the government. Millard, there is in the records, Millard, there is a document, Millard, if Millard is referred to, which is the procurement manual. If there is, Millard, on the last occasion, Millard, we had provided, Millard, though not to this court, Millard, to the concurrent bench, Millard. It is the Government of India, Ministry of Defence Procurement Manual 2009. আচ্ছা দেখবে জজ সাহেবের ফাইলে আছে কিনা রিপোর্টে তুমি দিয়েছো দাদা Millard, I'm sorry, Millard, page 138 of the report, Millard.
Page 138.
I am grateful to my learned senior friend.
Yes.
Thanks for violation.
No, Millard, this has to be given. Millard, my learned senior friend has given a portion of it, Millard. The debarment manual, Millard. This is the debarment manual, defense manual. Millard, I will provide a copy, Millard. I'm so sorry, Millard. It was provided on the last occasion of the last bench, Millard. Millard, before Millard takes up the quoted part, Millard, if Millard kindly takes up page 9 of the PDF, Millard, yes. At the beginning. If it is.
Which clause?
Millard, page 9 is clause 1.1. Chapter 1, Millard, the introduction. It a copy kore judge সাহেবকে দিয়ে দিতে
1.1.
1.1. The
Yes.
manual may be called the Defense Procurement Manual 2009, my lord. Then 1.1.2. This manual contains principles and procedures relating to procurement of goods and services for defense services, organizations and establishments laid down in terms of Rule 135 of the General Finance Rules 2005 and shall come into force from such and such. Now, my lord will kindly take up clause 7, my lord, which is at page 75, 7.13. 75. If Millard gives, we will provide. We should, it will be
7.5.
7.5. 7.13.5, Millard. Page 75 of the PDF. Should be page.
Yes. Yes.
Millard will kindly refer to 7.13.5 clause G.
The repeat order to be placed within 6 months from the date of completion of the supply.
And should be placed only once.
It should be placed only once. Yes.
So Millard, once they have given. Second is not permitted according to their rules.
When the order of extension was issued to you,
Millard, the first which we accepted.
second which you are not accepted, which date it was supplied as
Millard, it was issued. Millard, I am just placing page 43. It was issued on 20. No, not 43. The second extension is on 31st May 2024. It is within 6 months, Millard. It is within 6 months, but it is the second time. Millard, that Millard will recall the clause says.
Second extension.
Second extension is
So
not.
your first extension when it expired.
But first extension expired on 27th of May 2000.
May 2024.
Millard.
And they have issued the second extension 31st of
Millard,
May.
Millard.
So how you are telling that 6 months?
Millard, it is within 6 months, but it is the second time they have extended. The clause says within after 6 months
The
of.
repeat order is to be placed within 6 months from the date of completion of the supply.
Millard.
Completion of the supply means that the last date of the when you are going.
Millard, the last part, Millard. Within
previous order.
Within 6 months, the repeat order has to be placed within 6 months from the date of completion of the supply against the previous order, and it should be placed only once.
Correct.
So once is which was given to us in March.
March to March.
March to May we worked.
March to
that
May.
was the first time they gave.
Correct.
So it was only once they could have given. Within 6 months they could not have given a second extension itself.
No, even though the second extension was given on 31st of May,
we did not
whether
accept.
That is within 6 months. I am asking you whether within 6 months.
6 months from the date of completion. Millard, my tender was supposed to be over in the end of March 2024. So
previous order means first extension, second extension order. Second extension.
Millard, my original tender period was from March 2023 to March 2024.
Correct.
First extension given in March 2024 up to May 2024.
Correct.
Then they gave a second extension on 31st May 2024. So my humble submission is, Millard, they do not have the power to extend a second time itself.
Okay. Yes, sir. Anything further?
Not one thing I like to add. So for the Government of India Ministry of Defence Procurement Manual is there. 10.IN, the earnest money plus performance, page 138 of it.
Page 138.
Millard, in that PDF also Millard Bill 5, 10.11.
Any breach of the aforesaid provision of bidder may employed.
Any breach of the aforesaid provisions of the bidder or anyone employed by him or acting on his behalf, whether with or without the knowledge of the bidder, or the commission of any offence by the bidder or anyone employed by him or acting on his behalf as defined in chapter 9 of the Indian Penal Code 1860 or the Prevention of Corruption Act 1988 or any other act enacted for the Prevention of Corruption Act shall entitle the buyer to take all or any one following action whenever required. Then I, the earnest money / security deposits and performance bonds shall stand forfeited earlier, fully or partially as decided by the buyer, and the buyer shall not be required to assign any reason thereof. Therefore, III will immediately cancel the contract if already signed without giving any compensation.
I accept it, my lord. The entire submission is on the basis of one word, breach. And I have not breached anything.
Yes.
That's all.
But am I required to show any judgment if
so?
My lord, the judgment.
Why you are making a piecemeal
My lord,
submission?
then I am not. My lord,
You got to give their time.
2014. Huh? My lord, then let it be. My lord, I am not disturbing the court. My lord.
The petitioner has filed the present application challenging the impugn order dated 21st of February 2025, wherein the who has passed this order? Deputy director is the party here.
My lord?
Deputy director is a party here. Passed by the respondent number 5.
না উত্তর দিয়ে কি বলছেন শুনতে পাচ্ছি না
5.
Respondent number 4.
Yes. Deputy Director is respondent of 5.
Respondent number 5 by debarring
Yes, sir, 5.
petitioner
5.
from all running contracts awarded bid, participated bids or tenders and future bids for tenders that have been published or will be published by Department of Ordnance within bracket C and S and its allied establishments for the upcoming 5 years. By the said impugn order, the respondent number 5 has also directed that for forfeiture of bank guarantee / security deposit made by the petitioner in favor of the principal contractor of principal controller of the accounts, Calcutta, with respect of the performance security deposit. The respondents have awarded the contract. Where is the contract? Page 34.
Page 30
has awarded the contract to the petitioner.
Contract is at page 35 onward.
To the petitioner for where is the name of the pub?
The name of it is.
What is the name of the work?
35 minute. It is manpower outsourcing services.
Manpower outsourcing services for the period from for a period of 12 months. From 27th of March 2023 to 27th of March 2024. The respondents have extended the contract of the petitioner.
Respondent number 1 to 5. We belong to Ministry of Defense.
The respondent number 1 to
They are
5.
the main respondent.
Respondent number 6 belongs to Ministry of Finance.
The respondent number 1 to 5 respondents have extended the contract period of the petitioner initially from 28th of March 2024 to 31st of May 2024. Again, the respondents have issued an extension of the contract of the petitioner from 1st June 2024 to 31st of July 2024. 31st of July 2024. And that second extension you are not accepted, no?
No, second extension we did not accept.
July
And there's a third extension from
and
first
third
August.
extension on 1st August 2024 to 31st of August
Second did not accept, sir.
It is the case of the petitioner that the petitioner has accepted the first extension order from 28th of March 2024 to 31st of May 2024. Subsequent thereafter, the petitioner has not accepted the extension given by the respondent number 125 to the petitioner. So who has supplied the manpower? Who has supplied the manpower?
But up to the first extension I have.
You have supplied.
After first extension I did.
It is also submitted that till 31st of May 2024, the petitioner has supplied the manpower in terms of the first extension. As the petitioner has not accepted the second and third extension and also intimated to the respondents, according the petitioner has not supplied any manpower to the respondents. The respondents had issued a show cause notice on 29th of January 2025. Intimating that with regard to the payment of the manpower supplied by the petitioner from 27th of March 2023 till 26th of May 2024 was cleared, but thereafter payment was not cleared. And accordingly, the respondents have called for a clarification from the petitioner on or before 31st of January 2024 as to why appropriate action shall not be initiated against the petitioner. On receipt of the said notice, the petitioner has sent a reply on 30th January 2025.
It's 7th August and 30th January.
30th January 2025.
And 7th August also.
7th August?
7th August 2024?
I am asking with regard to 30th January 2025. 2025. Intimating that the wages payment in respect of the entire period from 27th of March 2023 to 26th of March 2024 has been cleared by the petitioner. And it was also informed that the second extension offer communicated by the respondents dated 31st of May 2024 was not accepted, and the same was duly communicated to the respondent by a letter dated 7th of August 2024. Counsel for the petitioner submit that as the petitioner Learned counsel for the petitioner has drawn the attention of this court to the to clause 2.1 of the tender document and submits that as per the said clause, the purchaser reserves the right to increase or decrease the quantity to be ordered up to 50% of the bid quantity at the time of placement of the contract. The said purchaser also reserves the right to increase the ordered quantity up to 50% contracted quantity during the currency period of the contract at the contracted rates, and the bidders are bound to accept the orders accordingly. We submit that the petitioner has complied with the said clauses by providing the manpower as per the requirement of the respondents with regard to the first original contract and with regard to the first extension contract. As regard the second contract, the clause does not affect the petitioner, as the petitioner has not accepted the second extension and the third extension. Second extension and the third extension. Full is true. The counsel for the petitioner further relied upon what is this called?
Defense Procurement Manual.
It has relied upon Defense Procurement Manual, particularly clause 7.13.5, 7.13.5 within bracket G, wherein it is mentioned that the repeat order is to be placed within 6 months from the date of completion of the supply against the previous order, and it should be placed only once. Relying upon the said clause, learned counsel for the petitioner submits that the respondents have issued the first extension within a period of 6 months, and the petitioner has complied with the said order by supplying the manpower. The respondents have debarred the petitioner for non-compliance of the extension order and non-payment of the wages to the employee with regard to the second and third contract, which the petitioner has not accepted. And as per the said clause, the respondents cannot issue any further extension other than the first extension. First extension. Full stop. Counsel for the petitioner further submits that the impugn order issued by the
One thing I'd like to make sure that's extended.
I will come to you. I have not recorded your submission. I will come to you. Counsel for the petitioner further submits that the impugn order issued by the respondent number 5 is without any issued. The counsel for the petitioner further submits that the respondent number 5 had issued the impugn order without considering the clause 2.1, as the 2.1 is only with regard to the extension, with regard to the quantity, supply quantity of the manpower during the currency period of the contract, not with regard to the extension period of the contract. Full stop. Per contra, learned advocate appearing for the state for the respondent number 1 to 5, for the respondent number 1 to 5, submits that
So what I like to bring to your lordship's kind notice is 123 of the report.
123
page 123 of the report.
of the writ petition.
Report.
The report. 123, yes.
7.13 option clause and repeat order clause.
Okay, I will see. I will record this. Per contra, learned advocate appearing for learned senior advocate appearing for the respondent number 1 to 5 submits that The contract dated 21st of March 2023 required additional submit that as per contract dated 21st of March 2023, the scope of work and job description as well as the format of price breakup has been accepted by the petitioner. He submits that to determine the quantity in terms of mandates for outsourcing manpower requires the scope of work, calculation of total work hours needed, and then to be divided by the expected man hours per day per person. He submits that the quantity is expressed as total number of man-days representing the sum of each individual days worked to complete the project. Full stop. He submits that the instant case, the man-days is required quantity as per scope of work of the contract which the petitioner has accepted. Full stop. Learned counsel for the respondent has submitted that the respondents have issued the so-called notice to the petitioner by calling upon the petitioner for clarification, but the clarification which the petitioner has submitted, the respondents have not satisfied with the said clarification. Accordingly, the impugned order was passed. Full stop. He has relied upon the guidelines on the Department of Forms of Bidding, wherein it provides that in cases where the department is proposed to be limited to a single ministry, the appropriate orders can be issued by the ministry itself, thereby banning all its business dealing with the debarred firm. Full stop. He further submit that in the present case, the petitioner, this is the case of the petitioner is dealt with a single ministry, and as such, the impugned order is passed by the single ministry, by debarring the petitioner for violation of the terms and conditions of the contract. Yes, which clause? Yes, page 123. Learned
123.
Learned counsel for the respondent number 1 to 5 has further relied upon clause 7.13.2.
7.13.1.
13.1. 13.1 of what it says. What is the guidelines? What is the name?
That's it. This is
department
order and option clauses.
No. What is this?
No, this is Government of India Ministry of Defense.
The one I was
procurement manual
2009,
and submits that as per the said provision, the repeat order and option clause should not be.
Option clause may be exercised more than once, provided together these orders do not exceed 50% of the original order quantity.
Shall be repeat order and option clause can be made more than once, provided that altogether these orders do not exceed 50% of the original order quantity.
It means extension may be done once or it may be done twice, thrice.
But it is
but it should not exceed 50%.
In support of this submission, the counsel for the respondent number 1 to 5 submits that if the total quantity of the manpower supplied by the petitioner is taken into consideration, comma, it is found that it has not been exceeded 50% of the original order, and as such, this second and third extension issued by the respondents is in accordance with. Anything further?
No. My page 85 submission has been made. Page 85 will had shown that debarment cannot be for more than 2 years.
That I have recorded.
Oh,
Heard the learned counsel for the respective parties peruse the materials on record. This court finds that the work order was issued to the petitioner for manpower of outsourcing services initially for a period of 1 year from 27th of March 2023 to 27th of March 2024, and subsequently the same was further extended from 28th of March 2024 to 31st of May 2024. The petitioner has accepted the first extension. It is admitted case of both the parties that the petitioner has cleared all the dues of the manpower supplied by the petitioner to the respondents till 26th of May 2024. After 26th of May 2024, the petitioner has not paid the minimum wages to the manpower supplied by the petitioner to the respondent. As per the record, it reveals that though the respondents have issued the extension order number 2 dated 31st of May 2024, but the petitioner by a communication dated 7th of August 2024, from 7th of August 2024, but your extension was given on June. Why you have given on 7th of August? Where is the
after they sent the letter to us, we replied. They were doing it unilaterally among themselves.
Where is the first
extension from 1st June 2024 to 31st July 2024?
Correct. So when the extension order was issued?
31st May.
31st May.
Yes.
So you have given the reply on 7th of August.
Because we were not supplying them at all. They were continuously pressing on us.
Or informed the respondents that the respondent is not interested for extension, and he submits that though the petition, he submits that since 1st of June 2024, the petitioner has not supplied any manpower to the respondents. In the reply to the so-called notice dated 29th of January 2025, the petitioner has also categorically mentioned in paragraph 3 of the said reply, stating as follows. Paragraph 3, look at page 54, paragraph 3. After receipt of the letter dated 30th January 2025, the respondents have issued the letter of the impugn notice dated 21st of February 2025 by debarring the petitioner for 5 years for participating any future bids or tender for participating all running contracts, awarded bids, participated bids or tenders and future bids or tenders and have been published or will be published by the Directorate of Ordnance within bracket C and S and its allied establishment for 5 years. In the said order, it is the respondent number 5 has also forfeited the bank guarantees / security deposit of the petitioner.
One thing I like to clarify that while Ministry of Defense is delivering for 5 years, that is only towards the tenders which will be floated by the Ministry of Defense. But so far the Ministry of Finance, while it would be done, there is all sorts of tenders.
That has already gone.
Those would be floated by
this court finds that
any of
this court finds that once the petitioner has already communicated the respondents that the petitioner is not intending to accept the second extension and the petitioner, and it is the specific case of the petitioner that the petitioner has not employed any manpower to the respondents after the 31st of May 2025. After the 21st of May 2025, this court failed to appreciate that how the respondents have passed the impugn order by debarring the petitioner for 5 years. This court also failed to appreciate that the so-called notice was issued on 29th of January 2025. But in this said notice, the respondents have never mentioned that the letter issued by the petitioner on 7th of August 2025, wherein the petitioner has 7th of August 2024, wherein the petitioner have categorically informed the respondents that he is not going to accept the second extension. Ignoring the letter submitted by the petitioner on 7th of August 2025, wherein the petitioner has categorically denied for extension of the second extension, how the respondents can compel the petitioner to continue with the work, for supply of manpower. Full stop. The clause which the clause of clause 2.1 of the contract.
One more thing. Till 31st August, the persons who worked there, they continued working. They didn't pay, but those persons were not taken out.
No. They are not my employees. Once the contract is over, they are not mine.
That is in the report.
In report page 131.
It is a table they have created, my lord. We do not know what is the genuineness of the table.
This is your.
This is your signature, my lord, taking the responsibility.
Where is that?
Page 131.
131.
Yes, the report.
130.
Who is the Rudra Ghosh?
Their officer.
Yes.
Their officer. Rudra Ghosh is the junior. It is respondent number 6.
Your officer.
It is your office. They have created at home.
How they have supplied? How you can?
It's a residential.
How you can prove that this persons have been supplied by them?
No, I am not telling that those persons were supplied. They stopped. They are working on 6th of May. But after 6th of May, right?
6th of May, 27th of
26th of May, 27th of May to 31st August, they continued there. They worked there.
They worked there, but they are not supplied.
No, I'm not telling that. They worked there.
Contract.
We neither raised bills nor our people worked there.
categorically
But
provide
no data has been set by them that they have been working with running my
context 2.1 of the clause 2.1 of the contract
R8.
provide that the purchaser, that is the authorities, can decrease and increase the quantity of the manpower, but this does not reveal that the set clause can extend the time of contract. Extend the time of contract. Full stop. Extend the time of contract. The learned counsel for the respondent has submitted that, though has also admitted that the petitioner has not supplied the manpower from 27th of May 2024 onwards. 2024 onwards. But the so how these workers were, but the workers who were earlier used to work in the establishment of the respondents were continue to work in the establishment of the respondents. Full stop. The counsel for the petitioner submit that the petitioner has not supplied, petitioner has categorically denied for extension of the time period for supply of manpower, and the manpower has never been supplied by the petitioner, and the persons who have worked with the respondents from 27th of May 2024 onwards are not connected with the petitioner. Are not connected with the petitioner. The clause 7.3.1 7.13.1 which the respondent has relied upon. Provides that repeat order or option clause may be exercised more than once, provided altogether these orders do not exceed 50% of the original order quantity. Full stop. Clause 7.13.5 within bracket G provide that repeat order is to be placed within 6 months from the date of completion of the supply against the previous orders, and it should be placed only once. Only once. Full stop. The so-called notice issued by the respondents does not reflect that the petitioner has informed the respondents that the petitioner is not intending to accept the second extension. So-called notice also does not reflect that the petitioner and that the respondents have informed the petitioner that till 27th of May 2024 the manpower supplied by the petitioner is less than 50%. Considering this, this court find that the clause which the respondent, clause 7.13.1, which the respondent has relied upon, is not covered in the present case. Considering the above, full stop. This court further found that the clause 7.13.5 within bracket G categorically provide that the repeat order is to be placed within 6 months from the date of completion of the supply against the previous order, and it should be placed only once. And in the present case, the first extension order was complied with by the petitioner by providing the manpower for the period from 28th of May 2024 to 26th of May 2024, and as such 2024. Considering the above, this court find that the impugn order dated 29th of January, the impugn order dated 21st of February 2025 is arbitrary, is liable to be set aside and accordingly set aside. As regard the payment of the workers who had worked with the respondents, have you paid the amount to the workers who have paid?
Let that be recorded. Let that be recorded that they have paid that to the workers.
The learned counsel for the respondent further submit that the persons who had worked with the in the establishment of the respondents from
During second and
27th of May 2024 till 31st of August.
So during the second and third extension.
31st of August.
31st of August.
31st
Till 31st
of August 2024, the respondents have already paid the minimum wages to the said workers. Thus, in view of the above, WPA number so and so disposed.
Obliged.
Take this.
Deeply obliged.
Obliged.
Yes.
The next matter in the appellate side.
Which one?
Item number 6.
Yes.
I'll just be praying for a time to file an exception to the report that they filed yesterday. That's all. Here's my other side.
I'm for the respondent number 2.
Counsel for the petitioner prays for time to file exception to the report filed by the respondent. That exception be filed by within a week.
Within a week.
Within a week. List the matter.
Oh, Lord Lordship will give me 2 weeks. Lord, clients are in Bombay.
Within 2 weeks. List the matter on 27 November.
Very good.
Under the same heading.
Lord, one more unreasonable request. Item number 21, there is some urgency. Well, it's an order which attracts interest, statutory interest at 18% per month.
Come tomorrow.
Any precedence if it could be given
Come
tomorrow?
tomorrow, I will check.
Grateful.
If it's not, then we'll see to it.
Grateful.
No faces.
Yes.
Well, it's a pleasure, my lord, to hear Mr.
Call. Original side mentioning.
Yes.
Which matter?
Item number 15.
15.
50.
Before? But unless and until you take the assignment, how? Okay, I am releasing it. But you have to take the assignment. That's correct. Connected order, but item number 50. 50. Learned counsel for the petitioner. You have counsel for the petitioner. Item number 50. Submit that the connected matter is pending before the another court. Under such he prays for release of the said matter. And the petitioner will take appropriate steps to assign the said matter before the appropriate court where the analogous matter is fixed. In view of the submission made by the counsel for the petitioner, WPO 479 of 2025 is released from the list of this court with the liberty of taking appropriate steps. With the liberty to take appropriate steps to assign the matter before the appropriate court where the analogous matter is pending. Yes.
After 18. My lord, may I have your lordship's leave to mention item number 5? My lord, Mr. Bachawat had mentioned this in the morning. This is a South Point matter.
Yes.
My lord, the matters were...
6.
Yes, my
5
lord.
and 6.
5 and 6.
5 and 6.
5 and 6.
Yes, my lord.
5 and
Yes,
6.
my lord. The matters were fixed at 12 noon, but because of the determination change, my lord, it's been 3:30. So, if your lordship kindly fixes any other date, my lord, sometime...
Fix hoga. Anatosh?
It's going on.
Lord, anytime after we are ready. If your lordship kindly keeps it anytime after the 8th.
खत्म नहीं होगा।
Lord, we have already completed our argument. So far as asked, because we have to give reply to Lord, whatever has been argued by Mr. Bachao.
As per the prayer made by the council for the parties, let the matter appear. 20th November.
I am grateful.
At 3:30.
20th November.
3:30.
I am grateful.
20th November is not a Friday, it's Tuesday.
My lord, I would like to mention
at the top. At the top. I am fixing at the top. 3:15. Adjourn motion में क्यों? Adjourn motion इसलिए assign Yes.
My lord, I would like to
15. Yes. हाँ.
November.
Item number 15. Learned Counsel for the petitioner draw the attention of this court to the order dated 20th February 2025 and submit that by the said order, the matter is delisted for the time being with the liberty to mention after conclusion of the criminal proceeding. He submitted till now the criminal case criminal proceeding is pending and is not concluded, and accordingly prays for placing the matter out of the list liberty to mention. In view of the submission made by the counsel petitioner, let the matter go out of the list for the time being, liberty to mention after notice to the other party.
This was a judgment passed by your lordship himself on 28 July 2025. However, unfortunately, as our client was seriously ill had a heart attack, we are in delay of filing the requisite for the drawing up and completion of the judgment. The department has informed us that we need your honorable justice's leave.
Lordship, I would like to.
Made a judgment. You mentioned before the regular bench. You mentioned before.
Lordship, you told that the judgment as it was passed by your lordship himself.
But the court, it is the court judgment delivered. You mentioned if it is not, you come.
Your lordship, I apologize. We mentioned it today in the morning as well. They said to come to your lordship and try to find out.
Your lordship, I would like to mention this matter. In this matter, the petitioner's daughter, 5-year-old daughter has.
Matter.
It's a writ petition WPO 197 of 2025. No, in this matter, the 5-year-old daughter of the petitioner has been murdered by the respondent IVF authorities, and we have, in spite of all the complaints by the petitioner, the commission, the West Bengal Clinical Establishment Commission, has led the IVF authorities scot-free with just a fine of rupees 5 lakh. We have challenged that order. I would like all affidavits are completed. I would like to just keep any day for hearing so that justice.
Other side.
We have served the other side also.
Yeah, this हम लोग का सही नहीं फाइल नहीं है. List next week.
Lord, may I have your
listen next week.
Lord, may I have your lordship's leave to mention a matter, Lord? This is that patent revocation matter which was specially assigned before your lordship. My lord, I was arguing the matter. My lord, I'll tell your lordship, my lord, the matter was fixed on the 23rd of September. My lord, that is the day the floods happened, my lord. That's why I couldn't come to court, my lord, on the 23rd of September. At 3 p.m. it was fixed. The matter could not be taken up that day, my lord, if your lordship kindly fixes any time. It's at your lordship.
Who's for the other side?
My learned friend is here. For the controller.
Controller.
Yes, my lord. My lord, if your lordship keeps it any time after the 18th of November, my lord.
पहले वाला कब रखा हम लोग? After 18 November, it may let me fix. It will.
Your lordship kindly fix a time.
Let it come on the list, then we'll see to it. Yes, call the list.
I'm
Yes.
I'm for the contempt number 1, 2, and 4. My lord, 4 months time has been granted to us to complete the sale.
Huh?
And 4 month time was granted to us to complete an sale and to pay the consideration amount directly to the applicant. My lord, and this matter we have mentioned before, your lordship, that the people who are traveling from Tirupati has not been able to come today. It kindly keeps it on 11th, my lord.
He will come on 11th.
11th, my lord.
Contempt now.
Contempt number 4 has been directed to file a supplementary affidavit. So that affidavit will reach us on 11th, my lord, if your lordship kindly. 24th September order, page number 4.
24th September.
24th September is the last date when the matter was taken up. That is the last order, page number 4, paragraph number 7.
4 and the affidavit filed by the proposal for the unless contained allowed to complete. Yes. So not yet completed.
Sale not yet completed. For completion of sale, your lordship has allowed us time of 4 months.
The Inspector of Police, East Police Station, Tirupati District, Andhra Pradesh, has submitted a report dated 5th of November 2025, stating that Srimati Pramila Sudha Languta is under medical treatment and is bedridden. And her husband is taking care of the said contempt. Consider the report submitted by the police. For the time being, the warrant issued against the Premlata Sudha Langunta is kept in abeyance until further order. Police. Counsel for the respondent number 6, contempt number 6. Appearing for whom?
1, 2, and 4. Contempt number 1, 2, and 4.
Counsel for the alleged contempt number 1, 2, and 4.
My lord.
So who will not appear? 4 is to appear before this court.
Lord, only one may be discharged because she is unwell, my lord. Only one may be discharged because she is unwell. 2, 3, and 4 have to appear, my lord.
3 and 4.
3 and 4. My lord, 4, I have prayed your lordship to keep the matter on 11 so that they can come, my lord.
Counsel for the alleged contempt number 4 prays for accommodation for appearance of the alleged contempt number 4. Accordingly, case adjourned. Let them, when he will appear?
11th, my lord.
On 11th for appearance of the alleged contempt number 4.
My lord, subject to correction, my lord, contempt number 4 has been directed to file a supplementary affidavit with regard to the status of the sale.
Correct.
That affidavit I shall bring on the.
There is an order.
My lord.
And my lord, I may only pray that this may be peremptory.
Affidavit on the next date, please. After serving the copy to the learned counsel for the case. Let the matter appear.
I only pray this may be peremptory because, my lord, has never been appearing.
Lordship, I am appearing for 5, 6, 7, and 8. Contempt number 5, 6, 7, and 8. Lordship.
Lordship, I am appearing on behalf of the contenders.
My lord,
you are for the contempt now?
My lord, my application for contempt, your lordship.
It is made clear that
My lord, will kindly take the last order of 18th September.
Lordship, as of today, I checked the NSC on like any stockbroking app. I checked it. The names have been changed, your lordship. It has been reflected.
They need to file a report because
Definitely, your lordship.
kindly see it's a contempt jurisdiction.
Yes, your lordship.
Where is the report?
Lordship gives us some time to file the report, lordship.
Kindly
There's some
keeps it
difficulty. One of
peremptory,
them
your
is
lordship.
unwell and the other person has gone to his village for the event of Chhat. Your lordship.
Counsel for the alleged contemnor submit that the contemnors have deleted the name of the company from the NAC website and press for time to file affidavit
of complaints.
Let affidavit of compliance be filed within a week.
Lordship, lordship makes it 3 weeks, your lordship.
Weeks.
Lordship, at least 2.
Already.
Lordship, these are all people staying outside of the state, your
So
lordship.
why you are doing this type of the work outside?
The lordship, for showing the conduct, lordship, I already have.
These are
I already have
papers, your
the
lordship, that
papers,
need to bring
the
it to the record.
intimation, the master data, the incorporation certificate where the name change has been reflected, your lordship.
Affidavit by 19th of November 2025 after serving the copy to the land counsel for the petitioner. Petitioner is liberty to take exception to the said affidavit and file our objection to the said affidavit if any. List the matter on 21st of November.
One more direction, a copy may be served to us in advance. I'm grateful, my lord.
Next.
Grateful, your lordship.
3 and 4 is, my lord, my application is section 9.
I pay for the interview.
Well, 2 applications, AP 857, my lord, your lordship has already passed an order and appeal is pending. So, my lord, I will not trouble your lordship with that for the present. Well, if my learned friends have something to say on that, of course, I shall respond.
I will. I can keep a report with me.
Well, it's APCOM 857, since your lordship has passed an order, once my learned friend, my lord, makes his arguments, I shall respond to that. Because there is an order passed and that is pending appeal. Well, so far as AP 91, APCOM 91 is concerned, well, here may I just remind your lordship as to what happened. Well, this was filed in 2024. If your lordship will kindly have a look at the prayers at page 16.
Yes.
Well, injunction restraining the respondents in each of them, etc., from creating any encumbrance in respect of 32 lakhs 37,045, 32 crores 37 lakhs 45,165 shares.
Now the arbitrator has been appointed.
Yes.
So let the take
But
a
cannot be done.
the arbitrator.
No, my lord, the difficulty is this. My lord, the only problem is that your lordship remembers that in this matter there was an order passed by Justice Bhattacharya. My lord, that your lordship will find at page 237.
Yes, appointing the special officer.
Yes, with a direction to sell the shares.
Correct.
Now, my lord, that was not challenged in appeal. That order, my lord, really has attained finality. And my lord, in an affidavit that was filed subsequently in that application, my learned friends have, my lord, clearly stated, yes, shares have to be sold. We want the shares to be sold, but we are not being able to do so because the depository participant is not, my lord, cooperating. That is their clear stand. The affidavit is on record. There is clear admission in the affidavit. Now, my lord, when it comes to, my lord, ultimately implementation of an order of court, my lord, the tribunal will not be able to, my lord, do anything. That is why, my lord, there is this, my lord, provision in section 9. If your lordship will kindly have a look at section 9.
The Arbitration Act, yeah.
Lord, 9 subsection 3. Once the arbitral tribunal has been constituted, the court shall not entertain any application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under section 17 efficacious. Now, if your lordship will kindly have a look at section 17 now. Well, section 17, my lord, is parameter with section 9, except if your lordship now please have a look at subsection 2 of section 17. Subject to any orders passed in an appeal under section 37, any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purposes and shall be enforceable under the Code of Civil Procedure in the same manner as if it were an order of court. Now, my lord, there is already an order of the High Court, which directs sale of the shares through a special officer. Now, my lord, so far as this is concerned, even if it were to be an order of the tribunal, ultimately for its enforcement, one would have to seek, my lord, recourse to Section 36 of the Civil Procedure Code and, my lord, bring it to this court for its enforcement. So, my lord, here it would not serve any purpose to send the matter back to the tribunal. Because, my lord, what we are saying here is that there is an order directing sale of shares. That order has not been challenged in appeal. That order has, my lord, in a manner of speaking, attained finality. And so far as that is concerned, my lord, it was only therefore working out a device or a mechanism through which, my lord, the sale of shares could be achieved.
So not one court, this court has already passed an order.
Yes.
Appointing the special officer.
That's right.
But the special officer has submitted the report with regard to the difficulty of the other party.
Right.
So what can be for the what?
No, my lord, Ashika. My lord, the difficulty expressed was only, my lord, by the, my lord, depository participants saying that we are not being able to sell the shares because, my lord, they have not constituted the trust, the trustees have not been properly appointed. My lord, they are saying, on the other hand, that, my lord, Ashika is creating difficulties in the wake of sale of shares. My lord, there is an apparent collusion between the two. My lord, where, my lord, one is, my lord, saying that because of the other, I can't sell or cannot facilitate the sale.
So what is the stage of the appeal now?
Well, appeal court, my lord, is a separate matter because appeal court.
857.
857 is, my lord, on Hiranmay. Your lordship had directed, my lord, in injunction on the sale of the shares of Hiranmay. My lord, that is, my lord, separately pending appeal. Now, my lord, if your lordship sees, my lord, we had also made a proposal. My lord, that proposal issue, your lordship will find, my lord, in our reply, affidavit in reply, at paragraph 4.
91 and affidavit.
Paragraph 3, page 4.
Signatory of demat account respondent have.
My lord, please see, my lord, paragraph 3, page 4E. My lord, in 4E, there are two suggestions, 1 and 2. My lord, if Ashika is facing a difficulty because the trustees have not properly constituted themselves as trustees, and, my lord, if today the trustees say that Ashika is creating a difficulty, my lord, in our wake of sale of shares, then, my lord, today the simple thing is to, my lord, ultimately that what we have proposed is, my lord, your lordship may direct the signatories to the demat account of the respondent number 4. My lord, that is, my lord, the trust. Be changed to the special officer already appointed, and the special officer, my lord, can open a new account.
Who is the signatory of the demat account?
My lord, signatories of the demat account are, my lord, the trustees. Erstwhile trustees. And, my lord, here, this, my lord, has been recognized by your lordship in the order that your lordship passed in the Hiranmay matter. Well, there your lordship has made a detailed observation in this regard. Well, that is your lordship's order of 16 December 2024. Well, your lordship has very clearly said here, I shall just read out the relevant portion of this, my lord, order. Well, paragraph 25 of the order, 16 December 2024. This court finds that since the year 2017, this court directed to sell certain such shares of IPCL, but till date the sale is not done. This court, by an order dated 20th February 2024, appointed special officer for sale of shares, but the respondents are not providing required documents to the depository participant, due to which the depository participant is not in a position to sell the shares. The documents provided by the respondents to the depository participant clearly reveals that the said documents are not in conformity with the SEBI circulars and in violation of several clauses of the trust deed. Considering the above, then, my lord, your lordship says, restrain them from selling the shares of Hiranmay Energy. Now, well, if your lordship will please see what is their stand in the affidavit filed in 91. Well, at APCOM 91, my learned friends have filed an affidavit. Through one Siddhant Chaudhary. Well, please straight away, my lord, take, well, at paragraph 6 of the affidavit, which is at page 4. And we'll then come to page 5, paragraph 6, my lord, C onwards. Well, at 6D, it may be mentioned that the erstwhile IPCL shares of the respondent number 4 are held in a dematerialized form with one Ashika Stockbroking, which happens to be the depository participant of the respondent number 4, and it is through Ashika that the sale of the erstwhile IPCL shares are required to be effected. 2 of the 3 initial trustees of the said trust tendered their respective resignations from the said trust on 26 May 2021. Then F. Mr. Deepak Rudra, the sole existing trustee, thereafter convened a meeting of the trust on or about 8 November 2021. In such meeting, Mr. Rudra inducted respondent numbers 1 to 3 herein as trustees of the said trust and thereafter resigned from the trust. Then kindly skip over and come to paragraph H at page 6. Apart from execution of such instruments to secure the loans advanced by the petitioner, the respondent numbers 1 to 3 herein, being the newly inducted trustees of the respondent 4, took immediate steps to sell the erstwhile IPCL shares so as to pay off the loans advanced by the petitioner. They applied for change of signatories of the bank account of the respondent number 4 maintained with Axis Bank Limited, which request was accepted and the authorized signatories duly changed. The problem began with a similar request for change of signatories on the demat account of the respondent number 4 maintained with Ashika. Respondents supported the request for change of signatories with all relevant documents like duly executed KYC forms, certified copies of board resolutions, etc. However, Ashika did not effect the change in the authorized signatories. Owing to such refusal by Ashika in changing the authorized signatories, the respondents were precluded from conducting any OFS for sale of the erstwhile IPCL shares in compliance with the solemn directions of the Honorable High Court at Calcutta. And then, my lord, kindly see, next part is even more important. That apart, they were also suffering financial losses due to such disability in conducting OFS. Under such circumstance, the appellant's petitioners, well, that is my learned friend's client, instituted a suit against Ashika before the learned commercial court at Alipur, which came to be registered as money suit number such and such. Copy of plaint is annexed statement Mark G. So, they themselves have now proceeded to file a suit against Ashika saying that you have not allowed us to sell the shares, so have caused us loss in them. So, there's clear admission that the shares have to be sold. There's clear admission that steps were taken to sell the shares, but the impediment, according to my learned friends, were caused by Ashika. Now, if today, an order has been passed, an order has not been appealed against, this order, is not an order for sale and appropriation. It was sale and retain as security because the order is passed in an application under Section 9. So, the sale of the shares was necessitated because the share prices, which we say, are being depleted day by day. That is something that will be sold, kept in an account, ultimately subject to the result of the arbitration, it will be paid. And that causes no prejudice to my learned friends. What my learned friends are now saying, contrary to the stand taken in the affidavit, no, the shares are not required to be sold, they should not be sold. You can, blow hot and hotter, you can't blow hot and cold. That is the doctrine of approbate and reprobate. And what
is the present market value?
At present market value, according to my learned friend, our debt is in the region of 633 crores. At market value can only be determined once the shares are sold because the quoted value, there is no buyer. They have not been sold since the first order of Justice Kapoor in 2023.
2013.
I'm sorry, 2013. Justice Shonji Banerjee in 2013. One more paragraph. Paragraph 12, it affidavit. Of the same affidavit that your lordship was seeing, please have a look at paragraph 12. I should know, before that paragraph, page 12, paragraph T. This is what your lordship's query is, my lord. This is answered. Despite such compliance by the appellant's petitioners and no order from any court or other competent authority restraining the change of signatories, Ashika refused to change the signatories. Consequently, no OFS can be conducted. It is worth noting that the said IPCL shares are listed shares. Based on the price of the said shares for the past 12 months, the average price works out to be around rupees 21 per share. Considering the average price over the last few months as a benchmark, the total value of IPCL shares held by the respondent number 4 is around 685.26 crores. And then, my lord, if your lordship sees paragraph 12, this is how you have dealt with it. Reply. Well, they say that the loans will be liable to repay the loans, if any. If upon being able to sell the shares hypothecated to it. The last sentence at paragraph 12.
So they admit about hypothecation.
So, my lord, hypothecation is admitted. My right to, my lord, receive money against sale of the shares is admitted. Fact is, shares have not been sold in 2013. The fact is, there is an order of court directing sale of shares through a special officer. Fact is, my lord, that order has not been challenged in appeal or otherwise. And that order, my lord, remains, my lord, as it is. This order, my lord, in a manner of speaking, has attained finality. My lord,
Because in the affidavit they have not
if
challenged.
my learned friend, my lord, try to contend otherwise, there is Supreme Court judgment that I'll rely on in this regard. But, my lord, I do not want to burden your lordship with authorities unnecessarily. My lord, this is my
What
case.
is your prayer now?
My lord, my prayer now is for sale of the shares as directed already.
Implementation of the
Implementation of the order passed, my lord, on the 20th of February 2024. That order, your lordship will find, my lord, at page 238. I'm sorry. Well, that's 238 of.
No, prayer A, order of injunction passed rescinding the. You have filed a new appeal? No.
No.
On the 91 only.
91 only.
Man and
Well, Lord,
agent
please
dealing
see. Well, Lord, prayer B.
prayer B. Prayer D.
B. I mean, it is really, my lord, pursuant to prayer B that the order of 20th February was passed.
Yes.
Well, Lord, so far as the suit that my learned friends have filed is concerned, that your lordship will find at my lord page
Ashika.
Ashika. That's against Ashika.
But they have also admitted with
It is
regard to the
91
same
SCs.
91 yes, page 109 of the affidavit in opposition.
Well, at page 109 of the affidavit in opposition filed in 91, my learned friends themselves, well, Lord, disclosed the plaint filed in the suit against Ashika.
And they are relying on this infringement.
What is the prayer in that?
Well, at prayer in the suit, your lordship will find is at page 120.
Change the name of the signatories.
Yes.
This is against Ashika.
Against Ashika. No, not only that, my lord, here, my lord, also a decree for, my lord, 11 crores, 1,186 crores. I mean, that is apparently because, my lord, they have not changed the signatories and they have not therefore facilitated the sale of the shares.
That is the ground. That is the ground.
My lord, please see, my lord, paragraph 25. This is, my lord, very significant of the plaint at page 122.
11 crore 86 lakhs.
Yes. A sum of rupees 1,186.
1,186.
Yes, is
21.
I'm sorry, my lord. Please see paragraph 23. Moreover, plaintiff has a loan from financial institution and the same has to be repaid once the IPCL shares held with the plaintiff power trust is disposed of. However, due to the refusal of the defendant Ashika Stockbroking Limited to change the signatories in the dematerialized account, loans acquired is not being able to be repaid and an enormous interest on the same is being incurred with each passing day. And then, my lord, also paragraph 25. My lord, they say, my lord, that sum of 1,186 crores is payable defend number 1 to the plaintiff on account of cost of remaining IPCL shares as well as interest.
From financial institutions.
And my lord, at page 123 in the table, your lordship will find loan from financial institutions, my lord, 492.44 crores. My outstanding is 633 crores.
Yes.
Well, these are my submissions. Oh, so this suit.
You are suit against Ashika.
Fine.
My lord, today, my lord, what my learned friend has said, though both the applications are before your lordship, my lord,
He has more or less secluded himself into the application under section, sorry, AP number 91. Now, my lord, first things first, my lord, we are in the final hearing. My lord, what my learned friend is trying to say today is, my lord, that once an order has been passed, is not being challenged, in spite of orders of affidavits, my lord, it cannot be finally disposed of by our final order. I am asking for that disposal today. Now, my lord, once we go into that question, my lord, my learned friend has sought to say that he is before your lordship for enforcement. My lord, I don't find any enforcement application before your lordship. It is not before your lordship. Furthermore, my lord, your lordship will find, though it might be folly for me to say this, but I am also being very technical now. So I don't find a prayer for sale. The prayer is for transfer of the sale proceeds. Your lordship will not find a prayer for sale. The prayer is only for injunction. Prayer B is not for sale. So therefore, my lord, first things first, why is my learned friend here before your lordship? He is here for protection, interim protection. What has he said? He has said that he wants interim protection for security purpose. Now, my lord, before he makes out a case for sale, my lord, I say that yes, I had come before your lordship and said, yes, you can sell it, sell it. Because my lord kindly appreciates, initially I had some, I still have, as a matter of fact, problems with Ashika. Now, my lord, the application by Ashika is still pending before your lordship. It has not been allowed as yet.
What?
My lord, the addition of party, my lord.
That is pending.
That is pending.
This process
IAGA number 1.
on 91.
In 91.
Ashika's application.
So, my lord, that has not attained any finality as such today. So today, my lord,
on the
sorry.
problem, if suppose today if Ashika is been added,
my lord,
and you have filed the suit before you have filed the suit before the Alipur.
Yes.
In the commercial division.
Yes, my lord.
And in this suit, you have prayed for
signatory. Change of signatory.
Signatory, change
Yes.
of signatures.
Yes, I've asked for that.
What will happen here if the Ashika is a?
That is what I thought. Today, my lord, my learned friends are trying to enforce the entire action. First, he says that we are in collusion with each other. I couldn't have heard about a better collusion where I fought tooth and nail against Ashika. Now, my lord, other than that, my lord, that will be requiring your lordship to pass an order encompassing into the jurisdiction of whatever suit I have filed, my lord. So your lordship is being called upon to do that. Now, if your lordship says today, my lord, kindly does not take me amiss, I'm not questioning your lordship jurisdiction, but it's a section 9. In a section 9, if your lordship now holds that yes, the signatories needs to be changed, because his proposal is also that. I'll come to that, whether he can look at your lordship in a reply, he can make such proposals, my lord. That is not correct. I had also told your lordship, my lord, that I don't think I can answer to at every instance a new proposal, my lord. That is not maintainable as such. But, my lord, today, if your lordship holds, then your lordship will have to hold that either they are signatories, I mean, my signatories are supposed to be the rightful signatories, or they are not supposed to be rightful signatories. There is an order to that extent from your lordships. But, my lord, while your lordship has passed an order against Hiranmani, your lordship remembers that your lordship has passed an order. Again, my lord, I say that is an interim order. Today, my lord, my learned friend is saying that he's going to enforce an order. Now, my lord, your lordship's order, if your lordship kindly sees the order per se, my lord, the first order passed by this court, my lord. Opposition. But will kindly take the affidavit in, or rather, my lord, may I start with IAGA number 1.
No, Mr. Shah, just a minute. Mr. Shah, in this application, you have paid for injunction and deposit of share.
Sale value of shares.
Correct. So you can make this application before the arbitrator under section 7.
Well, that will undo the order already passed by this court.
Correct. So you can take the shelter of that order already passed, that the arbitrator.
But, my lord, my lord, so far as that is concerned, my lord, the court, my lord, cannot direct, the tribunal cannot direct, my lord, the sale of shares through the special officer which has been directed.
If it's not sale, then what I proceed? Kindly see the prayer B, which
Yes.
you are not pressing. Respondent deposit the entire sale proceed. You can go with the arbitrator.
No, my lord, that order is already there. That order is already there because what this honorable court has already done is directing sale of the shares and, my lord, retention of the sale proceeds in the hands of the special officer. So, my lord, that order is already made. I don't have to, my lord, ask for that order all over again before the tribunal. Now, my lord, the difficulty is that once, my lord, this order is made and this order is not being complied with, can the arbitrator direct compliance of that order? With the greatest of respect, no. For that, my lord, under section 17, as the lordship finds from section 17(2), I have to again come back to this honorable court and seek the recourse of this honorable court to, my lord, enforce that order. That is, my lord, the difficulty. Otherwise, I would have gone before the arbitrator.
My application.
My lord, there are, my lord, certain.
I have sought for recalling of that order.
Which order?
In my application, intervention application, I have sought for recalling of that order passed by honorable.
Only on the ground that my learned friends have not cooperated, the trustees did not have the power to, my lord, direct sale of the security. That your lordship has already dealt with in Hiranmai. That is why, my lord, now the order of the court has to enforce through another mechanism.
These are my lord, with humility, I say, my lord, these are interim orders, your lordships. Obviously, it's subject to the final hearing where we are today.
My lord,
that's why my learned friend doesn't have any application for execution or enforcement before your lordship, my lord. It is in the main application. He's asking for further orders.
Do I have to, my lord, take out a separate, my lord, application for execution? My lord, when it is a section 9 court, I have to do that when it is a section 17 order because the arbitrator is not an execution, my lord, forum. But, my lord, I can ask for implementation if your lordship directs, my lord, that a particular thing be done in a particular way. My lord, do I have to then go and file an execution?
Then, my lord, there will be no question of any final hearing.
Well, so far as that is concerned, I shall show authority. If my learned friend says that the order of sale of the shares to the special officer has not attained finality, I shall cite authority on that.
I'm trying to make out that case. That there is no case made out for this.
Well, may I, my lord, in that case, just interrupt my learned friend? Now, if my learned friend wants to see authority, if my learned friend is contending, I shall, my lord, show an authority.
I said that I will argue.
Let my learned friend argue. Let him show, my lord, whatever cases he wants, I shall then deal with that.
Because with regard to the Hirname, this court has already observed with regard to the contention raised by the Ashika.
Yes.
Correct.
Yes.
Now the Ashika has filed an application for impleading them as a party. And they have also, have you filed the application also?
Yes, pending.
Well,
that's Ashika number 1, my
Where
lord.
it is
Well,
pending.
Ashika.
IGA number 1, your lordships.
Well, Ashika has filed an application. Ashika has filed an application. Well, actually, your lordship.
AP number 91, my lord.
Yes, and my lord, the prayer is only for vacating.
So it would be better, Mr. Shah, it would be better let they be allowed their application, both the application be allowed and you will be referred to the arbitrator and you make an application under section 17 before the arbitrator.
And I'm very sorry.
That will.
Very sorry, my phone.
That will be better then.
Well, I would
Because
normally.
now Asika, because this court has already held, the Asika is not coming forward for the because of the trustee's name and all these things, and already arrested with of the Hirnema Energy Limited for transferring that. Now the Asika wanted to come in with an application. Asika cannot be a party before the arbitrator. He is a third party.
Right.
Now Asika filed an application to intervening and recalling of the order. So you are taking the benefit of the order passed by Justice Bhattacharya, wherein the special officer has filed a report that due to this, and this court has also already held also. So let that both application be allowed, and you may be your case can be referred to the section 17. You take appropriate.
I'm just, my lord, asking myself this question, my lord. Then, well, what do I ask before the arbitrator?
That's why now you are taking the benefit of the order passed by this court.
That's right.
By the Justice Bhattacharya allowing a special officer for selling.
Right.
So selling is not happening because of the here and there, whatever it
Right.
may be. And this court has also held that there is a dispute with regard to the signatory of the trustees.
Yes.
So it cannot be done. So and restraint not to change the share in the Hirnama.
And that was the reason why your lordship passed another order.
If today the order is recalled, suppose the order passed by Justice Bhattacharya is recalled, taking into consideration of their contention and taking into consideration the special officer's report. So there will be no order. If there will be no order, then you can very well go to the
if
section
Justice
17.
Bhattacharya's order is recalled, then of course, my lord, it will be a different situation.
So that's
but
why.
my lord, that is not yet recalled.
No,
My lord,
if you are conceding to that, then
I cannot concede, my lord. I cannot concede, my lord. Ultimately, my lord.
Then it can let that application both all the things will be heard together.
Yes, that is what your lordship had directed. My lord, let it be heard together. I have no difficulty.
So that let it be heard together with regard to the impleading.
Yes,
with
my lord.
regard to
Certainly.
the recalling of the order and your application.
Yes, my lord.
Total 91 can be
Yes,
distributed.
that is what your lordship had
Okay, no
directed. Directed.
Now you come.
My lord, then
I will hear them last. You are.
no, my lord, I'll point out why, my lord. If they are added, my lord, then I have something to submit. If they are not added, then it's a different.
Has to be added. You take
Well,
it
then
granted.
let me
Take
proceed
it
on-
granted has
yes,
to be added
let it
because of
proceed
the
on that.
circumstances.
Yes, my lord. Let me proceed on that.
Kindly see, my lord, what is happening.
That's why take it granted it is added because what are the circumstances they had to be added.
Yes, let them be added, my lord. I don't have a problem, my lord. But
very great.
Then, my lord, may I now, my lord, let us understand why are we here. My lord, it's a section 9 application for interim protection. Now, my lord, your lordship, they came before this court when this order was passed by Justice Bhattacharya. Because, my lord, together with the application, the recalling is also a part of it. Now, I don't know what is going to be the fate of that. Vis-a-vis.
That leaving aside.
If it is not there, then I don't have much to submit.
No.
If that order is recalled,
Yes.
then I don't have too much to submit.
That's
Because-
that leaving aside now on merit.
On merit, my lord, if it is recalled, my lord, let me answer both the questions.
That's why this court has opened.
If it is
Court is
recalled,
open. If that order is recalled,
if it is
I don't
recalled,
think there will be any difficulty before the arbitrator.
my lord, if it is recalled, then what is being recalled? The recalling is with regard to the sale and the injunction. Now, my lord, my learned friends have come up before your lordship with another AP on this specific ground that sale cannot be conducted. Sale could not be conducted because of whatever collusion, whatever it is. Therefore, we need to be further secured. So the question today is not only whether a sale is required at this moment, because it's a jurisdictional fact which your lordship will kindly look into, that there has been a subsequent order of protection. My learned friends cannot ask for protection and protection on that again, but second protection. Hiranmoy was never, malad, the shares were never required to be injuncted, malad, but for the case which they are trying to make out that look, these shares cannot be sold. They have depleted. Where I will again show, malad, because it will take some time, because I will show that even their application, they have not been able to even say on oath that these shares are depleting in money. Malad, today my learned friends are proceeding as if they will get the award.
No, that's why. So what will happen if tomorrow the share will get down? Then
I'm grateful, Malad. Therefore, Malad, what will happen if the share gets depleted?
Yes.
Depleted. Then they will have to show that. At least that much they will have to show. I have made a positive statement. I have given documents. My learned friends have only submitted and made submissions without any affirmation as to knowledge and are saying that they are depleting. On the basis of such pleadings, Malad, they have already got themselves protected twice over. So today, Malad, if that is the case and if this order is recalled, they are not entitled to any further orders because they are already secure. First. Second, Malad, let us say, Malad, this order is not there. Oh, sorry, not recalled. Malad, let us have a look into the order which has been passed. And kindly see, Malad, Malad will kindly take IAGA number 1 of 2024 because I'll make certain submissions from that application itself. And last, I will have to jurisdiction appointed to take for it. Huh?
Yes.
Malad, your lordship has got the order, Malad. Grateful. Malad, 20th February,
Page?
6.
Page.
Page 18, I'm sorry, Malad. Page 18 of IAGA number 1.
Yes.
Petitioner seeks interim protection. Malad, that is not important. Now, background is a controversy not required to be gone into. So, Malad, that is also neither here nor there because there was no adjudication per se, Malad.
Come 19, last third, fourth.
Yes. takes note of the submission made on behalf of the respondent rupees 633 crores in inflated amount.
Before that, the only difficulty appears to be the depository participant, one Ashika Broking Limited.
Which is resisting the sale of the shares of IPCL and Power Trust. Right. Now, kindly sees. No, before that, kindly sees 19, there are two parts to it, kindly, it has not been taken away, that whether they are the rightful assignees also, that remains open also. That question has been kept open. If your lordship kindly sees para 2 at page 19, as to who will get this money.
Which was the assignable?
Then, para 3 is whatever be the alleged uncertainties of the assignment of the loans in favor of the petitioner, which is kept open, it's clear that the response owes a substantial amount of money to the petitioner. The only difficulty, I'm not reading the next line, the only difficulty appears to be the depository participant resisting the sale of shares of IPCL. Then, the figure obviously, is inflated, so we said that. Now, next page. Hence, this court, hence, this court is of the view that a special officer may be appointed to oversee the sale of shares upon appropriate directions of the depository participant. So, today, it's an order against the depository participant. And the receiver will only oversee the sale, which the depository participant will have to undertake. It's not an order on me, Then kindly sees, the order shall be in the form of an interim protection, subject to the fate of the arbitration petition. So how has it reached a finality? I'm asking myself this question. And today we are in the final hearing, Then, with such and such, and he is supposed to file a report. But in the report, it is found that they are objecting. Now, why I am looking into this application, your lordship will kindly see, your lordship knows that there have been dispute between Ashika and us, Ultimately, what it tantamounted was, that the order was passed, excuse me, page 114, kindly comes to page 114. This was the order, between Ashika and the company. Kindly sees page 115. Applicant, just in the italics, if your lordship kindly sees. The applicant Ashika does not object in changing the signatories to the demat account of the trust in case SEBI permits such change. So it was required that something from SEBI has to come.
So that's why Ashika is taking shelter of this, because of the signatory,
So,
trustee signatory, you are not complying with all the.
That is not the point, It said that it is subject in case SEBI permits.
Correct.
So they will have to show that SEBI has not permitted.
That's why they are relying upon the SEBI guidelines.
No, they will have to show from SEBI that it is not allowed. Because the order was such.
Order was such, but now they have taken.
I cannot be held responsible for that. Because I have proceeded against them in my manner, which they are saying that I am colluding. My straight on prayers is that. My straight prayers are that. Now, let us understand what is the prayer they can ask for today. They are saying substitution of the depository participant. Can that ever happen? That will has to undergo to another transfer to a third party. But the entire attempt is to just take over the shares. But the point today is, are they entitled to? They are only entitled to an interim protection. So they will have to make out that case. The injunction they've already got. In spite of the fact that they are saying that we have not hypothecated these shares to them. So that's why injunction has been passed. Now, sale. Sale was dependent on the depository participant. Today, your lordships have passed orders. Your lordships have considered their application. your lordship has upheld with humility, I say, my lord, time does not take me amiss. At least for the interim, that whatever actions they have undertaken is correct and I am at wrong. That is what is the plea and substance of your lordship's order. And therefore, your lordship has passed another order of injunction securing them. Well, that is section 9.
Correct.
So you are secured.
So your main contention is that there is nothing remains in the application when the interim order is passed, no arbitrator is appointed. So what further order is required?
Yes, because your requirement, well, what are they saying? They are saying there is an admission. Well, this is what we said, that I cannot sell because of the depository participant. I never said sell and you take the money. I did not say that. That's not there in the order. Now, if it's not being sold, my lord, it remains.
No, but in the suit which you have filed,
my lord,
affidavit.
but I am only humbly submitting, my lord. The suit is that I am asking for the depository participant, the name to be changed.
Correct.
And obviously, for that action, I am asking for a claim for damages. That does not include my learned friend's client in any manner.
122.
Page 122, paragraph
Yes, my lord.
3.
Yes, my lord.
Plaintiff has a loan from the financial institution and the same has to be repaid once IPCL shares held by with the plaintiff Powertus is disposed of.
Yes. I have not got that prayer, my lord. My lord, today, may I again, my lord, kindly allows me to make. My lord, your lordship will now have to decide if your lordship is looking into that prayer. That's a dispute between both of us. Then your lordship will have to decide that question.
How? Can't.
That is what I'm submitting, my lord, today. So unless that is decided, my lord, and the order was, my lord, absolutely, my lord, based on the whatever the actions will be of the depository participant, not me. That's why the order was against Ashika. Now today my learned friend is saying that if I go to section 17, then I'll get an order and try and enforce it here, so I don't have to come back. But first things first, can this dispute, my lord, my lord, with regard to sale, if there is a sale, my lord, I had on the last occasion, I had requested your lordship. If your lordship directs them, why are they not doing it? I'm not standing in the way. Anything wrong, your lordship can direct them. Order of court. But your lordship decides, no, I will not pass that order. I will again secure them.
Correct.
So now they're secure. You cannot say today, my lord, that at this final hearing stage, my lord, that no, your prayers are all gone. Yes, we can attend finally. Now, my lord, may I take your lordship to the applications? 2 minutes बाकी है.
Yes.
आज की सुन चलो. But kindly takes volume 1 AP com number 1 minute.
91.
91. Huh? At a thing. Your lordship will come. Lordship should say, oh, no, no. And my lord, another question has cropped up in my mind, which I don't know, but I will study on it and come back to your lordship on the next day. But again, does not take me amiss, my lord, but on the question of jurisdiction of your lordship to continue with a commercial matter, even if it is part heard.
That is one of the points.
I will point out why, my lord, because there is an order. I'll point out this is because, my lord, there is an order of this court. Your lordship knows that you cannot transfer a suit from one division to the other. If that is not allowed, my lord, then this would be a problem.
Special essay?
No, special essay hobe na, because it's not under the your lordship's roster with humility, my lord. Is not under the Commercial Courts Act.
When he is assigned, my lord, your lordship dons that mantle.
No, my lord, there is a division bench order of this court. I will just point it out, then your lordship takes it up. I don't have a problem with that. But only we are, well, before your lordship fighting this out, and then suddenly your lordship.
Then first that is to be decided. My list will be shortlisted.
Well, I'll try and assist. I'll also give him a copy. Well, this is absolutely, my lord, on a.
I find the list maximum on that.
No, because I will point it out.
My lord, this brings us back to the old adage, we live to learn.
My lord, I also learned today. I saw the division bench today. So that is why I'm not too sure about it. I will give a copy to my learned friend. This is not adversarial. This is a question of law. So I'll obviously give it to my learned friend. He can also look into it.
Give the copy.
I will give it to him.
The question of avoidance, not a question of law.
Counsel for the
Avoidance.
petitioner.
Our key.
I think I'll get a better order here.
APCOM 91 of 2024 concluded his argument. Counsel for the respondent has argued the matter at length, but due to paucity of time, it could be completed. When the case is kept on, let the matter appear. On Monday?
Yes. This Monday, my lord. My lord, this Monday, I think after 2 there will be some.
Then when? 12 or 13?
13th, my lord.
13th.
Very well. শুনছি নাকি সোমবার তোমার একখানা কি
13th November.
বলো না যেটা করছে ওরা
No,
no, no. Yeah.
Contempt
জয়বাংলা,
matter,
জয়বাংলা নাকি?
matter, contempt matter.
Lordship, I appeal for the list.
It's going to expire tomorrow, so.
Lordship, the matter has been fixed tomorrow for hearing.
কিসের বিজয় সম্মেলন? কি জিতেছে? কিসের বিজয়?
শুভেন্দু অধিকারী সবাই আসছে। সবাই আসছে। এই নিয়ে আজকে দেখ খবর